Before vacation, cyber permit. Stop sharing. Stop sharing. ಬಾಕ್ಸ್ ಕೊಟ್ಬಿಡಿಗಿರಿ ಇದಕ್ಕೆ ಆ್ಯಡ್ ಆಗಂತದ ಇದಿಷ್ಟು ಬಾಕ್ಸ್ ಹೋಗಿರ್ಲಿಲ್ವಾ ಏನು ಸ್ಪೋಕನ್ ಹಾಂ ಸ್ವಲ್ಪ ನಿಧಾನ ಕೇಳಿ 91 63 27 43 43 42 17 ಹಾಂ 903 ಅಲ್ಲ 58 57 89 ಆಯ್ತು ಹಾಂ 58 601 ಹಾಂ 86 92 ಹಾಂ 26 ಮುಗೀತಾ ಒಂದು ಸೆಟ್ 81 ಚೆಕ್ ಮಾಡಿದ್ದೀರಿ ಹಾಂ 9720 ಹಾಂ 41 82 76 40 ಆಯ್ತು ಆರ್ಡರ್ಸ್ ಆರ್ಡರ್ಸ್ 51 22 58 284 CP 271. CP 271. ಅದು ಟೂ ಸೆವೆನ್ CP 271. ಗಿರೀಶ್ ಅಯ್ಯಿಂದ
Your Lordship, permission.
No. What is the next date in that commercial code date? 15. Yes. Yes. Arrest warrant issued by where? Commercial. 15. I thought that arrest warrant want urgency. Yes, 15. 15. Yes, 25th. Tomorrow.
Petitioner for declaration. Final arguments if any tomorrow.
Yes.
Monday it is 5th it is posted.
Monday, yes.
Tomorrow it may be.
I think it will happen, Mr. Yes, Monday.
Partition separate request, reopen the recall application for further chief of police. Both application were dismissed. No, we posted for arguments and this month my lordship. Kindly out on 7th by Monday my.
Yes, 8th. Yes.
My lord,
What is that urgency? Yes, 16th. Yes.
my lord, in this case, my lord, the simple question, who are the legal heirs, my lord? And these respondents have been traveling from, roaming from courts to courts from 97, my lord. And this court had ordered the lower court to finish the trial by 6 months. And it is a stage of arguments, my lord. And this court had passed an order in 2022, my lord, to complete the trial in 6 months.
Now, what is that order you are challenging now?
To find out who are the legal heirs, declare who are the legal heirs of the.
No, is there any order passed by the trial court?
Not by trial court, my lord, by this court itself to complete the trial within 6 months, my lord.
ಆಯ್ತು ಈಗ ಏನನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ನೀವು?
ಅಲ್ಲ ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಬಂದು ಇಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ, the impleading applicants.
You are filed an application for vacating.
Yes, my lord. ನಾಳೆ ಸ್ವಾಮಿ, tomorrow, my lord.
Yes.
My lords, serial number 72. It's a parted matter by your lordship. Last week, since 2-3 hearings, it is not coming up.
No parted before this court.
My lords, your lordship had heard that is over the matter. Execution, this one are stranded. Kindly take it up at 2:30, my lords.
Not 2:30. Whenever it's reached.
At least by Tuesday, time may be fixed, my lordship. Kindly, because it is since 3.
Whenever that matter reached, I will hear and pass. I have heard so many matters some other reason it will be urgent. That is not that potted. If it is reached, I will hear.
My lord, it can be posted for, I have informed other side, Tuesday, my lord,
Tuesday.
72.
Two matters, my lord, for a fresh matter, my lord.
Much of-
Petition was tomorrow or Monday.
Yes, what is that matter? Challenging.
GMCPC matter.
No, what is that order you are
An order has
challenging?
been passed, my lord, rejecting my application to transpose me as a plaintiff number 3.
7th, Monday.
Monday.
My lords, I am the landlord seeking arrears of rent, release of arrears of rent. This court was pleased to give me 2 weeks time and the matter was listed on April 1st. But the matter was adjourned without informing me, my lords, on request of the other side counsel. So I request the 8th or 9th. I am faltering in my payments. What is that urgency in that matter? Release of arrears of rent that is deposited before the trial court. An express or without an express order release ಮಾಡಬಾರದು ಅಂತ this court had given an order. Yes. So I am seeking now release of that rental deposit in my favor. The deposit was made in February 10th, on February 10th, 8th or 9th. That will be there in that court, 21st. Yes. My lords, please, 8th or 9th, my lords. No, what is that? It was a date given matter. The matter was not listed. This, me after moving 3 memos. Still, what is that urgency? You are releasing that amount. It will be there. Even today or next month, it will be released. You see that urgent matter I have to take. No, date given matter, it was not listed, my lords. And without me, without intimating me. No, that is not the issue. Issue is that what is that urgency? Otherwise, I have it after vacation. Yes. I am faltering in my EMI payments, my lords. Yes. This is my only source of income. That's why I am requesting this court to give me an 8th of 9th. 21st. Yes. Tomorrow, yes. Tomorrow, yes.
My lord, amendment application has been allowed. They have changed the nature of the suit, my lord. Next date is on 5th. The matter was supposed to be listed on 3rd, my lord, today.
Yes, tomorrow, yes.
My lord, fresh matter, my lord.
RFA 25th, yes.
My lord,
26 rule line application has been rejected, my lord.
Even no, have you filed an application for vacate? Yes, not to 8. ಮಾಡಿದ್ರೆ subject to result, they have to be demonstrated. ಯಾರ್ property? Yes, Monday. Vacating, yes.
My lord, I
Suit
filed
for specific performance, my lord. Reopen and recall of PW1. The application was rejected. Matter is posted on 17 for arguments and merits. My lords may kindly have it.
Yes,
my lord,
fresh matter, my lord.
fresh matter, my lord.
settlement. Yes, tomorrow.
My lord, fresh matter.
My lord,
Trial court.
is fixed on 8.
No, all fresh matters only. I will give the dates, you give that urgency. That's all.
My lord, pending my trial court only.
No, the fresh matter, you don't want mentioning that, you don't want the date there tomorrow. If it is next week, you give that, we'll give a date. If you want 2 days, then only you have to mention.
My lord,
Fresh
with
matter,
your
my lord.
lordship kind permission, my lord.
Next week,
My lord.
My lords, fresh matter. My lord,
fresh matter again. Next week, ಅಲ್ಲಿ 7, 8, 9, 15, 16 ನೋಡ್ರಿ fresh matter ಆದ್ರೆ.
My lord, sir, in my case, my lord, I filed the application for the vacating the interim order, my lord.
It's already part of the trial court judge. And if he is concerned, my argument will not be heard by the same day.
No, you know that you will going to transfer.
Yes. It's available on the website, my lord. So, responding has been heard in the month of November 24. And my case is also, I am ready to, I am responding there, I am ready to make argument. This is not taking the floor. We have filed a requisition for early disposal, immediate matter.
Yes.
My lord, I filed the application, my lord, I filed the application vacating the interim order. Some urgency is there, my lord.
My lord, it is going to be executed. Since there is pending matter, my lord, it did not reach. There is an mentability, my lord, in respect of section 100.
Mention madapa.
15th, yes.
Tomorrow, my lord, or Monday. But deliver one house possession.
Yes, 9th, yes.
My lords, one matter for 230, my lords. My lords, wherein my lords, auction notice has been sent. Auction is on 5th, my lords. I am the purchaser of the flat, my lords. The my lords, 144 flats, my lords, commercial court has passed an order to auction. Sale warrant has been issued. I am one of the buyer, my lords. My lords, it may kindly taken at least to protect my interest. I have filed unnecessary applications to that one.
Tomorrow, yes, tomorrow.
My lords, 230, my lords, please.
Tomorrow.
My one route and application has been rejected, my lords. Matter is set up for final arguments on 7, my lords.
Yes, 8, yes.
ಎಲ್ಲ ಆ ಕಡೆ ಬರ್ತದೆ.
Press matter, 15th, yes.
My lords,
Nothing will happen.
one more writ petition vacating stay, my lords.
Vacating stay, 21st.
ಆಮೇಲೆ
ಸ್ವಾಮಿ ಪ್ರಶ್ನೆ
Vacating 21st. Monday, yes, Monday.
Lord, I filed the application for the ಹೇಳಪ್ಪ.
When order has been passed? When order has been passed by that? Yes, tomorrow.
Lord, one matter,
pertains to
commercial
my
suit, I am for the defendant. Plaintiff has produced a document that has been wrongly marked, your lordship. The matter has been posted for cross-examination on Saturday. Kindly have it tomorrow, your lordship.
Is the next date?
Saturday.
Yes, tomorrow. Yes.
One matter, RFM, Lord.
ಪ್ರೆಸ್ ಮ್ಯಾಟರ್
Vacating application ಹಾಕಿದ್ದೀರಾ? Yes, 8, yes.
ಪ್ರೆಸ್ ಮ್ಯಾಟರ್
Which one? Final disposal, I don't think so. Let us see.
Lord, one matter, Lord.
No, you just can mention and move that matter before the trial court. We'll try that.
Lord, 2012.
Yes. Eight.
Lord, one RFM, Lord, the 2012 matter, Lord, a partition suit, Lord. I'm for the plaintiff, Lord. It doesn't take, Lord, five minutes of more, Lord. I request for any date, Lord.
Matter will
Partition.
not reach. What is that? That is the difficulty.
2012 matter.
23rd, yes.
Oblige, Lord.
Lord, with your lordship,
RFA.
RFM, Lord.
RFA, then 25th. Yes.
Lord, with your lordship, we on 27th had mentioned this matter. Your lordship were pleased to grant today as the matter, as an application for vacating stay. 2004 suit, matter was pronounced, vacating stay, matter was supposed to.
Yes. So please. Not the date photo correct. You are appearing for respondent. The other suit dispose ಆಗಿದೆಯಾ ಅಲ್ಲಿ? Yes, ನಾಳೆ tomorrow.
ಲಾರ್ಡ್ಶಿಪ್
Eight, yes.
Lordship, the challenging one of the IAS in Hosadurga court. So can be taken up maybe 7th or 8th.
15th, yes.
15th.
My lord, press matter.
ಏನನ್ನು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
Period 2. 8 or 7th or 8th.
8th ಇಲ್ಲ 9th, yes. So what is that order you are challenging, madam? Yes, 9th.
My lord, my application is recall and reopen was rejected, my lord. It has been posted for arguments on Monday, my lord.
Yes.
Maybe kindly taken up tomorrow.
8, yes.
The first matter.
First matter, yes, 7, 21st, yes. Yes. Wait.
My lord, suit for declaration and possession, my lord. In view of the order passed by this honorable court, my lord, in RFA, my lord, time frame has been fixed, my lord. It was supposed to be disposed on 31/3, my lord. Now the evidence of the parties is closed, my lord. Now we filed an application under Order 26 Rule 9 for appointment of court commissioner, my lord. That has been rejected, my lord, day before yesterday. Now it is posted for the arguments of the plaintiffs, my lord, today. Hence there is the urgency, my lord.
No, the RFA are writ.
RFA disposal, my lord. In that RFA, my lord, time frame has been fixed. The matter was remanded to the trial court. And 31/3 was the deadline, my lord. Now, my lord, day before yesterday, my lord.
Seventh.
My lord, because my lord, today is posted for the arguments. Tomorrow they may take up the other side arguments and post for the judgment, my lord.
No, but Monday, judgment will not pass before that, yes. Let us see on Monday, yes.
At least tomorrow, my lord.
Monday, 7th, yes. Yes.
May I please, Your Honor?
Yes.
WP 10946 of 2025. My colleague is there to.
Page was correct.
Mention ಮಾಡ್ತಿದ್ದಾರೆ.
Yeah, she is mentioning.
Yes, madam.
Yes, what is that, madam?
WP 10946 of 2025, my lords. Delivery warrant has been issued against me, my lords. I am the objector in the execution petition. I am in the possession of the property.
When order
I
has been
request
passed?
to have the matter tomorrow, my lords.
No, when the order has been passed, madam?
Order was passed on 12th of this month, my lords.
Yes, tomorrow, yes.
Much obliged.
Page-wise adjournment, list number 1, page number 1, serial number 1 to 6, page number 2, serial number 7 to 17, page number 3, serial number 18 to 25, page number 4, serial number 26 to 34, page number 5, serial number 35 to 41, page number 6, serial number 42 to 45.
44, my lord.
Serial number 42, Your Honor. I'm for the respondent number 4, WP number 5812. The matter has been listed for non-compliance, Your Honor. Last date of hearing, we have filed our objections. Other ಮೇಲೆ non-compliance ಅಂತ ಇದೆ. 2 weeks time may be granted, Your Honor. I will comply with the same.
Earlier, the twice the matter was No, you are appearing for whom?
I'm for the respondent number 4 in this case, Your Honor.
Office objection, how you are concerned?
Illa, the office objections has been raised with regard to the objections we have filed.
Yes, mister. I represent for the petition. No, in India, what is that office objection on which?
Your Honor, actually.
Not at order.
Your Honor.
No, office objection on statement of objection filed by.
Statement, yes, Your Lordships.
Statement of objection to what?
Statement of objections to the main application, the petition which has been filed, Your Honors.
What is that statement of objection can be filed with GMCPC? It is on application where both the parties has been heard and order has been passed. It is not written under 226. Yes.
Yes, sir.
Before the trial court, it is listed on 16 for Malad. Set forth for evidence.
Yes.
Pleading application is dismissed, Malad.
Yes, mister.
Your Lordships, 1 week maybe time may be granted because the senior is out of station, Your Honors.
Date may be fixed, Malad.
What is that next date?
16 for Malad.
Yes, use this matter on 15th. Yes.
Please, Your Lordships.
The
Serial number 44, my lord. Serial number 44, my lord. In this, the counsel appearing for through VC from Delhi, my lord, he is not feeling well, my lord. Maybe attend.
You are appearing for?
Appearing for petitioner, my lord.
You want time?
Yes, ma'am.
Yes, sir. The request of counsel for petitioner. Leave this matter next week. Yes.
Page number 7, serial number 46 to 49, page number 8, serial number 50 to 53, page number 9, serial number 54 to 56, page number 10, serial number 57 to 59, page number 11, serial number 60, page number 12, serial number 61 to 62, page number 13, serial number 63 to 68, page number 14, serial number 69 to 72, page number 15, serial number 73 to 76.
Yes. Yes, at the request of counsel for petitioner, leaves this matter tomorrow. Please.
Page number 16, serial number 77 to 81.
Serial number 78, Lords. I appear for the petition in this case. Lords, they kindly have it next week. There's some inconvenience today, Lords.
Yes, at the request of counsel for the petitioner, leaves this matter next week.
page number 17, serial number 82 to 85, page number 18, serial number 86 to 90, page number 19, serial number 91 to 96, page number 20, serial number 97 to 102.
My lord.
Yes, at the request of counsel for the, at the request of party in person, use this matter on 18th June. 18th.
My lord, serial number 100, I am the petitioner, counsel for the petitioner, my lord. There's an interim order may be extended. That has certain fraud in petitions, I couldn't argue today.
I informed the other side. Yes, at the request of petitioner, use this matter after 2 weeks, interim order granted earlier is extended next week.
Page number 21, serial number 103 to 108, page number 22, serial number 109 to 111, page number 23, serial number 112 to 117.
116, my lord. For the petitioner. Personal inconvenience today, my lord, it may have it on 8th, my lord.
Yes, at the request of counsel for the petitioner, use this matter on 8th Agadilla.
7th August, Monday.
Yes, 9th. Yes. Yes.
Page number 24, serial number 118 to 123, page number 25, serial number 124 to 130, page number 26, serial number 131 to 138.
136. Yes, at the request of counsel for the petitioner, use this matter of 2 weeks.
Page number 27, serial number 139 to 142, page number 28, serial number 143 to 145, page number 29, serial number 146 to 148, page number 30, serial number 149 to 156, page number 31, serial number 157 to 165, page number 32, serial number 166 to 172, page number 33, serial number 173 to 178, page number
My lordship,
34,
my lordship, on serial number 174, my lordship, advocate for petitioner. My lordship, today I am not keeping well. Kindly be on 8th, my lordship.
Use this matter next week. Yes.
My lordship, kindly date may be fixed, my lordship.
Yes, yes, next week, madam. Yes.
page number 34,
My lordship, interim order may be extended.
Interim order granted earlier. Yes.
179 to 184, page number 35, serial number 185 to 189, page number 36, serial number 190 to 193, list number 1.
Serial number 78 was adjourned, but extended.
Yes, interim order extended.
For being spoken to, serial number 1, Rajesh A.
My lord, I appear for petitioner, my lord. My lord, in this case, my lord, on 1/4/2025, an order was passed, my lord. In that, my lord, an alternate option was given to me, my lord, to take out hand summons to the respondent in this matter, my lord. However, due to the council thing, the matter came to be disposed of. But now I'm ready to take the hand summons since there is an urgency in the matter, my lord.
Matter was disposed of on
1/4/2025.
Before order is signed, counsel for the petitioner has moved that matter for being spoken to. Today it is posted for being spoken to. The council wants to take notice and summons to that respondent. In view of the above, the order dated 1st April 2025 is recalled. Read this matter preliminary. Yes.
My lord, hand summons, my lord.
No, no, order has recalled. Now it has to be posted for preliminary hearing. Then we'll see.
Date, my lord, any date may be fixed.
Yes, read this matter for preliminary hearing on 23rd. Yes.
Obliged, my lord.
For preliminary hearing, serial number 2, K. Ravishankar.
Petition.
Yes, Mr. Raj.
Yes. Defendant's writ petition. Suit for mandatory injunction. Last may I kindly turn to the plaint averment itself. Ink page number 19.
Yes.
The cause of action, your lordships got it.
No, no, that, what is that order you are
Let
challenging?
order challenge is order 39 rule 7 where the inspection by a court commissioner is ordered. While allowing, there is an order for status quo without hearing me. Kindly have a look at the order passed on ink page number 12 on 27/2/2025 on the temporary injunction.
Yes.
Lordships got it, my lord. This is an order on IA number 1. The heard and perused on page number 12. The suit is for mandatory injunction, direct the defendant to remove the encroachment made on the eastern boundary of the plain schedule property for a permanent prohibitory injunction restraining defendant so and so on the eastern side of the plain schedule property. On a perusal of the photographs, go to show that the construction has been started. Now the plaintiff has filed the case on the eastern side of the property. The same cannot be granted without hearing the defendants. Hence, based upon the averment made in the affidavit plaintiff documents, the plaintiff has not made out a prima facie case and accordingly issues the emergent notice returnable on so and so. Next page, page 13. I appear sought for time for filing written statement. The case is posted on 19/3. 19/3 they files an application under section order 39 rule 7. That your lordships will get it IA number page 30. Order 39 rule 7.
Page 30.
30.
Yes.
Yes.
What is that prayer?
The prayer is accompanying a praise this honorable court may be pleased to pass an order to hold inspection of the suit's property by appointing the advocate commissioner in the above said case. Note the below mentioned a disputed surveyor grant the applicant such so and so.
Yes. What has happened on that application?
No, yes. For which I filed an objection, annexure G, page 33. Thereafter, the court passes an impugned order in page number 14. Allows the application and while allowing without hearing on the applicant temporary injunction application passes an order of status quo in page number 70. First of all, the court declines.
There seek for an appointment of court commissioner is appointed.
Yes.
What is to maintain status quo? Along with that, they have passed that.
Once the court holds that it without hearing on the application, my alternate alternative submission is that status quo order itself it is bad under law because on the first date of hearing the court declines to grant without hearing me on the application, that is IA number 1. As on 19/3/2025, the application I sought time to suit for mandatory injunction to remove the encroachment. Encroachment ಗೆ ನಾನು encroach ಆಗಿದ್ದೀನಿ ಅಂತ first ತೋರಿಸಬೇಕು, ಆಮೇಲೆ boundaries fix ಮಾಡಬೇಕು. The suit itself it is not maintainable. Kindly see to have a look at the plaint averment.
What is that your defense before the trial court?
Defense not filed a written statement at all. Written statement ಹಾಕ್ಲಿಲ್ಲ, IA ಗೆ objection ಹಾಕ್ಲಿಲ್ಲ. It has been posted not filing written statement and objection to the IA. In the meanwhile, they file an application.
Where is the plaint?
Plaint is annexure B. ಅವರೇ ಕಾರ್ಪೊರೇಷನ್ ಗೆ ನೀವು ಅಳತೆ ಮಾಡಿ ಅಂತ ಕೇಳ್ತಾರೆ. Before the corporation could take action, this suit came to be filed. It's a premature in nature. Page 19.
Direct the defendant to remove that encroachment made on the eastern boundary of the plain scheduled property within the time bound fixed by the honorable court for permanent prohibitory injunction restraining the defendant their mens or any persons claiming.
First, they have tested.
What is their case? You are putting up in a construction
that is their case on the eastern boundary and
they violation of the plan.
No. Our property, ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ adjacent ಇದೆ. ಅವರ ಈಸ್ಟರ್ನ್ ಬೌಂಡರಿ ನಾನು ಸ್ವಲ್ಪ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿ ಕಟ್ಟಿದ್ದೀನಿ ಅಂತ. No violation of plan sanctions. Kindly have a look at the averment at para 4 of page 19. The cause of action, your lordships got it?
Yes.
19 ನಲ್ಲಿ paragraph number 4. That the cause of action was the suit is first week of January. She visited the plain schedule property and utter surprise and she was shocked to see that the survey stone installed in the eastern boundary has been removed and encroaching the eastern boundary of the defendant has been put up in the construction. In this regard, plaintiff also requested the defendant number 2.
What is that you are under construction now?
I am under the construction unless it has been demarcated and they have given a complaint to the corporation authority. Corporation authority said we will conduct the joint inspection report. Before that could be done, if they filed a suit and obtained the order of status quo.
Issue notice, stay of order dated 21st March 2025, passed in OS number 253 of 2025 in the court of 4th Additional City Civil and JMFC, Mangalore, till next date of hearing.
Public.
Serial number 3, Y. Rajendra Prasad Shetty.
My lord, the plaintiff's writ petition. Plaintiff filed a suit for prompt injunction. And in the said suit, my lord, made an application for temporary injunction to restrain the defendants from interfering with the peaceful possession and enjoyment of the social property. Ashma, kindly see, my lord, page 52, my lord.
Yes.
This is the sale deed which has been executed by the first respondent and the fathers of the respondents 2 and 3. Page 52, my lord.
Yes.
In respect of the social property in favor of page 52. This is dated February 2002.
Yes.
Entire extent, my lord, 1 acre 3 guntas has been sold in favor of Margaret Ane. The said Margaret Ane in turn, my lord, has sold this property in favor of the petitioners before the lordship.
Yes.
And pursuant to the sale deed, my lord, all the revenue records and everything has been changed.
Yes.
And I have also put up constructions.
Yes.
There are some repairs in the scheduled property. I have produced the photographs.
Yes.
My lord, though the respondents don't have any right and title, they are making an attempt to interfere. The learned judge, my lord, has issued an emergent notice. My lord, by virtue of this order, my lord, they are making an attempt to trespass into the social property.
Where is that order sheet?
Annexure, page, page 19, my lord.
19.
19. Page 19. The plaintiffs have filed present suit for the relief of permanent injunction against the defendants in respect of social property. The plaintiffs have filed so and so and praised to pass in ex parte ad interim or temporary injunction, restraining the defendants, their henchmen, agents, family members from interfere.
Next date?
Pardon me?
What is the next date? 25/4. Yes. Next date?
25/4, my lord.
25/4. Yes. Our issue notice. Parties are directed to maintain status quo.
My lord, status quo ಅಂದ್ರೆ ನಾನು I have to put up constructions. ಅಲ್ಲಿ ಅದಕ್ಕೋಸ್ಕರ ಮೆಟೀರಿಯಲ್ಸ್ ಎಲ್ಲ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ.
Where is that your construction and the plan?
ಅಲ್ಲ, it is a farm house, my lord. It is a farmland. It is not, it is in the city. It is farm house.
Where is the photograph?
104 ಇಂದ ಹಾಕಿದ್ದೀನಿ ನೋಡಿ. And electricity connection, everything is there. Page 102 is the house. 101 in the start at the photographs. 102, 103. They're making an attempt to trespass into the social property. Police complaint to Kotidevi, they are not taking any action. 106, my lord, I have collected materials for putting up of compound and other some repairs.
Yes. Now, who are there? They are adjacent owner.
Allala, they have sold. Their father has sold that property. They don't have any right at all. The first respondent is one of the vendor.
Yes.
And the father of the respondents 2 and 3 are also vendor. Yes. Rashma, can you see page 52, my lord? They don't have any right at all. Marappa, now Rashma, kindly come to plain copy 114.
Yes.
But Marappa, my lord, is the father of third respondent, Manju. Then, my lord, Siddhalingappa, my lord, the second vendor. Here, first petitioner. Then, my lord.
Are directed not to interfere into that petition scheduled property till next date of hearing. For the respondent, only that persons who have sold to you.
Oh, they are the only, there are no other persons.
Yes, yes.
Serial number 4, Anish Josh Anthony for petitioner, HR Sridhara Murthy.
Yes.
Lord, the defendant is before my lordship, my lords. Orders on Rule 10 application is being rejected, my lords. Lords, the plaint is, my lords can see in page number 24, my lords. Government start from page number 25.
Now, suit for
eviction, my lords.
Who has filed an application?
But I had filed the application, it has been dismissed.
You want to implement that?
My lords, suit for return of plaint under orders on Rule 10 is been dismissed by the trial court.
Return of the plaint.
Return of plaint, my lords.
Yes, you have filed by whom? You have filed an application.
Yes, my lords. My lord, the two.
Why it is dismissed?
My lord, the two reasons which has been argued before the trial court is that one is that, my lord, it was not on recorded, my lord. One is that there is no averment or specific averment to the extent that the value of the suit scheduled property is above 3 lakhs.
No, your contention is that this is below 3 lakhs.
My lord, they have to state in, my lord. Nowhere it has been stated. But under Order 7 Rule 1I, the value of the suit scheduled property involved in this need to be stated. My lord, they cannot leave it to the court to assert based on the assumption or presumption.
Where is the plaint?
Page number 25, my lord. Page number, start from page number 25. There is no averment, my lords. The only in paragraph number 10, they says that the suit is one of the possession of suit scheduled property. Plaintiff has paid court fee of rupees 39,000, but that is not enough. That is for the purpose of
commercial shop.
My lords.
Yes. Commercial unit. Now, what is the rent, Mister?
My lords,
my lord,
the plaintiff, the defendant has suppressed the fact he has not filed the violation slip. Wherein violation slip is specifically taken that monthly rent is 49,300.
My lords,
violation is 5,91,600 rupees.
Violation slip is.
My lords, kindly see, my lord, section 12 of Commercial Court Act, 12C.
Yes.
Where the relief sought in a suit, appeal, or application relates to immovable property or the right therein, the market value of the immovable property as on date of filing the suit, appeal, or application as the case may be shall be taken on account for determining specified value. That is under, my lord, 2(1)(I). It is not the rent. Should be the value of the property need to be taken on account.
No, which provision you are reading? 12?
12C, my lords. 12(1)(C). Need to be read along with, my lord,
determination of the specified value.
Yes, my lord.
Whether the relief sought in the suit, appeal, application related to the immovable property or to the right therein, market value of the immovable property as the date of filing the suit. On application as the case may be should be taken into the account for the determination of the specified value.
And it need to be read along with, my lord, 2(1)(I), my lord. Specified value in relation to a commercial dispute shall be mean the value of such matter of the in respect of the suit.
2(1)(I),
my lords. Specified value. In relation to the commercial dispute shall mean the value of the subject.
Wait, mister.
My lords.
2(1)(I). Specified value.
In relation to a commercial dispute.
Yes, now read. Yes. In relation to the commercial dispute shall means
Shall
the
mean
value
subject-
of the subject matter in respect to the suit as determined in accordance with the rule 12. It shall not be less than 3
3
lakhs. Higher the value is notified to the central government.
Central government. Nowhere it has been stated that, my lord, the value of the property is above 3 lakhs. Nowhere it has been mentioned in the plaint.
Valuation slip, it has been there.
It is only rent is been mentioned. Rent is not cannot be taken into account under section 12(3), my lords. It should be the value of the property,
Where the
not the
relief
rent
sought
of the property.
appeal and application related to the immovable property or to the right therein, the market value of the immovable property as on the date of filing the suit, appeal or application as the case may be should be taken into that account for the determination of the. No, market value of that property will be more than that then.
My lord, it need to be, my lords, may I kindly see my Order 7 Rule 1(I). Order 7 Rule 1(I), my lords.
Yes.
Need to be read along with that, my lord. Particulars to be contained in plaint. The
Order?
plaint Order 7 Rule 1(I), my lords. The plaint shall contain the following particulars: the statement of the value of the subject matter of the suit for the purpose of the jurisdiction and of court fee, so far as the case admits. It shall contain. It's
That's
not
that-
contained.
No, see, that is what the court fee and suit valuation act, they have to file an evaluation slip. That is
I
a
don't-
part of the claim.
I don't.
Now that valuation slip they have produced.
It is for the determination of court fee, not for the pecuniary jurisdiction of the court. For the pecuniary jurisdiction of the court, they have to state that this property is more than 3 lakhs for entertaining the present suit as a commercial suit. It may be
Now-
below 3 lakhs, it may be above 3 lakhs.
Now, what
They
is that-
cannot.
Now, what is that reason given by the family trial?
My lord, it is not been considered, my lord.
But may I submit?
Wait,
It's a new fact that has been
raised by.
Let me see,
Please.
where is that, what is that order?
But it has been not considered by the, even though I had argued the same, it has been not considered by the trial court.
What is that considered? You just show me.
But it has been considered, what is considered is that when in paragraph page number 16, my lord.
Yes, you read that para 10.
It is further contention of the defendant, the plaintiff has sued for the eviction against before the expiry of lease period. It has not violated the terms and conditions of the lease, and hence the suit is not maintainable and liable to be rejected under 7 Rule 10. But this contention of the defendant is not acceptable. But whether the defendant has violated the terms of the agreement or not is a matter of fact which need to be obtained from the trial. But this is also argued. And because merit the for this another ground.
Can be formed expression by this court. Moreover, it is well settled principle of law that considering the question as to the jurisdiction, court has to
My lord,
verify their permanent made in the plaintiff. This court can't verify and consider at this stage defense raised by the defendant. Clearly stated that court in nature. No, they have considered under Article 7 Rule 11. Yes.
My lord,
yes, Mr. Where is that? In the plaintiff, you have mentioned that what is the value of the property?
Value of the property, the suit is disclosed in valuation slip only, but
should you not say that in respect of jurisdiction, it is coming within this court for value of so and so?
Yes, but
where is that plaint?
Plaint same page number 26 minutes. The suit is one for possession of scheduled property. Plaintiff has paid requisite property. That's all the
date of
plaintiff has
issuance of the
stated.
notice calling upon the defendant to hand over the possession of the scheduled property. Notification. Plaintiff submitted that he has to file a pre-suit mediation. So, which is that order? Pleadings.
And order 7, Rule 1I.
Order 7.
Rule 1I. The statement of the value of the subject matter of the suit for the purpose of jurisdiction and of the court fee, so far as the case, or for the jurisdiction also they have to state. It is for the court fee they have stated. And the court fee, it is a 12 month of the rent. That I am not on dispute.
Wait, Mr. Rule 1I.
Yes, my lord. Order 7, Rule 1I.
Order 7.
Order 7, Rule 1I.
6th read. Yes. Rule 1I. Yes. A statement of value of the subject matter of the suit for the purpose of jurisdiction in the court fee so far as related to the case admits. What is that it says? The plaint shall contain the following particulars.
Shall contain, my lord. There is no other. It shall contain.
No, is it the valuation slip is a part of the plaint?
My lord, valuation slip is for the purpose of determining court fee. Court fee for my lord present suit is 12 months of the rent. But as far as when they want to entertain the same for the commercial
defect in the suit, if it is not mentioned.
My lord, for the consideration of orders 1 Rule 10, the plain government alone need to be considered. That also being considered recorded by the trial court. My lord, by considering the trial the plain government, there
Yes,
is no.
What is that your defense?
Defense.
We have not stated
the
in that
application is at page number 28. The application is at page number 28, 7 Rule 10 application filed by the defendant.
No,
Where
he is not under this application. Your plaint doesn't disclose that what is that value of the suit.
The valuation
the
slip
defect can be dismissed. That is what that now you have to be argued and say that. If you show that any judgment showing that if it is not mentioned, it is not in a defect, it cannot be dismissed or return the plaint. Then otherwise what he is arguing is correct because it is not disclosed. On what basis court has considered that this is within the jurisdiction of the court?
This aspect is not raised before trial court. This is for the first time.
Yeah, jurisdiction point, Mr.
Yes.
It need not be. If that court has no pecuniary jurisdiction, cannot pass any order at all. Yes, you have to answer. When will you answer that?
Monday, Tuesday.
Yes, 8th. We'll have
My lord, on 11th, it is on.
Have any judgment on this point?
Yes, my lord, my own decisions are there.
Huh?
My lord, I had also argued a similar matter and my own decisions are there. And next date 11, I will proceed.
Yes, you produce that judgment that it is in a defect, it has to be written on that point.
Yes, my lord.
Yes. Or it can be curable defects. He can produce that. That
It is not a curable. It's not a curable defect, my lord. A plaint cannot be amended. The plaint government alone need to be considered.
Yes,
Even
let
if
us,
the,
let us see that on judgment Tuesday.
my lord, 11th it is posted for evidence. Let the trial court may not take up the matter, my lord.
No, when is
I am
that?
not seeking
11th,
more than
my lord.
11. It's on
Tuesday, Mr.
8th.
You are posted on 8th, 11th.
Yes,
is the-
grateful. Maybe on My lord, it may not be reached, my lord, then again, the plaintiff, per pound month, my lord, there are four postings have been given. The trial court may not take up the matter, my lord.
Eighth, yes.
Great.
Serial number serial number 5, MB Chandrachuda.
Yes.
Suit for declaration injunction has been filed. There is a denial of title by the defendant contending that they are the owners of the property. On 25/1/2021, issues have been framed before the trial court. On 6/9/2021, I filed an application under 26 Rule 9 of CPC for appointment of the commissioner. Objections have been filed.
No,
Suit for declaration injunction. Enforcement by the defendants.
Yes, where is your application?
So last my kindly, the application is dated 6/9/21, annexure D, page 33.
53.
33 33.
Yes.
ಇದಕ್ಕೆ objection ಆಗ್ತಾರೆ defendants. Next page is the objection.
Yes.
Contending that application is premature. The Honorable Court on 10/2/2022 said, before commencement of the evidence, application cannot be considered. You can insist the court after completion of the evidence. Now the evidence of the parties has been completed. I requested the Honorable to consider IA number 3 for consideration. Kindly go to page number 103, paragraph number 18.
103.
ಹೌದು.
Yes.
Paragraph 18, both the parties have led their evidence and produced the relevant document in support of their pleadings. When the case is about to be posted for arguments on the main suit, present application came to be filed by the present plaintiff.
Yes.
Application was filed about 4 years back. If at all the plaintiff was very much diligent in getting the commission appointed for local inspection of the suit schedule property, nothing prevented him to agitate his grievance at a reasonable point of time. But after closure of the evidence of DW1, he pressed IA number 3 at the belated stage, which is not justifiable on the part of the plaintiff. Kindly see the order passed by the trial court on IA 3 10/2/2022.
Yes.
Liberty has been reserved to me for
Yes.
pressing the application 10/2/22. You lost my kindly, sir.
Yes. Heard. Issue notice. Stay of further proceedings in OS number 8348 of 2019, pending on the file of 19th additional city civil and session judge Bangalore till next date of hearing.
Serial number 6, Suresh Babu, please.
It's a suit for partition, Lord. Plaintiffs are before your lordships challenging the orders passed on order 6 rule 17 seeking amendment, Lord. The amendment application came to be dismissed.
Yes.
On the ground that, Lord, the trial is already commenced. Lords may kindly turn to the application at page 30. What I'm seeking is, Lord, it is a suit for partition. The relationship has been wrongly typed. That is number one, Lord. And the shares have been given to the daughters, excluding the son who is deceased, his wife and son, Lord. That I wanted to introduce it in the pleadings. Lord, that application came to be dismissed by appraising the matter on merits. Lord, it's a very settled principle flaw.
No, that you have reduced that extent or increasing that?
No, Lord, there was a mistake, typographical error. That is 8 acre, 8 guntas. In that.
What is that materials to show that it is only measuring 2 acres, 8 guntas?
No, Lord, it is 8 acres, 8 guntas. ಅದೇನಾಗಿದೆ ಪೆನ್ನಲ್ಲಿ ಯಾರೋ ಒಂದು 2 acre out of 2 acre 2 guntas ಅಂತ that won't come.
You want to say that
it is 8 acre 8 guntas because altogether it is given to the daughters 2 acres they have given, excluding the son. Lord, the Honorable Apex Court is very clear. Lord,
No, I will come to the Apex Court later. Let me understand that. Yes. See now,
Lord, there are two aspects, Lord. Millards may kindly turn to page 30, the application.
Yes.
Now, the first, what I need to introduce is, Lord, in para 2 of the plaintiff, second line, delete the word second defendant and replace it by second plaintiff, because second plaintiff is his son. In the typing, it is
two of the plaintiff
line 2, delete that second defendant in the place to be mentioned.
Lords may kindly turn to page at
Plaintiff ಅಂತ.
page 20, 20 ಅಲ್ಲಿ plaint ಇದೆ. Plaintiff number 1 ತಾಯಿ, plaintiff number 2 ಮಗ. ಈಗ defendant number 2 ಅಂತ ಟೈಪ್ ಆಗ್ಬಿಟ್ಟಿದೆ ರಾಂಗ್ ಆಗಿ.
ಆಯ್ತು, ಇನ್ನೊಂದು ಯಾವ್ದು?
ಇನ್ನೊಂದು ಅದೇ ತರ ಇನ್ನೊಂದು ಇದು ಒಂದು ಪ್ಯಾರಾ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದೀವಿ. ಏನಂತ ಅಂದ್ರೆ third schedule property was purchased out of the joint family nucleus ಅಂತ. As such, the father had no right to execute the gift deeds in favor of the daughters. Blood, the third, what I am seeking, the third amendment is blood, 8 acre 8 guntas, delete 2 acre 8 guntas. ಅಂದ್ರೆ ಅಲ್ಲಿ ಬರೀಬೇಕಾದ್ರೆ 8 acre 8 guntas ಅಂತ ಕರೆಕ್ಟ್ ಆಗಿ ಬರೆದಿದ್ದಾರೆ. ಪೆನ್ ಅಲ್ಲಿ ಔಟ್ ಆಫ್ 2 acre 8 guntas ಅಂತ ಬರೆದಿದ್ದಾರೆ. ಆ ಪೆನ್ ಅಲ್ಲಿ ಏನ್ ಬರೆದಿದ್ದಾರೆ ಅದನ್ನ ಡಿಲೀಟ್ ಮಾಡಿ ಅಂತ ಕೇಳಿದೀನಿ ಅಷ್ಟೇ. That will not change the nature of the suit, blood.
Issue notice. Stay of further proceedings in OS number 33 of 2021 pending in the file of senior civil judge JMFC Gubbi till next date of hearing.
Serial number 7, Sukanya HT.
Yes.
Representative petition. The writ is for passing the orders in MA number 38 of 25 on IA number 2, which is produced as
Suit for
injunction.
Injunction.
So Lordship kindly see, there is an injunction order granted against my client. That injunction order was challenged in MA number 38 of 25. There is 1 day delay, and the
You
court.
have filed an appeal.
I filed an appeal.
Yes.
1 day delay, court has ordered emergent notice as annexure refer page 81. My problem is, in view of the injunction order granted, I cannot remove the centering materials. It is on hire.
No, that, what is the reason given for the trial court to reject it?
They said, your Lordship may kindly have annexure D at page 54. Page 54, annexure D, page 54. Your Lordship may go to exact page 60. Page 68, para 7.
No, then you
Page-
maintain status quo.
Am I-
Status quo till next date of
No,
hearing.
no, my colleague told me status quo is, I cannot remove the building material. They'll go to police, there is status quo order, don't touch the building material, it is on hire.
No, you want to remove that building
So,
material.
building materials.
No, you are not putting up for further construction.
That's second submission. First is welding materials I have to remove because it's higher basis. Secondly, you Lordship, after filing this injunction suit, OS number 2172 for 24, when the matter was posted for orders, he was however expected there will be no injunction, therefore filed another suit, declaration of title and admitting my possession. There is a house in existence, they admit my possession there.
We are not on
Right,
that.
right,
See, if you want to put up further construction,
right.
then whether you have obtained the plan and all, because order of
As
this court
we-
will not be permitted.
I
to
know,
put up-
I know that. I know that last case also you were stated that in case, my case also you stated. My problem is this, and there is a house in existence. Only the removing the RCC and putting we are removing asbestos sheet and putting RCC because of the rainy season. That's one thing I am
For
making.
that modification also you require permission.
I know that.
And by my order, you can't to go.
Right, your honor become license then.
To remove that centering
Centering
materials.
materials.
But after that, you have to maintain status quo, should not put up any further.
No, that centering material order not be tried, then I will argue the matter in the MA, so that I will see that that order is, I trying to convince the judge for setting aside that order.
Yes, we'll grant interim order because you can't pass final order without hearing.
Right,
other side.
right, I know that.
Yes, how issue notice. Learned counsel for the petitioner has submitted that. In view of that
Injunction order.
injunction order, the petitioner cannot remove that centering materials in view of the above. The parties are directed to maintain status quo. The petitioner is permitted to remove that centering materials, but should not put up any further construction. Yes, till next date of hearing. Let us see if there comes.
Right, okay.
We can dispose of that.
Right.
Yes.
Serial number 8, Mahesh Chandra BN.
Suit for partition, my lords, filed by the daughter in respect of the ancestral property.
Yes.
Lords,
the petitioner has filed an application seeking restraining respond number 4 not to alienate the suit schedule property. The trial court has dismissed the application. Further, an miscellaneous appeal was filed by the petitioner, my lords. The same also came to be dismissed.
Yes.
Admittedly, my lords, in the written statement by the purchaser, it has been admitted that it's an ancestral property.
Yes.
And the petitioner holds a share in that. And the purchaser has not pleaded in his written statement as to what was the legal necessity, my lords, for the father to sell the property as a karta.
What is that you are challenging now?
Lords, an order passed by the trial court as well as the first appellate court, not granting an injunction of not to alienate the property, further alienate by the purchaser, my lords. Respond number 4. I'm only seeking that let them not further alienate the property.
No, what has happened? That IA is rejected.
Yes, my lords.
What has happened to that MA?
MA also dismissed, my lords.
No, your suit for
partition, my lords.
Why it is not to alienate has been rejected?
Lords, rejected for the reason it requires a full-fledged trial, since the daughter, when the property was sold, was a minor, and 16 years has been elapsed from that time.
Issue notice. Which property? You have not mentioned the scheduled in the petition. How many properties are there?
Only single property, my lords. One property.
Where is the plaint?
Plaint, my lords, page number 13, my lords. Schedule at page number 16.
Parties are directed not to create third-party interest in respect of suit scheduled property till next date of hearing.
Great, my lords.
Cell number 9, Murthy DL.
Yes.
Suit for recovery of money, my lord. I am the defendant before the tribunal, my lord, trial court, my lord. I have fully cross-examined the PWA1, my lord. Thereafter, the case is posted for defendant's evidence, my lord. Thereafter, next date of hearing, I have filed the adjournment application, but the trial court dismissed the said application and closed my side evidence.
Where is that order?
Order page number 70, my lord. Last page, 70. The learned counsel for the defendant has filed adjournment application also. Page number 70, my lord. It appears from the records that wide order dated so and so. This court directed to the defendant to produce the evidence, both oral documentary in the next date of hearing, without seeking any further adjournment. The defendant is an advocate and she has present before the court today. In spite of the said direction, the defendant has not produced her evidence and the reason assigned seeking time is not satisfactory. Hence, the prayer is rejected. The adjournment application is dismissed.
ಆಯ್ತು ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ ಇಟ್ ಇಸ್ ಫೈನಲಿ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎರಡು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದು ಫಸ್ಟ್ ಟೈಮ್.
ನಿಮಗೆ ಎರಡು ಡೇಟ್ ಕೊಡ್ಬೇಕು ಅಂತ ನೀವು ವೈ ಕಾಂಟ್ ಯು when your party is there why can't you examine?
ನನ್ನ ಕಂಟೆನ್ಷನ್ ಏನಂದ್ರೆ ಸಿಗ್ನೇಚರ್ ಫೇಕ್ ಇದು ಚೆಕ್ ಮತ್ತೆ ಪ್ರನೋಟ್ ಮೇಲೆ ಸಿಗ್ನೇಚರ್ ಫೋರ್ಜರಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನಾನು ಇದು ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪೋರ್ಟಿಂಗ್ ನಾನು ಸಿಗ್ನೇಚರ್ ಕಳಿಸಿದ್ದೀನಿ ಡಾಕ್ಯುಮೆಂಟ್. ನನ್ನ ಸಿಗ್ನೇಚರ್ ಅಲ್ಲ ಅದು.
No, by through court or you yourself as
ಸಪರೇಟ್ ಪ್ರೈವೇಟ್ ಆಗಿ ಅದೊಂದು ರಿಪೋರ್ಟ್ ಬರ್ಲಿ ಅಂತ ನಾನು ಒಂದು ಡೇಟ್ ಕೇಳಿದೆ.
that is not that application you have filed there.
ಅದು ಹೇಳಿಲ್ಲ ಅದರ.
Then how that court can dream that all this is there? See, now unnecessary it is in a suit for
recovery of money, my lord.
Now what is the next date?
Argument, my lord. It is posted for argument.
When
9th.
What is the next date, Mr.?
Next date 13th or 14th of this month. 14th and 13th or
14th ಅಲ್ಲ ರಜೆ ರೀ. 13th 14th.
17/4.
17/4. Leave this matter on 16th. In the meantime, petitioner permitted to serve hand summons to that respondent. If there comes, we can.
The
fix-
council record.
In addition, also council. Directed to serve a copy and council appearing for, permitted to take hand summons and also permitted to serve a copy and the council appearing for the respondent before the trial court. Is this matter on 16. If there comes, we can dispose or fix the date. On that day, you complete your, yes.
Serial number 10, Manjunath H for petitioner.
For the petitioner by me.
For the caveat.
Yeah, the suit is for specific performance. I am the defendant's writ petition. I have filed the application for recall and reopen of the stage to examine the authorized
Suit for
officer of the.
specific performance.
Yes, my lord. And I have disputed the transaction as the loan transaction. And in this regard, we want to examine the authorized officer of the Airtel Limited just to prove the conversation taken place in between the
Whom you have to examine?
authorized officer of the Airtel, my lord.
Why?
Because my lord, here the conversation between the defendant number one.
Then
Allal, one
Airtel officers, so BSNL officers, total what is this?
Why, my case is that, my lord, my case, my lord, kindly,
Apply that and get it that.
my lord, may kindly peruse the impugned order, page number 19, my lord. Impugned order may kindly be perused, para 12,
Yes.
page number 19. On perusal of the
How can
materials.
they record that conversation?
No, my lord, my case is that, my lord, I have produced the exhibit D5 conversation CD, which has been ignored by the trial court, saying that no document has been placed.
May be recorded, but they cannot record.
Yes, my lord.
It
In
is
this
an
regard,
against that
yes,
privacy.
my lord. In this regard, the honorable trial court observed that there is no document placed on record regarding the conversation.
Document ಕೊಟ್ರು ಬರೋದಿಲ್ಲ madam.
My lord, may kindly, I will read
Unless
it.
criminal investigation, if the police request, law provided
my lord.
that they can be, otherwise they cannot be.
My lord, may kindly peruse the para 12 of the page 19. my lord.
Yes.
On perusal of the materials placed on record, admittedly, it is the suit for specific performance of contract. When the matter is set down for arguments on merits, the defendants have come with these applications. The defendants in their written statement, they have taken a specific contention that the alleged agreement is not executed for the purpose of out and out sale, but it has been executed for the purpose of security of the loan transaction. Now witness are to be summoned, the official of authorized officer of Vodafone corporate office. In the above, on the ground, there was a mobile conversation done by the plaintiff with defendant number one Uttam Kumar through mobile SIM number so and so towards the loan transaction. It is very relevant to note that the defendants have not produced the call record details, and moreover, the defendants have not produced any item of documents to show that the aforesaid SIM card belongs to the one Amarnath. Mere examining the witness as mentioned in the IA, it will not serve the purpose to substantiate the version of the defendants.
Yes.
Under the circumstances, IA is rejected. In this case, my lord, I have examined the Amarnath as DW2, where they denied that the SIM card is standing in the name of Amarnath. In this regard only, the suggestion was made to the Amarnath saying that this SIM is not standing in your name. In that regard, I want to examine that authorized officer to say that SIM card standing in the name of Amarnath. In this regard, my lord.
No, SIM card standing in this name of Amarnath, you can get the records. For that, you cannot seek for an officers to be come and submit.
My lord, as far as this finding of the honorable trial court regarding we have not placed any documents are concerned.
ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟರು ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ತಿದ್ದೀನಲ್ಲ ಆಯ್ತು ಅವ್ರು ಏನೋ ತಪ್ಪು ಬರ್ದಿದ್ದಾರೆ even then it cannot be missed. How can that they can record your conversation? It cannot be. That is what the law is.
That I will make the appropriate application tomorrow. It is for the arguments on the final last chance before the trial court. I may be permitted to make the proper application.
What
for,
proper application?
Amarnath, standing in the name of Amarnath. The SIM is the SIM card, the bearing number say mobile number 8.
Documents ತಗೊಂಡು documents produce ಮಾಡಿ ಸಿಮ್ ಅಲ್ಲಿ ಸಿಮ್ ಯಾರ್ದಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
my lord.
ಅವರಿಗೊಂದು requisition ಕೊಟ್ರೆ they will see.
2018-19, my lord, the SIM card was inoperative, and this is a prepaid SIM card, and that is the reason we are not getting the bill as of now. And in this regard, we may be permitted.
For that, it is available on law, you can do it, but this cannot be maintained. Yes, correct. In this writ petition, petitioner, defendant number 1 and 2.
2 and 3.
1 and 2 ಅಲ್ವಾ?
2 and 3. One ಸತ್ತೋಗಿದ್ದಾರೆ ಸರ್.
Defendant number 1 and 2 ಅಂತ ಹಾಕಿದ್ದೀರಾ?
Change ಆಗುತ್ತೆ. 2 and 3. In fact, 2 and 3.
Defendant number 2 and 3 called in question. Order dated 10/3/2025 passed by Additional Senior Civil Judge Magdi, whereby dismissed that application filed by the petitioner under order 18 Rule 1, Rule 17, read with section 151 of the CPC. Where is your application, Mr.?
Annexure E, my lord, 61, page number 61, and annexure G, page number 67, 61 onwards. Application one, annexure E, 61.
The heard examination of the witness in this above evidence dependent at the end of justice. Yes. Plaintiff has filed a suit for
Specific performance.
specific performance. On service of summons, defendant has appeared through township and filed written statement. On the basis of the pleadings of the parties, trial court has framed that issue. Parties are adduced their evidence. When the matter is posted for arguments,
Yes, my lord.
arguments, that petitioner has filed application for reopening of that evidence and also filed an application to issue summons to examine officer of the Vodafone corporate office, authorized officer of Vodafone corporate office, on the ground that his conversation between the plaintiff,
Plaintiff and defendant number 1,
his conversation between the plaintiff and
deceased defendant number 1.
defendant number 1 in respect of transaction has to be proved.
Yes.
The main allegations of the petitioner that the aforesaid SIM number is belongs to one Amarnath. Conversation of the parties to the one it cannot be permitted them to summon that witness of the officer of the authorized officer of the Vodafone corporate office. Petitioner wants to prove that conversation. He can prove any other method available under the law. That to fag end of that matter when it is posted for arguments, this application has been filed. Considering all these aspects, the trial court has justified in rejecting this application.
Great. Serial number 11, Noor Muhammad.
Petitioner suit for specific performance was decreed on 7/7/2023, my lord. After the disposal of the suit, at the time of filing the execution petition, noticed typographical error in the plaint, my lord. Hence, I filed the application for amendment, my lord. My lord may kindly see the application at page number 31, my lord.
No, suit is decreed.
Suit is decreed, my lord. Adರಲ್ಲಿ the petitioner wants to add constructed area ಅಷ್ಟೇ. My lord may kindly see the ink page number. Suit for specific performance, my lord. Ink page number 31, my lord, is the application for amendment to delete the 2 square which was mentioned earlier and to add the word ground, first, second and third floor of the constructed area. My lord.
2 square ಇದಕ್ಕೂ ground third floor entire scheduled properties is changed.
ಅಲ್ಲ ಅದರಲ್ಲಿ earlier, as per the earlier my vendor sale deed, I mentioned that 2 square. My registered sale agreement is very clear, my lord. At ink page number 9, my lord, annexure A, my lord. Schedule is at ink page number 15, my lord. Ink page number 15, third para, my lord. ಈ ಮಧ್ಯೆ ಇರುವ ಪೂರ್ವ ಪಶ್ಚಿಮ 20 ಅಡಿಗಳು ಮತ್ತು ಉತ್ತರ ದಕ್ಷಿಣ 11 ಅಡಿಗಳು ಒಟ್ಟು 220 ಚದರ ಅಡಿಗಳು ಈ ರೀತಿ ಅಳತೆ ಮತ್ತು ಚೆಕ್ಕುಬಂದಿ ಒಳಪಟ್ಟ ನಿಮೇಶನ್
What is the order passed by the trial court?
Trial court reject the application, my application on the ground that proposed amendment sought to the plaintiff is entirely new case, my lord. My lord, may kindly see, the constructed area has been mentioned in the registered sale agreement. That is an admitted document, my lord. And the judgment of the apex court is very clear, my lord. After disposal of the suit also, the amendment is permissible, my lord.
No, permissible. What that you can change entire this thing. See, if there is any clerical mistake or boundaries is mentioned, it is entire thing. You said 2 square. Now in place of 2 square, now you are adding ground first, second, third floor. Line number 6, para number 3.
My lord, may kindly see.
Instead of 2 square, it should be corrected as in a 4 square. That can be. You are changing entire boundaries itself. Now you will get in a suit for injunction or degree in respect of that High Court. You file an application to change it Vidhan Sabha. It is permissible as per that Supreme Court judgment. Amendment can be done even after that also, but it should not change that nature. When suit itself is pending, you can't do it. Can it be done it after that?
My lord, may kindly see. I am changing the amendment, adding the constructed area as per the registered document, my lord.
No, that is not the case before the trial court, because the evidence of the parties will be different when you have sought that.
Really constructed. I am not changing the number and boundaries, my lord. My lord, may kindly see. Constructed area subsequently at
that degree.
Decree at annexure C, my lord, page number 30, my lord. Page number 30, schedule, my lord. All that piece and parcel of the house property bearing municipal door number 23.
Now, where is that page number 30?
30 is the schedule, my lord.
No, that where is that judgment and degree?
In page number 25, my lord.
Judgment is 25.
Decree, my lord.
Judgment there.
Judgment is not produced.
Produce the judgment, let us.
Please, my lord.
What is the defense taken by the defendant, whether he is admitted?
Please, my lord.
Yes.
They are not disputing the.
Let us see that. Yes.
Please, my lord. Kindly 9th, my lord.
Yes, at the request. Read this matter next week. Yes.
9th date may fix, my lord.
Not 9th, it will come next week. It is already disposed of suit. What is there, judge? Yes. On 21st. Yes.
Please, my lord. Serial number 17 is also connected matter, my lord.
Same.
Same.
Yes.
Serial number 12, case hearing.
Yes.
Well, for petitioner Millards, the defendant's writ petition for amendment of the application rejection Millards. Millard, the impugned order, page number Millards 11, reasons at page number 14. Millards, what had happened is suit is one for ejection. I submitted in my written statement that the plaintiff is not the owner, specifically taken that contention. May I draw the attention of the court to the written statement at page number 28, Millards. Para number 5, Millards.
Para number
5, page number 28.
Yes.
May I read it, Millards?
Yes.
The averments made in paragraph number 3 of the plaint are denied. The plaintiff are not the owners of the suit schedule property. They have got no title to the property. The averment that defendant is one of the tenants of the schedule A property denied. Plaintiff has got no documents to show his ownership to the property. This is my contention, Millards.
Yes.
But what had happened is I could not lay my hands the certified copy of the documents insofar as earlier owner.
Yes.
That I wanted to introduce as per amendment at page number 34 annexure D, Millards, by way of application.
Now why it is rejected?
Millards, stating some technical ground, stating that Millards, I had no document at that time, etc. May I draw the attention of the court to page number 16, Millards?
Yes.
I'm sorry, page number 15, para 13, Millards.
Yes.
As stated above, on perusal of order sheet disclosed that earlier defendant filed an application on order 7 rule 11 CPC wherein also he disputed the title of the plaintiff over the suit premises and said the application came to rejected. As stated above, defendant seeking permission to introduce new amendment based on the copy of sale deed dated 12/10/1922. On going through the said document, it reveals that the defendant taken certified copy of the said document from the senior sub registrar Gandhi Nagar.
But your order 7 rule 11 application is
That is rejected, and on the same ground, my lords, that he is not the owner. That the court held that it's a matter of trial.
matter of trial, not that he is a owner.
No,
there is
no, no, no,
pending.
no, no. It is not been decided.
Yes.
So therefore, my lords, what the court has held, it is 1922 document.
Issue notice. Stay of further proceedings in SC number 15085 of 2020, pending on the file of additional, which court, Mr.?
My lords, that is small causes court, my lords. That is
Of small cause, Mehal, till next date of hearing.
grateful.
Cell number 13, Satisha DJ.
Yes.
But the petitioner is a JDR.
Hmm.
But the execution petition was filed by the respondent in pursuance of the decree of specific performance, which has been decreed on 8/1/2021.
Yes.
But the impugned order, kindly see page number 66. In the execution petition, my lord, the respondent files an application order 21 rule 95 seeking delivery of the property from the JDR. The court has ordered, my lord, the delivery warrant has been issued as against JDR. But if the facts, my lord, order 21 rule 95 is clear. 21 rule 95 application has been prior to the obtained by sale certificate, order 21 rule 94. And also order 21 rule 92 is specific, my lord, when the sale confirmation order become the absolute. There are two orders ingredients in 21 rule 95.
Again order ಮಾಡಿದ್ದಾರೆ ಈಗ. What is that
Delivery
order?
warrant has been issued
Where is that?
without complying the order. That's page number 66. Page number 66.
Read.
On the other hand, JDR had filed an objection. In the said objection has over, the purchasers are in possession of the scheduled property. They are not parties to the suit, hence prayed to reject the application. On Peru, the judgment and decree in OS number 302/19 clearly reveals that decree holder has obtained the decree of specific performance of contract. As per the judgment in decree holder has obtained the sale deed in respect of the scheduled property. Presently, JDR has failed to deliver the possession of the scheduled property till today. Moreover, the JDR has not given sufficient reason for rejection of the application. Further, the JDR has not produced any stay order from any appellate court. Hence, suit property could be delivered to the decree holder in the instant petition as per the judgment in so and so with the ends of justice. Decree holder hence the inclined to pass it forward. Application so and so issued delivery possession warrant against JDR through process. May I kindly see order 21 rule 95. The impugned order came to be passed on the said application.
No, that may be a wrong provision.
But the
But that degree has to be executed by director to deliver that warrant. What else there?
Right,
There
the
may be-
law is requirement, my lord, when the application order 21 rule to 95 seeking for delivery of the property,
No, that's,
my lord, kindly see for a moment.
where is that?
21 rule 95.
Hmm.
Where the immovable property sold in the occupancy of the judgment debtor are of same person on behalf of the same person claiming under title created by the judgment debtor subsequently to the attachment of such property, and a certificate in respect thereof has been granted under rule 94. The court shall, therefore, the rule 94
No,
is
no,
clear.
that is for action purchaser, mister. That will come to that later. If that property has been auction purchased for attachment,
But decree holder is a purchaser through court.
some other provision, mister, to deliver that
But
position.
there is no provision. This is a provision. 21 to 95, our hakirodu application.
Application, they have given wrong provision.
But very identical
No, that
matter, my lord, the
is-
honorable apex court is very clear. There are two ingredients has been fulfilled out of 21 to 95. First is attachment, another is,
See, if there is any degree for money,
please.
then if you are not satisfied the degree, then your property will be attached. For that, this is the provision. Here, there is a degree for handing over the possession. Then they have passed, there is some other provision, mister. They, just because they have quoted a wrong.
Right, another, my lord, was Article 134 of Limitation Act when the date of application has been filed within 1 year from the confirmation of sale by the court. That is absolutely not at all by the confirmation order. Article 134 is very clear.
What is that?
The order,
Confirmation of sale would not arise as Mr. Here degree is to deliver the possession, is it not?
decree is a delivery.
Then
No,
that degree has to be
decree is
executed.
the execute the registered sale date only.
Where is the degree?
Please, madam. Operative question, page number 21, my lord. 21. Suit filed by the plaintiff so and so specific performance of contract hereby declared. The plaintiff for entitled for the specific performance of contract, defendant is hereby directed to execute the sale deed within 1 month so and so.
Degree plaintiff here with 1 month from today, if the defendant fails to execute the sale deed, plaintiff has at liberty to get the sale deed executed through process of court. Sale deed execute ಮಾಡಿ
First execution is to satisfy the decree, and another second execution has been filed. In this second execution, order 21 to 95 application has been filed by the respondent.
that
That
there
is
is no
bar.
degree for handing over the
No,
possession.
no, no. It is a different concept to the execution.
Then they have to file in a separate suit for possession.
Plus,
Yes. Or when that order has been passed.
pled on 4 next date.
4/4.
15/2, madam. Order 28/2. 28/2/2025.
Delivery of the possession of the warrant is if the process is paid. Report on 4/4/2025. What has
Tomorrow.
happened?
Tomorrow.
Tomorrow. Yes, heard. Issue notice. Stay of order dated. Where is that order dated?
Further proceedings.
ಯಾಕೆ further proceedings?
ಅಲ್ಲ ಅವ್ರ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿರೋದು ಹಂಗಾಗಿ.
Further proceedings ಯಾಕೆ? Delivery warrant ಮತ್ತೆ. See, stay of order dated 28/2/2025 passed by senior civil judge Gudibanda in execution petition number 51 of 2023 till next date of hearing.
Cell number 14, K.R. Krishnamurthy.
Hand delivery may permit. Tomorrow is the case.
Yes.
Cell number 14, K.R. Krishnamurthy.
None appear. Leave this matter of 2 weeks.
Cell number 15, Amaresh A. Angadi.
For petition, my lord.
Yes.
Defendant petition, my lord. The respondent is the plaintiff. Has filed a suit for a permanent injunction along with the temporary injunction in the year 2019 were rejected when they have not established ownership and possession. Now you want to amend the prayer seeking possession and also ownership declarations. It's after lapse of 5 years.
No, see,
Belated stage.
suit is pending.
Suit is pending, my lord.
Then he has filed an application for declaration and possession.
Possession.
That can be. if
His
it is-
case is, I am in the possession, he filed the permanent. No, he
The
turned up.
possession is denied. If the possession is denied, he can permit it to amend for declaration and possession. For that only order 6 rule 17 to avoid multiplicity proceedings, this can be amended and he has been permitted.
No, it is a belated stage amendment. You could have filed after 5 years when the issue was framed. They posted for the evidence.
Supreme Court said, amendment allowed, it will be come into the force the day he has filed an application. Second thing is, if there is any delay or barred by law, it will be an issue in the suit, it will be decided.
That is not.
That cannot be a ground for rejection.
Supreme Court says, my lord, 2016, there's 6 principles are laid down.
No, 2022 judgment is there.
22 also there.
2022 recent judgment.
Yes, my lord, 22 also in this, the belated stage cannot be.
No, belated stage, he has to give an explanation. If the delay is satisfied, even Supreme Court said, it can be cured by imposing the cost. Unless any amendment, it is cost prejudice to you. that means defendant. That cannot be.
That is my related malafide intention, my lord. This is my lord.
Yes.
Lord,
That
Supreme
is the intention of the legislation. Instead of now, he has to file a separate suit for declaration and possession. Instead of that, it can be amended.
My lord,
That is what-
my lord, he's claiming my property. He claiming my property.
ಆಯ್ತು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಲ್ಲ ಏನ್ ನೀವು ನಾಳೆ ಸೂಟ್ ಹಾಕ್ಬಿಟ್ಟು ಕಬ್ಬನ್ ಪಾರ್ಕ್ ನಮ್ದು ಅನ್ಬೋದು ಬಟ್ ಯು ಹ್ಯಾವ್ ಟು ಬಿ ಪ್ರೂವ್ಡ್.
It has to.
That is not.
Look, prima facie,
Filing
my
in a
lord.
suit, it will not become a owner.
Your lord, kindly say, he has filed application. Your lord, para 21, my lord. There are 6 principles laid down.
Yes. Yes.
Para 21. On amendment, generally, in the decision reported in a Rajwa Builders and Developers Management Suit, referring the Gautam Supra, the principal amendment have been summarized. Para 63, it has been held as follows. On critically analyzing both English and Indian cases, some basic principle emerges which ought to be taken into consideration by allowing or rejecting the application for amendment. Whether amendment short is imperative or proper in effective adjudication of the case, whether application for amendment is bona fide or mala fide, the amendment should
Again,
not.
see, refusal of the amendment would in fact lead to that injustice and lead to that multiple litigation. Now he has to file other suit if it is rejected now.
Mala, this application itself, suit itself is maintainable because he is claiming my property. You are also kind of.
No. See, it is your property or not after serving that this thing your object. Suppose tomorrow you will file in a suit for declaration against your property. Is it bar? He can file it.
Let him file it, Mala. I am not.
Same
In
thing
this
now.
case, Mala, more of 22 also, Mala. The billiard stage cannot be done it.
Yes. Yes. You take notice.
Yes, please.
Yes, issue emergency notice.
24, the case is posted, interim.
Can someone will see.
Say the further procedure, Mala, they may amend.
I am not satisfied that at all.
I will tell you.
Unless it is, see, even then there is a barred by limitation, you can file in a written statement, objection, that will be that issue. Unless by amendment is withdrawing any admission or it cause any injustice to that other party. Supreme Court said even delay, it can be compensated by, imposing the cost. Yes, let us see.
Just 1 minute, Mala.
Yes.
My application for intemporary injury rejected, I produce the order copy. Kindly see your order. They are claiming
Application for?
application for the injunction, temporary injunction rejected by the court below. Then they come with after 5 years. That order also.
See, if defendant has filed an objection denying the title, then possession, Supreme Court said, unless it has to be amended, he cannot be. That is what that once it is denied, he has to be.
Just I produce the order copy. Please.
Let us, you take notice, let us see that.
At least time being, madam. Otherwise, they will amend the cost rate.
Can't liberty. If you succeed, everything will go. You take your hand summons.
Yes. Next date of 22 ಇದೆ case.
ಆಯ್ತು ಮಾಡ್ಲಿ ಅವ್ರ ಅಮೆಂಡ್ಮೆಂಟ್ ಒಂದೇ ಆಗುತ್ತೆ ತಾನೆ ಇನ್ನು by the time if you succeed then you will lose everything. His suit itself will go. Yes.
Cell number 16, Mohan Kumar N.
Yes.
Serial number 16, Mohan Kumar.
None appear. Release this matter after 2 weeks.
Serial number 17, Arjan. Serial number 18, Sharat S. Gogi for petitioner. VB.
I appear for petitioner, my lord.
Yes.
My lord, I have filed a suit for declaration and for possession in OS number 335 of 2025.
Yes.
On 16 on annexure, may kindly could annexure G, my lord, page number 217, last document.
Yes.
My lord, along with the suit, I had filed 2 applications. One is not to alienate the suit scheduled properties and not to change the nature of the properties. 217, my lord. 217.
Yes.
My lord, the interim order was at page number 218. This interim order was granted on 16/1/2025. The court, having satisfied with the prima facie case, order is passed. Defendant, their men or their other person claiming on behalf of them are restrained from alienating or changing the nature of a suit A scheduled property till next date of hearing. The plaintiff shall comply the order, issue TI order, suit summons notice to so and so. May kindly see, at this stage, learned counsel appearing for the plaintiff submitted that since there are more than 70 defendants, the plaintiff may be given 2 days time to compliance. Submission is accepted, the plaintiff shall comply on or before 18/1/2025. Advancement application filed, heard and allowed. Learned counsel appearing for the plaintiff submitted that in order dated 16/1/25, though the court has considered IA 1 and 2, there is an omission to refer IA 2. Therefore, order dated 16/1 is corrected accordingly. Then, my lord, it was posted on 1/2/2025. 1/2/25, some of the defendants appear. The advocate filed wakalat to defendant 11, 25, 20, so and so. Learned counsel appearing for defendant number 61 has filed IA 3 under order 39 rule 4 to vacate the interim order, ex parte order. Heard the learned counsel appearing for the defendants who have appeared today, and learned counsel appearing for the plaintiff 6 times 2 for a further submission. The court has granted an order of ex parte order injunction in respect of suit scheduled property, which is described as agriculture dry land in survey number so and so, 1 acre 30 guntas. Material produced before the court shows that the huge constructions have come up. Now what happens is the court proceeds to vacate the interim order without giving me an opportunity to file objections to this vacating application, nor heard me on IA number 1, and proceeds to vacate the interim order only on the basis of submissions of the defendants.
No, now that remedy is to file an appeal. How is that writ?
No, my lord, the orders are not passed on merits.
No, this is IA application for vacating has been considered and passed an order is merit.
No, no, IA number 39 rule 4 vacating is also not passed on merits.
No, see, whether order is speaking order or not, it will be considered whether it is a merit or now that order is passed under 39 1 and 2, then it is available. Not
no, my lord, the court does not.
Even rejection of the ex parte order is also available. That's what that recent this court held.
My lord, may kindly see, the court is not specifies that it is considering order 39 rule 4. Only application is filed. Only application is filed. The court is exercising this power to vacate under order 39(4) is not specified.
Change the nature of the school scheduled property. IT granted is vacated. However, liberty to that given to the plaintiff argue on that merit IA 1 and 2.
Yes, those applications are kept pending.
Further, liberty is given to the plaintiff to bring to that notice of the court if first constructions are started in the suit scheduled property. Limited case members of the IA is not considered.
Yes, my lord, not disposed.
Liberty to give a plaintiff to argue. What is that earlier injunction order? Temporary
injunction order is not to alienate and not to create third party interest, not to change the nature of property.
Now that why it is directed defendant not to change the nature of suit scheduled property, therefore ex parte granted.
May I make a
The objections were served on same day.
I would bring to the notice what my learned friend is saying, but he misled the court. He made a false statement before the court to obtain an order of injunction.
What is that?
The misleading statement that was made was, kindly turn to the plaint. The plaint is produced by the petitioner, which is at page 57.
Yes.
And in page 57, although he makes all the parties, properties are shown as agriculture landed properties. Now turn to the schedule there. What is mentioned as schedule A and B, survey number 15/2 of Bavasanapura village, page 105. Yes. The plaint commences at page 57, 105. This is shown as agriculture land. He tells the court by filing an application that this is an agriculture land and seeks an order of ex parte injunction. The learned judge believed him, granted an ex parte order of injunction, which would be a normal course. The position insofar as these two properties are, there are huge constructions that have come up. What this plaintiff did was, he went to each house, started writing the case number on the walls of the property. But I filed an application when he started disturbing possession of several persons.
But I'll
Now
just,
that there is no.
but I'll just point out
Yes.
why a false statement is made even before the court. Look at the photographs.
It's a
This
false
was the
submission, my lord.
application. Just 1 minute, sir. These were the photographs which I produced.
Yes.
On the walls of the properties, kindly turn to each photographs. He started writing the case number. Land for which injunction is sought is an agriculture land. He does not disclose that these are the constructions that are put up.
Yes.
Now what he does is he uses the case number, uses the police, uses rowdy elements, goes to each house and start putting up the case number on that. The order that is granted is not to alienate. He uses that order and misuses the injunction order.
Yes.
And every family was disturbed. When women and children were in the house, he started disturbing. This is what the plaintiff attempted to do insofar as the case is concerned. Now, the learned judge was brought attention to what orders that came to be passed.
Yes.
Permit me to read what the order says, page 220.
Yes.
Learned counsel for the page 220.
Yes. Yes.
Learned counsel appearing for the plaintiff submitted that still there are vacant areas, but at present there is no material to substantiate it. It is further submitted that on the basis of the interim order, plaintiffs have even displayed the case numbers in the building situated in the property. Interim order is passed to effect that defendant shall not alienate and shall not change the nature of the suit A properties. This order was granted considering the description of the property given in A of the plaint. When the constructions have already come up in the suit, A schedule property, if this order is allowed to operate, it will lead to multiplicity of proceedings, confusion with regard to status of the A property as on the date of filing of the suit. Further, when constructions have already come up, there is no urgency to direct defendants not to change nature of the suit. A schedule property. Therefore, ex parte TI on 16/125 is vacated. However, liberty is given to the plaintiff to argue on merits on IAs 1 and 2 after appearance of all defendants. Further, liberty is given to the plaintiff to bring to the notice of the court if any fresh constructions are started in the suit property. It is submitted that the case numbers are displayed in the building. When temporary injunction was granted in respect of agriculture property, plaintiff should not have hurried to display the numbers in spite of protest of the defendants. Therefore, plaintiffs are directed to remove within 24 hours. If the plaintiffs fail to remove, the defendants are permitted to remove. But is this erroneous? The learned judge was brought attention of this misleading statement that was made. Any judge would have.
My lord, he made these submissions, but the trial court did not hear me on these, countering these submissions. Countering these submissions was nothing heard. May kindly see, my lord, agriculture scheduled property is mentioned because it is unconverted land. May kindly turn to para number 16 of my plaint, page number 78. I have described each one of the sites, the allegedly formed.
See, you have alleged that it is a vacant agriculture land.
Yes.
No, my lord, I have only stated that it is agricultural dry land. May kindly turn to para 16, page number 78, my lord.
Now the fact is that it is an even though if it is an agriculture land, if it is not converted, he is constructing. If it is illegal and or not, it will be.
No, my lord, my only submission is the property has to be protected. Which should not further cause damages to the defendants who have purchased either by misleading or then having a knowledge of it. Yes. Now, may kindly see if the court says that the trial court proceeds without giving.
No, Mr. Is it in the pleading? Have you stated that in the agriculture land he is putting up in a construction? Has he stated in that?
No. Yes, kindly turn to para 16. Para 16.
Yes, this is agriculture land. Without permission, he is putting up in a construction.
My lord, I have mentioned that they have found the illegal layout. May kindly para 16.
Yes.
Para 16.
You said only agriculture land.
No, may kindly turn to page number 77.
Now that who has permitted you to put in a number on that building? Is it interim order?
My lord, it is all created story. May kindly permitted to take your lordship to page number 77.
Now
page number 77.
Any construction if is made, it is subject to the result of that case.
My
It is
lord.
always there.
Milord, yes, Milord. Milord, at least let there be an order not to alienate the property. May kindly turn to page number 77.
Yes, yes.
Page number 77.
The properties are not his properties.
Milord, it is matter that the court should have allowed me to hear, address my argument. Then I would have satisfied.
Third party interest till then deciding.
But even then, list pendants
Yes.
applies, my lord. Who am I?
Even then
And I have
also-
put up
Milord,
constructions. When you put
Milord,
the
there
first
has
one-
to be some protection to avoid a multiplicity of proceedings. Lease pendants may apply, but the purpose of order 39, 1 and 2
not
defeated.
to alienate the third party.
Please,
The
Milord.
application is to be disposed of.
May I make a submission?
Please, Milord. Please,
All
Milord.
these defendants have invested and they are all private properties.
They
How
are
can
not
this
bona
court
fide
also-
purchasers.
1 minute, sir.
Yes.
How can this court say that don't alienate property? Which property I should not alienate?
The suit scheduled property.
Where
Yes.
is the suit scheduled property? Agriculture land.
No, Milord, kindly, that is what is misleading.
If it is your property, it is
Let
not a
him-
suit scheduled property.
let
You
him-
construct a palace.
I
Yes.
Court order will not
Yes.
come in your.
Okay,
Yes.
Let him
But only
say,
thing is that.
let
in
him say,
suit scheduled property.
let him say the property numbers.
Milord, I have specified.
We say that suit scheduled property, parties should not create any third party interest in
Yes.
the application. If it is not in the suit scheduled property, it will not applicable to.
Let him
Please,
not
Milord.
miss this
Please.
order of the court.
Yes.
Take rowdies and police and constables, pay them some.
This is
marmot,
all only
go
to
and write case
prejudice
numbers.
the mind of the honorable court. It is only to prejudice the mind of the court.
Suit scheduled property, you will not create any third party interest. I will not pass any order. I will record it and leave it.
My lords may have
Please,
it on
madam.
Tuesday. I will place the record.
Yes, that's all. If you say that, then even interim order will not be granted. You will not chance of misusing also.
Please.
He has already done that mischief.
No, Milord, he is misleading. I have specified each site number which they alleged to
Eye
claim.
opens to the court. If he had not opened the eye of the court, that this mischief would have been continued.
Milord, if the court had allowed me to address my arguments, I would have definitely convinced the
For
court.
all frivolous purposes.
You cannot be restrained to put up a construction because it is your property. If you are invested, you can construct, but don't create third party because tomorrow, if he succeed, persons who has purchased again will be put in trouble. That is
Please.
what that interest of the court. Yes.
That's all right. What I say
Please.
is, which property not to be alienated?
Now, when the suit
Any
scheduled
property, any
There is no
portion in the suit schedule property.
There's no suit schedule property.
There is
They
a
are
schedule as
agriculture
the-
land.
There is suit schedule, but that
They
is
are
how he is
agriculture land.
misleading me, Lord.
If that is not your property, why do you worry? Tuesday.
The case numbers which cause
May I please?
inconvenience.
Today this matter on Tuesday.
Bill number 19, Ananda Ramake.
Please, my lord, interim order.
Yes.
Please,
The
my lord,
petitioners,
interim
my
order.
lord, are the respondents in the FDP before the trial court.
Yes.
My lord, the FDP is filed, my lord, to pursuant to a preliminary decree, my lord, and annexure B. By, my lord, the respondent number 1 hearing. There, my lord, in that preliminary decree for partition, my lord, all the sharers were not made parties, my lord.
Yes.
So, my lord, the other sharers, they filed one more suit. That is, my lord, annexure C. About, my lord, in OS number 195 of 2014.
Yes.
There are, my lord, 19 other sharers filed the suit, my lord, the comprehensive suit.
Yes.
Now, my lord, issues are framed in the subsequent suit, which is at page number 68.
Yes.
Whether, my lord, the preliminary decree in the earlier suit is null and void.
Yes.
Now, my lord, when the subsequent suit is pending, my lord, they file this FDP. And, my lord, pursue the FDP to take, my lord, actual division of the properties. I filed an application, my lord, stating that the subsequent suit has been filed by sharers who are not made parties in the earlier suit.
They
And
could have
issues-
implemented in the FDP. Why the fresh suit?
No, my lord, fresh suit was filed, then the FDP was filed.
Yes.
So therefore, my lord, I said, let the FDP be stayed until, my lord, the subsequent suit gets decided. Ultimately, my lord, if the subsequent suit gets allowed, my lord, the entire exercise of FDP will
No, is
become
that
futile.
same family?
Same family, my
Where
lord.
is that genealogy?
My lord, genealogy is,
Suit filed earlier.
yes, the suit filed earlier, my lord, your lordship may kindly see the judgment. Annexure B at page
Whether
18.
Suit filed earlier is the same family members.
Same family members, my lord.
Or
Same
the
family.
same branch.
Yes, my lord,
Where is
yes.
that you have.
My lord, your lordship may kindly see annexure B, page 18 only. They make, my lord, only 4 persons as respondents. The respondent number 1 herein. My lord, the genealogy I have not produced. I'll produce it if required.
Yes,
My lord,
B.
page 18, annexure B. My lord, kindly turn to
What is the relationship?
My lord, in juxtaposition, your lordship may kindly see annexure C, page 30. My lord, they are all, my lord, they belong to this Alia Santana family, my lord. So, my lord, there are several persons.
No,
It is not in dispute that, my lord, they are belonging to the same branch.
No, plaintiff and
Yes.
the defendant.
Yes.
What is their relationship? How they are related?
Plaintiffs and defendants in annexure B, my lords.
Annexure B.
My lord, annexure B, my lord, they are the legal heirs of one Krishnini Shetty.
Who?
That is the grandmother of the plaintiff.
Grandmother of plaintiff.
Grandmother of the plaintiff. And then, my lord,
she is how that related to defendant?
They are also, my lord, the grandchildren of the children of Krishnini Shetty's children. And my grandchildren, all are grandchildren.
All are grandchildren.
They are all grandchildren.
That means to say that the plaintiff and defendant are brother and sister.
How? Cousin brothers and sisters.
Now you come to that YS page annexure C.
Annexure C, my lords.
How they are related to that earlier suits?
My lord, they all belong to the very same extended family, my lords. Because some of the children's children are not made parties. The my lord, exhaustive the genealogy is not been produced, but my lord, this relationship is not disputed.
Because see, if there are family members, in the first group there should be a partition.
Yes.
Among them, their branch will be entitled. If there is an earlier suit is partition for that first group,
yes,
then among that branch, there are other proper persons are there. They have filed in a second suit. That is any different because they have no right unless there is a partition among their grandparents.
Yes.
Lord, therefore, I want to know if this is a different branch or a same branch.
It is the same branch, my lord.
Yes.
It is the same branch. And my lord, this very aspect, my lord, has rightly pointed out by lordships, has to be decided, my lord, by way of an issue. That is issue number 1. So, my lord, until
now that what is that order passed by
the order, my lord, my application is rejected. I had sought for stay of further proceedings in OS number 195. Now that is dismissed. Observing that, my lord, it is not a subsequent suit. Because FDP is not a subsequent suit, it is a continuation of the earlier proceedings. Page 92, my lord.
Page 90?
Page 92 of the writ petition, that is the reasoning, my lord.
92.
92. Lord, the trial court strictly goes on the technicalities of section 10 and then holds that FDP is a continuation of the earlier suit.
So you have filed an application in the FDP?
FDP application act to stay the FDP until OS 195 is disposed of. Now that application is rejected, saying that FDP cannot be considered as a subsequent suit. It is a continuation of the earlier suit.
That rule is not, which rule is applicable for your case?
Section 10, my lord, and 151 we had filed. Because section 10 says, my lord, stay of subsequent suit. My lord, and therefore, my lord, we also included section 151.
There is no any provision under order 20.
Order 20.
Because execution proceedings, there is a
provision. Is not yet filed, my lord.
No, execution, there is a provision for stay.
Yes.
Like that FDP, is there any provision?
My lord, to my knowledge, my lord, order 21, my lord, rule 20, my lord, would be FDP, rule 24. Yes. We invoke section 151 as well, my lord.
Rule 20.
That is order 21, rule 29, my lords, if your lordships are referring to stay of execution.
Yes. What about that FDP? That's what I
Lord, FDP, my lord, would fall under order 21, rule 20, not 20. FDP.
Which is that provision?
For FDP, my lord.
Yes.
Lord, so far as FDP is concerned,
Application for execution. You verify tomorrow?
very well.
Yes. Leave this matter tomorrow.
Bill number 20, Joseph Anil Kumar A for petitioner, Harsha V.
My lord, for the respondent, my lord, I have filed wakalat. Let us serve the copy on, to me, my lord. It may be taken up on 15th or 16th. I'll be ready. It may
There
be
is an
disposed of on
urgency in
that.
the matter. There is urgency. I have produced it. Kindly see the photograph also, page 99. My lord, they have interfered in my possession through GCB, by bringing JCB.
Now, what
And
is that you are challenging?
My lord, suit for permanent injunction, my lord. My lord, I filed a suit for permanent injunction stating that I am the absolute owner of the property in question. By registered sale date way back in the year 1988, I purchased the property. My lord, in 2013, my lord, there was sale negotiation between the plaintiff and the respondent, that is petitioner and the respondent. Respondent offered to purchase this property for a sum of rupees 8 crore, my lord. He paid 10 lakhs rupees and an unregistered agreement of sale was executed. But he could not comply with the further conditions.
Yes.
In 2019, my lord, the sale agreement came to be cancelled. And my lord, he demanded a sum of rupees 85 lakhs that was also paid to him, my lord.
Yes, now what is that order?
Now, my lord, the court below, instead, though my lord, I have showed my bona fides and showed photographs also of his interference, court has simply issued a emergent notice, my lord, on my IA.
Where
My
is
lord,
that?
my lord, page number 17, my lord, page 17. My lord, he doesn't appear in the suit, but he appears before this honorable
lord,
court
even
without
in that
notice
we have-
also.
even in
Today,
that we have-
summons is there, my lord. Yes, my lord.
Where is that order sheet?
My lord, page 17, my lord, page 17. Sorry, my lord, annexure A.
Yeah.
Annexure A.
On 15/3 ಏನಾಯ್ತು?
15/3 ಮತ್ತೆ await service ಅಂತ ಹೋಯ್ತು. ಮತ್ತೆ it is again posted on 24/4, again summons. He doesn't appear there, my lord. Now, my lord, without notice also he appears.
Yes.
He appears here. I have produced the photographs also, my lord. Kindly see the JCB.
Serial number ಎಷ್ಟಿದೆ?
Is 20, my lord.
20.
Yes, my
He
lord.
filed an caveat.
No, he has not filed any caveat.
20 na?
ಹೌದು 20 ಸಮಯ because of my I appear on
Serial number 20.
20, my lord. I appear on for
You have
my
voluntarily you are appeared.
he is
I
voluntary.
got to know that he has filed the injunction suit, my lord. There we are ready to file the wakalat.
What
But
is
on
that
that,
next date there?
My lord, 24/4, my lord.
it may be taken up on 15th or 16th, my lord. It may be disposed on that date.
Latest
24?
4, my lord.
4.
24.
4.
15th or 16th, it may be taken
Until
up.
then, don't,
No, my lord, what he has done
Let
is,
us-
my lord, there was a growth of vegetation, my lord. That he has cleared, that's all. And
No. My
other
lord, he
than
has
that,
no
he has
right
not
over the
done
property.
anything.
till next date, don't do anything. Both of them maintain status.
Please, my lord, please, my lord.
Even when that
I am
was
also-
brought up to the court, that was brought up before the court, my lord, we asked him. He told that since there was jungle and the other parties
But he has
was
no
around
right over the property.
Vandan
Where is the interference?
That you are the only defendant.
He is
I'm
the only defendant.
What is the next date? 24th. You file an, I will say that dispose of that matter in.
On 15th or 16th, it may be disposed of.
No, I will dispose here itself.
Yes.
I will direct it to dispose that application. Is filed by him on merit. You go and appear there. Then till then, both of them maintain status.
Please, my
Let
lord.
them pass an order on merit.
Please, my lord.
Yes. In this petition.
Sir.
Petitioner
Sir.
seeking
Harsha.
set asiding that order date is 6/2/2025 passed in OS number 245 of 2025 by 8th additional civil judge JMFC Mysore, whereby the trial court has refused to grant ex parte injunction order. Plaintiff has filed a suit for
Permanent injunction, my lord.
suit for injunction. Along with that client, he has filed application under order 39 rule 1 and 2. Trial court by order dated, ಯಾವತ್ರಿ ಅದು date?
My lord, order dated
6/2/2025 has issued an
emergent.
summons to that defendant and refused to grant any ex parte injunction order on IA number 1. Again, that matter has been posted on 15/3/2025. Since 15-3 ಏನಾಯ್ತು?
15-3 await notice ಅಂತ ಹೋಯ್ತು.
15-3 ಏನೋ ಜಡ್ಜ್ ಏನೋ ಲೀವ್ ಇದ್ರು ಏನೋ ಇತ್ತು.
15-3 again matter has been urgent directed to posted on 24th.
Yes, my lord, 24th.
24th. Since no interim order has ex parte injunction order has been not granted, the petitioner plaintiff is before this court. The defendant respondent has appeared through counsel. Learned counsel appearing for the respondent submitted. The respondent will appear before the court before next date of hearing by filing an wakalat through their counsel.
A copy may be served even now itself.
I'll serve, my lord.
Copy.
Trial court ಏನಿದೆ ಇವಾಗಲೇ ಕೊಟ್ಬಿಟ್ರೆ
file an
objection ಅವತ್ತೇ ಹಾಕ್ಬಿಡ್ಬೋದು.
Yes.
Ready, my lord. I'm
In view of the above, since defendant respondent has undertaken to appear before the trial court, I am of the opinion that the writ petition may be disposed of with a direction to dispose of that application without expressing any opinion on the merit. Accordingly, writ petition is disposed of. The trial court is directed to dispose of that IA number 1 filed by the plaintiff under Order 39 Rule 1 and 2 by end of April. Till the disposal of that application, parties are directed to maintain status quo in respect of suit scheduled property. The trial court is directed to decide that application on merit without influencing any observation made by this court.
much obliged.
Copy.
But
Yes, you serve a copy.
I'll serve.
Yes.
Bill number 21, Ramachandra for petitioner, K.R. Bharatwaj.
My lord, I have a small submission to make.
Yes.
I'm on caveat in this matter.
Yes.
And I have not been served.
David is not.
Put up, sir.
Mr.
And suit for specific performance.
One rule 10 is rejected, my lord.
He is a lispendence purchaser. Order one
One
rule
rule
10 has
10.
been
Two
rejected.
things. Now, if you want time or you are ready,
I want time. my lord.
ಸೇಲ್ ಡೀಡ್ ಕೊಟ್ಟಿಲ್ಲ ಒಂದೇ ರೀಸನಿಂಗ್
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
ಯಾವತ್ತು ಬೇಕು?
Next week, my lord, 9th, my lord, if it is okay with you.
Yes. At the request, leave this matter on 9th. In the meantime, you serve a copy.
Please.
Bill number 22, Neelu P.S. for petitioner.
Yes.
Petitioners of the plaintiff before the trial court, my lord. They have filed impleading application under order 1 rule 10 to implead proposed defendant number 11, my lord. Defendant number 6 to 9 have entered joint development agreement with proposed defendant number 11, my lord, in the year 2021.
Yes.
On the basis of that, we filed impleading application, my lord. The said impleading application was rejected, stating that list pendency attracts, my lord.
Now, that suit for,
Specific performance, my lord.
they are subsequent purchaser.
No, they have entered joint development agreement. They are the builders.
Where is that? They have entered in a joint development agreement with whom?
With the defendant number 6 to 9.
6 to 9.
Please, my
When,
lord.
during the pendency or before that?
My lord, this joint development agreement was entered during the pendency of the suit, my lord.
During the pendency. Yes, where is that order passed by the trial court?
My lord, page number 23.
20?
3.
Yes.
My lord, it clearly states the proposed defendant has not disputed his joint development agreement with the owners dated 15/12/2021 and is during the pendency of the suit. The copy of the agreement shows that the proposed defendant number 11 agreed to give 35% of the build-up area, including other parts, to the similar extent and retained remaining 65% with him. This is the mere agreement, and there is no transfer of title or interest in his favor as provided under section 19 of the Specific Relief Act. Hence, I am of the opinion that the proposed defendant is not
Take
necessary.
notice. Yes, notice.
Bill number 23, Chandranath Ariga K.
Yes.
Order under challenge, my lords, is on application filed by the defendant number 2, that is petitioner, my lords.
wherein we had sought for certain documents to be produced, directing the Tahsildar to produce certain documents, my lords. The documents are in relation.
Suit for
partition, my lords.
Yes.
In a suit for partition, my lords, there are two contentions which were taken by the plaintiff, my lords. Very first contention, my lords, was that regularization application was filed by defendant number 2. Thereafter, by virtue of an order passed by this honorable court in a writ petition, the matter was remanded. After remand, my lords, the plaintiff also came to be impleaded so motu by the Tahsildar. Our sole contention, my lords, is that the form number 50 under section 77 was filed by defendant number 2, and she is the absolute owner. Then there is no partition which can be effected in the suit schedule properties.
What is your application?
My lords, my application, my lords, is at Annexure G, my lords. It's at ink page number 53, my lords. Now I have sought for a direction by the trial court, directing the Tahsildar to produce
Or
the
entire file related to the proceedings of the EDP. You Tahsildar file, you can file a certified copy by applying that.
My lords, indeed so, my lords, indeed, my lords. The only reason why the application came to be rejected, my lords, is, my lords, may kindly peruse ink page number 58, my lords, the impugned order, my lords. In that, my lords, internal page number 58.
Yes.
65, my lords, ink page number 65. The reasons, my lords.
Yes.
Third line, the reason starts. The defendant number 2 has approached this court by filing frivolous applications, which was without any efforts to obtain the said documents and is completely depending on the court and take advantage or misuse the process of law. Therefore, this court is of the considered opinion that the application is filed by the defendant number 2 without making an effort to obtain certified copies or through RTI would not be maintainable at all. Appear to be only filed to drag the proceedings. The court
that is
cannot
what
call for public documents.
To give, then
My lords,
only you can ask
it
that.
is not that we have not made any efforts. Though the my lords, the penultimate page, my lords, if I may read, my lords, the counsel for the defendant is continuously stating that he has already applied for the document, but the document which he has showed through his mobile was somewhere after filing this application. Though they have filed the application seeking for those documents, it is filed subsequent to the filing of the application before the trial court. My lords, the only reason why we have sought for filed an application before the trial court is, my lords, for a speedy disposal. For the only reason, my lords, if at all, if I file an application, my lords,
you can't ask that to.
my lords, if I may, my lords, if I may refer to a judgment, my lords, by this honorable court. My lords, this honorable court, my lords, in a coordinate bench of this honorable court, my lords, at internal page number 6, though it's a public document, my lords, this honorable court allowed the application for the reason that there should not be any delay. It is true that the petitioner defendant could obtain her own extracts and produce before this court, and also she could obtain certified copies of the documents so observed by the trial court. It is true that the petitioner defendant could produce her own statement and could also submit certain documents, but at the same time, if the application is allowed, no prejudice would be caused to any of the parties, and if the documents are summoned from the bank, it would save some time of the court and it would aid in speedy disposal of the suit. As observed by the trial court, all documents mentioned in the application are not public documents. That is secondary. Moreover, the consent deed is an unregistered document. That is one document.
At the time of the court, it would have been speedy disposal. As observed by the trial court, all documents mentioned in the applications are not public documents. If it is public documents, you cannot seek. That is what that the court intends.
Here was a case, my lords, where there were two types of documents which are sought to be produced: public as well as non-public documents.
Non-public documents, the public documents, you have any remedy under that.
My lords, indeed, my lords. My lords, indeed, my lords.
Therefore, court has specifically stated that, as observed by the trial court, all the documents mentioned in the applications are not public documents. That means to say, if it is a public document, it cannot be.
My lords,
that is what. Yes,
my lords, if I may, my lords, if I may. In addition to all this, my lords, the reason
why
assigned by
can't you
the
file an
trial court,
application and obtain that?
Well, as we have, my lords, well, as by the time we get those documents, my lords, I being a layman, my lords, by getting those documents, my lords, the trial would have been completed, my lords.
Yes.
And my lords, now the
No,
trial
no,
court,
now
my
that,
lords.
in that Right to Information Act, there is a time limits within that. they have
Indeed,
to-
my lords, 30 days is stipulated, right, time limit is there. My lords, what happens is this, my lords, that entire documents will not be summoned. If at all, if I file through an RTI application, entire documents, I may not get it. I may get only certain documents. But if at all, if the court passes an
Whatever the
order, my lords,
documents, if you can get it through that RTI, you get it. If it is not can we get through that, then court can be directed. It is not that you can file an application, otherwise nobody will go to that RTI. Everybody will file an application here only.
my lords, it may be taken up tomorrow, my lords, I shall seek instructions. My
Yes.
lords, on
At the request, leave this matter next week.
that. Date, my lords,
Yes, on 21st.
grateful.
Bill number 24, M.
You are the tenant.
I am the Mulgeni tenant.
But as like in a land reforms, you are also having a right to file.
No, no, I am having a preferential right.
Yes.
Mulageni tenant is transferable and heritable. Yeah, and he is only a formal party, my lord, at annual 10 rupees, 20 rupees, like that.
Yes.
Mulageni tenants, my lord, are predominant, are having more right.
Yes.
Now, my lord, the property is also situated in the Mangalore city, my lord, is a residential house.
Yes.
So Rent Control Act applies, Rent Act applies, since annual, that is also.
Comes within the corporation.
Yes,
limit.
yes, that is among other contentions, my lord. Now, my lord, I have made an application, my lord, that the validity of the said act, my lord, was challenged before this honorable court. And the learned single judge, my lord, has upheld the validity of the act,
Yes.
against which, my lord, a writ appeal is pending, filed, my lord, by the owner, landlords association, my lord,
Yes.
Dakshina Kannada and Udupi district. That appeal is pending, my lord, in writ appeal, my lord, 726 of 2023. I
What is
produced,
that order here you are challenging? You
my
are,
lord, in the suit,
you have filed an.
I have filed, my lord, annexure C,
Yes.
and IN number 7, to stay the suit, my lord, pending disposal of the writ appeal.
Yes.
My lord, annexure C, your lordship will get, my lord.
Yes.
IN number 7 filed by me under section 151, my lord. This application is rejected, my lord, by the trial court now. Wide annexure, my lord, F. Ink page 28 onwards is the order, my lord. The importantly, my lord, ink page 31, my lord, para 9 may kindly be perused.
Yes.
Para 9, your lordship got it, my lord.
Yes.
It appears that the government has enacted the Karnataka Conferment of Ownership on Mulageni or Volamulageni Tenants Act, wherein Mulagenidars and tenants can file application for conferment of their ownership over the tenanted property. The competent authority has to adjudicate the claim, and by fixing the consideration, ownership of the tenanted land can be conferred on the tenants.
Yes.
Next page, your lordship may kindly turn to, my lord, ink page 32,
Yes.
first line, my lord, para 12. It is also to be noted that the act does not say that as on the date of commencement of the act, all Mulageni properties are vested with the government. The procedure has been contemplated in the act to get ownership of the Mulageni tenants. It says that the tenant has to file an application before the competent authority, and the competent authority has to adjudicate the matter.
Yes.
More so, my lord, there is one provision contained in the said act, section 10, my lord. Section 10, I am not having the copy. I'll just read and pass on.
Yes.
I'll read, just
Yes,
read and
you read,
pass on.
yes.
I'm sorry, my lord, I'm not just. Section 10, bar of jurisdiction, except as provided in this act, no civil court shall have jurisdiction,
Civil courts are barred under that.
bar, and all pending proceedings shall be transferred unto the section 10. So, my lord, in the fitness of things,
Yes.
Till the writ appeal is adjudicated, my lord, I sought to stay the further proceedings in this suit. Section 10 subclause.
The single judge has.
Single judge has upheld the validity of the act.
Oh, it is upheld.
Yes,
Now
against
that-
that, my lord, there is a landlords association, Moola Gars Association.
No, see, as on today, this legislation is in force.
Yes,
Then civil court has to apply and reject the suit.
my lord,
Unless it is set aside,
yes.
it is in
But-
the force.
But now the matter is pending in writ appeal and status quo is ordered, my lord. In the writ appeal,
Status quo regarding the position of the parties. That's
ಅಲ್ಲ
all.
ಅದು ಸ್ಟೇಟಸ್ ಅಂತ ಆದ ಕಾರಣ ಈ ಆಕ್ಟ್ ಅನ್ನು ಯಾರು ಮುಟ್ಟೋದಿಲ್ಲ. ಈ ಡಿವಿಷನ್ ಬೆಂಚ್ ಐ ಪ್ರೊಡ್ಯೂಸ್ ದ ಪ್ರಿಂಟ್ ಔಟ್ ಆಲ್ಸೋ ಮೈ ಲಾರ್ಡ್ annexure E. ಮೈ ಲಾರ್ಡ್ ಇಂಕ್ ಪೇಜ್ 26 ಅಲ್ಲಿ
Yes.
order in main appeal, issue notice on the application for stay as well as on the main appeal so and so. The learned senior counsel appearing for the appellant submit that during the pendency of the writ petition, interim order granted in favor of the appellant's petitioners were operating. The learned government advocate opposes the prayer. Considering the submission of the learned senior counsel for the appellants as well as the learned additional government advocate, the parties are directed to maintain status quo as on date till further orders of this court. And the matter is pending, my lord. My lord, on
Heard. Issue notice. Stay of further proceedings in OS number 757 of 2016, pending on the file of first additional civil judge JMFC, Bangalore, till next date of hearing. Let us see. Yeah.
Cell number 25, Chandrasekhar GM.
great.
And
Yes.
my lord, that suit itself is disposed of. Petition does not survive.
Yes, learned counsel for the petitioner filed in a memo stating that original suit itself has been disposed of. The writ petition will become infructuous.
Please,
The memo is taken on record, dismissed as becoming.
please.
Cell number 26, Prakash Angadi PV.
I appear for petitioner in we have deposited the count before the honorable district court in excess of rupees 7,42,000 my lords. There are certain extent of land, 57 square meter was acquired my lord in respect of that, there is a separate bifurcation, apportionment was done. With respect to the compensation with respect to the land is 6,87,652 my lords. Whereas for the acquired structure, 7,42,492 my lords, it is altogether 14,30,144 my lords. Instead of depositing 14,30,000 my lords, we have deposited 21 lakhs my lords. We have filed an application before the honorable district court for seeking refund of the excess amount deposited my lords. No orders is passed my lords. The petition filed under section 3H4 was disposed of by the district court my lords. Thereafter we came to know that the excess amount was deposited my lords. After disposal of the case my lords, we have filed IA my lord. IA is still pending my lord and no orders are passed.
Where is that application?
My lord, I have filed an application at page number 37 my lords, annexure B my lords.
Yes. This to. refund the
We have sought for refund of
Now, what is that amount decreed in that arbitration case?
my lord, it is my lord, SLA was passed the award my lord, determining compensation to the acquired extent 14 lakhs my lords. In the place of 14 lakhs, we have deposited 21 lakhs my lords. Considering that there is a dispute pending before the honorable court my lords. The honorable district court they passed the order in AC allowing the
Appeal.
directing the second respondent to receive the total compensation amount my lord, page number 30 my lord.
No, you have filed an appeal before that district court.
I have filed a
under
petition
3H.
3H my lord.
In that you have deposited an excess amount.
Yes my lords.
What has happened to that appeal?
My lord, that was disposed my lords by the honorable district court.
Entitled to receive total sum of compensation of 21 lakhs.
Yes my lord.
ನೀವು ಎಷ್ಟು ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ರಿ?
ನಾವು 21 lakh ನ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ.
But in the place of 21 lakhs, 14 lakhs was supposed to be deposited by us, my lord.
Remaining,
Remaining 7 lakhs is our money which we have sought for refund of the same, my lords.
no, that order itself is for a 21 lakhs.
ಅಲ್ಲ 21 lakh petition ಫೈಲ್ ಮಾಡ್ಬೇಕಾದ್ರೆ 21 lakh ಅಂತೇಳಿ ಬೈ ಮಿಸ್ಟೇಕ್ ಅದೇನ್ ಸ್ಟ್ರಕ್ಚರ್ ಗೆ ಸಪರೇಟ್ ಅಮೌಂಟ್ ಮಾಡಿದ್ರು, ಡಬಲ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ ಅದನ್ನ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬಿಟ್ಟಿದೀವಿ. ಲ್ಯಾಂಡ್ ಗೆ ಒಂದು ಅಮೌಂಟ್.
ಈ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆರ್ಬಿಟ್ರೇಷನ್ ಕೇಸ್ ಅಲ್ಲಿ
Yes, ma'am.
degree itself is 21 lakhs.
21 lakhs, my lord. That is what, my lord, that has to be set aside by this honorable court, my lord, since as per the entitlement, my lord, we are supposed to deposit only the 14 lakhs, my lords.
No,
By,
now have you challenging this order?
yes, my lords.
No, you are seeking only considering your application.
Yes, I sought for considering my application, my lord.
No, when there is an order that respondent is entitled for a 21 lakhs.
I will file amendment application.
No, you have to challenge that order, or you have to file an application for modification of the decree before the court.
We have filed application only to till not to.
Already degree 21 ಇದೆ. ನೀವು amendment ಕೇಳ್ದಾನೆ ನಂಗೆ ವಾಪಸ್ ಕೊಡಿ ಅಂದ್ರೆ how they will give it, mister? You have to file an application for amendment.
My lord, will file.
Withdraw that and file an application for amendment
My lord,
for that in the AC 5 of 2017.
till then, the district court may directed not to release the excess
No,
amount.
your case itself is not maintainable here. As per that judgment degree, you have to deposit 21 lakhs.
No, that is already deposited, my lords. But in view of the order passed by the district court, if the amount is released to the party, then the exchequer will be difficult, it's very difficult to.
The degree is challenged or degrees seek for a modification. I can't direct that not to release when there is any degree. Degree for 21 lakhs is there.
Decree for 21.
Whether it's a right or wrong, we cannot decide here.
But we have filed an application, my lords, and the honorable district.
How can they direct it to withdraw when degree is 21,000? Application ಆಗತನ ಇಲ್ಲ ಬರೀ 14,000 unless degree is modified.
ಅಲ್ಲ modification ಒಂದು ಐ ಹಾಕಿ ಅಲ್ಲಿ
ಏನಾರ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ that observation may kindly be made. Otherwise, my lord, the district court may not entertain my application.
You have to advise your client what you have to be. You are the counsel, mister. Don't take advice from me. I am not here to advise.
No, my lord, only the.
Otherwise, I will dismiss this petition. It is not maintainable so far. Yes. At the request, please this matter of 2 weeks.
Yes.
Office objection, first time matter, cell number 27, Gopala BV.
Yes, my lord. This is office objections, my lord. I will comply the office objection. In meantime, my lord, there is an urgency, my lord.
I will pass over all office objections. Try to comply that, then we'll take that.
2:30.
Yes, all office objections wherever it necessary.
Yes, ma'am.
That you have to be complied.
Yes.
Then we will call afternoon. Yes.
Okay. Afternoon, it will be called.
No, now that ಎಲ್ಲಿ office ಕಳಿಸ್ತೀರಾ? It will send to that office.
Yes, ma'am.
There you go and comply that.
Yes.
Then all office objections matter, again we will call after 2:30.
Okay.
Yes, wherever there is an office objection, production of certified copies or that legible, that will overrule and pass an order. Wherever that require for that we have to be compliant.
Basically, we'll comply.
Yes.
Cell number 28, Nagmala BK.
Yes. Description of the annexure to be stated, preamble portions of the annexure, type the copy.
Preamble copy ಅಂತ.
Case number is not forthcoming in the annexure A to be.
Annexure A ಅಲ್ಲಿ preamble sheet first sheet ಹಾಕಿಲ್ಲ.
ಬೇಡ. Case number is not forthcoming in annexure A, clarified.
Annexure ಅದೇ first sheet.
You clarify whatever you can done it, yes.
Cell number 29, MS Nagaraja.
See, office objection with regard to incorporation of additional, interim prayer, my lord.
Paginated
Yes.
correctly. Yes.
Interim prayer
Nature of
incorporate.
the respondent to be stated. Yes, you pass out.
Do it in the course of the.
Yes, pass out.
ಇಲ್ಲ ಮಾಡಿ.
Your urgency, you complain.
Yes.
Or if you want time, I will grant for compliance. What is that? You pass out, yes.
Only
Number
incorporation.
Yes.
Cell number 30, Malaya MR.
Yes. Interim prayers to be sought, IA number to be clarified, none appears. 2 weeks.
My lords, in serial number 31, I appear for the petitioner. May I request for a passover, my lords?
Office objection, you comply? Yes.
I'll comply, my lords. Kindly pass over, my lords.
Pass on.
Please.
Yes.
Serial number 32, Ramachandra.
Yes. Ramachandra, none appear. 2 weeks time is granted to comply office objection.
Serial number 33, Hari Prasad MD.
Lordship, we already complied on 22 Jan, my lordship. Again, in regard with the prayer sheet, fresh sheet.
Written statement with respect to that OS. If any written statement hakidara,
Lordship. That are
copy,
all old, my lordship. That are old complaints, objections.
no, that.
The new
have
one
you-
is fresh sheet regarding with fresh sheet of prayer sheet.
No, only 2 office objection.
Only one, my lordship.
Yes, written statement has been filed before the trial court.
Only one, my lordship.
What is that?
Regard with the prayer sheet to be fresh, add fresh sheet.
ಯಾವ್ದ್ರಿ ಅದ್ ಮೇಲ್ಗಡೆದಿದೆಯೇನ್ರಿ?
Last one, lordship.
33.
33.
Hmm.
That can be oral lordship. Matter may be taken up tomorrow.
One time.
Tomorrow or Monday, lordship.
Yes,
During the course, we'll complete the office.
yes. 2 days time is granted to comply.
Monday, lordship, date may be
This
fixed.
matter on Monday.
Monday, much.
Yes.
Office objection, second time matter, serial number 34, Sunil S. Narayan.
Only two ಎಲ್ಲ ಮಾಡಿ ಎರಡಿದೆ ಒಂದು ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ another name has not been mentioned ಅಂತ.
Page 6-7 to be stitched. Name of the R2 in this petition not.
I'll only I will do it during the course of the day I will do it.
Pass on.
Pass.
Serial number 35, Manikanta HB.
Only,
Sheshagiri Rao.
only one office objection, my lords. In synopsis, the year has been interchanged. 1993 ಬದಲು 1995 first ಬಂದಿದೆ.
Copy of the written statement to be filed.
That was overruled by your lordship in the last date of hearing.
Yes, list of the events to be in chronological order in synopsis. Yes.
Lords, already notice
What
was.
is this? Ready? You want?
No, my lords, we are ready, my lords. Notice was issued. It's a application for res judicata, my lords. Wherein, based on the document on which the declaration has to.
Permanent notice to respondent in addition permitted to serve a copy on that. Yes.
They have filed wakalat also, my lords.
Ready?
Okay, ready, my lords.
Where is the other side?
We intimated, my lords. We have intimated.
What is that urgency?
Lords, urgency is now the stage is set down for cross-examination of.
What is your application for?
Application for res judicata, my lords. The suit is hit by res judicata. For the reasons, my lords, the
application is dismissed.
Dismissed, my lords. On the ground, my lords.
Suit
for declaration, recovery of possession and permanent injunction. Filed by respondent number 1, my lords.
Suit for declaration.
Yes, my lords. I have produced plaint.
What is that order? Which is that impugned order?
Lords, impugned order is at page number 61, my lords.
Yes.
Operating portion at page number 66, my lords.
61, 66,
Yes, my lords.
Yes.
Last paradali, my lords.
Yes.
And on perusal of judgment copy of a former suit and the former suit is ex parte judgment, uncontested one. Therefore, this suit will not come under the ambit of section 11 res judicata. The reason assigned is, my lords, because the earlier suit, there was an ex parte judgment, section 11 would not apply to the said case.
What is that law that is it?
My lords, there is a judgment of Andhra Pradesh High Court, my lords.
Yes. Yes.
It's kindly, my lords. In page 5, para 4, my lords.
Page 5, para 4.
Para 4, my lords. The next contention that falls to be noticed is that the rule of para 4, my lords.
Yes.
The next contention that falls to be noticed is that the rule of res judicata is not available to the plaintiff who has obtained only an ex parte decree. I do not think this contention can succeed. An ex parte decree is as much a decree on merits as a decree obtained after contest. The definition of decree in section 2 of CPC equally comprehends both these classes of decrees. There is nothing in section 11 which renders it inapplicable to ex parte decrees. Reliance has been placed by the law and counsel for the respondent on the words heard and finally decided occurring in section 11,
but these words do not seem to be of assisting to him. Where summons in the suit duly issued to the defendant, but he did not take opportunity appearing and contesting the suit, and the suit was decided against him in his absence. It cannot be said that it is not a case heard and decided within the meaning of section 11. Vide Radha Mohan versus Eliza, a decision of Division Bench of Bombay High Court in Baldev Das versus Mahantlal points even more strongly in the same direction. It states that law as follows. It is perfectly clear and now well established that an ex parte decree can operate as res judicata because an ex parte decree is a decree on merits. The court passing the decree hears the case on merits, finally decides it, and passes the decree. The only difference between an ex parte decree and a decree in victim is that when an ex parte decree is passed, the defendant is absent, but an ex parte decree is as much on merits as a decision in victim.
Yes, Mr.
The suit schedule property is same, my lords.
If I'm not wrong, I have to question the very maintainability of the writ petition. I'll tell my lordships why. Let's assume this application is allowed what is filed by. I'll just quantify the net resultant for a moment. The net resultant, my lords, would mean the dismissal of the very suit filed. My lords, if a application is filed to interdict a civil proceeding before the trial court, then, my lords, the application is rejected. Resultantly, my lords, only a revision is maintainable 115 of the CPC. My lords, it's not the interlocutory order. My lords, what they are deeming, my lords, before this honorable court is the intermediary order.
What you said is that finding is not correct. But only thing is that it has to be converted as a CR.
That is one thing. Then, my lords, kindly see. Virtually what they are dealing, my lords, before your lordship, the 7th Rule 11 application. My lords, Hanuman Das Totla, my lords, Supreme Court says, res judicata is a mixed question of fact and law. It cannot be dealt in the 7th Rule 11 application.
All depending upon each fact.
Supreme Court said, my lords, explanation to section 11 says, especially explanation 7 there.
Yes.
Not says.
No, I'm not on that. The court which rejected on the ground is not correct.
In fact, my lords, I would say
ex parte degree is not in a degree. Therefore, it is not in a res judicata. They said it is a mixed question of facts and law. Will be tried. Now that issue has gone now by dismissing that.
What I could say, my lords, is this. If they are before this honorable court saying, my lords, that kindly see, my lords.
No, anyhow that it has to
let them reserve. What I could point out, my lords, is this. Let them reserve that liberty so that an issue can be framed.
No, only one thing we can do it. We can set aside. Trial court has to be directed to reconsider in accordance with law. Then they can say that, not on this ground.
That's why I point out, my lords, this. I'm only pointing out, my lords.
That too, if both are agreed that it can be. Otherwise, it has to go to the CRP.
But it has to, my lords, I would point out this. The writ petition on the face of it is not maintainable.
No, that is what said.
Yes.
If it is not maintainable, it can be converted at a CRP. But what I suggested can be send it back if you both agreed on consent.
May I take only to that
my order cannot be make use in that other case.
All right. May I take my instruction only with respect to that. Yes. For a limited remand, ಅದನ್ನು ಕೇಳ್ಬಿಟ್ಟು ನಾನು ಹೇಳ್ತೀನಿ ಮಧ್ಯಾಹ್ನದೊಳಗೆ ಹೇಳ್ತೀನಿ. If that is all right, andre,
because
I understand.
It is not a precedent in all cases. Tomorrow, it will be before me saying that yes, your lordship. That cannot be. I can straight away say that convert is as a CRP and post it.
I understand. I'm not for a moment saying 7th Rule cannot.
This prima facie that finding is wrong.
It would not come into the ambit of 7 Rule 11 for the reason, my lords. I have produced a copy of the earlier claim
net resultant
and earlier order, my lords.
Ultimately,
if your application
said it is this will be an issue.
Yes,
but there should be a trial whether in both the suits issues are same.
Yes, ma'am.
Whether all has to be tried and decided at the Supreme
Court. That is
issue
exactly the finding of the court also.
My lords, an issue may be framed to that extent and it may be considered as preliminary issue, my lord.
Will say only IA has to be passed in accordance with law. Or I will say that it will go before that.
Because, my lords, kindly see, 6, 7, 8, the trial court, my lords, has actually gone into that issue. It's not that it is given a blind finding to that effect.
It may kindly be seen. The suit schedule property is the similar. They extract it. It is the same.
Can, after framing the issue, to say that it is not in a degree, how can that issue decided tomorrow?
Because my lord,
That's-
already.
No.
There is a
Not
code
what it
which
says,
says
not
that
kindly see. my lord.
their
One
title
moment.
deed is null and void, my lords. They are claiming under the title deed which has been declared as null and void.
No, all that
Kindly, my lords.
title deed, null and void, same issues are there, same property, same parties, all will be tried in that. But court can't say that this is not any degree.
Lords, it may be set aside and be
Not any degree,
remanded
then
back.
Nobody will appear for that, all defendants will not appear. Get them a degree, you can't.
Correct. I would not say that.
Now I
Kindly
will
see,
say
my
that
lord,
you
for a
convert
moment.
as in a CRP.
Let's let
And
them
then,
seek
my lord, kindly see
instruction.
for one moment.
No,
50
I don't want to waste the time.
I'll take that instruction, my lord, because,
No, no, Mr. Sunil, if they pass other than that merit,
Yes,
then I
my lord.
can't because it is actually CRP. Only consent order if they are agreed. Otherwise, I will say that convert as in a CRP. Yes.
Please, my lord, I'll take my instruction only to that effect. There are two additional submissions after that I can place before your lordship. I'll take only to that effect. Madhyana itkotira, sir. Madhyana.
Now, because on that issue, I can't decide if you are argued. Then I am entertaining this. Tomorrow it should not be president in other case. That's what that my concern is.
ಅಲ್ಲ, ಇನ್ನೊಂದು coordinate bench ಏನ್ ಮಾಡಿದ್ದಾರೆ, they've exercised powers under order 7 rule 11 in some interlocutory application.
On 151, my lords.
151 ನಲ್ಲೇ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. Saying that
There was no 7 rule 11, my lords.
7
The
rule
court
11
invoked
they
7
said
rule 11 and
226 ಅಲ್ಲಿ I
rejected
can
that
exercise
line,
such
my lords.
powers ಅಂತ ಹೇಳಿ a suit has been
No,
rejected.
when specific provision is
Exactly.
there, you can't
Exactly.
invoke that 151.
Kindly.
161, 151 cannot come to the
Can't be
aid.
invoked that. Otherwise, that yes.
Kindly.
Yes,
Please.
pass on.
Kindly. Grateful.
For order serial number 36, Purna Chandra and Puranik.
For the petitioner, my lord, there's one office objection regarding the death of defendant number 2. LRs of defendant number 2 are not brought in the trial court only and the amended plaint was filed.
Srimati, defendant number 2, Lakshmi, not a deceased person as per that order passed by the senior civil judge, Principal JMC Archikere, annexed person to be clarified. Then after the degree, they are dead.
Yeah, no, my lord, before only they have died. Amended plaint has been produced on 21/6/2024, Annexure D, page number 45.
Be produced. Since
ಮೃತರು ಇವರು ಕಾನೂನು ಸಮ್ಮತ ವಾರಸುದಾರರು ಯಾರು ಇರುವುದಿಲ್ಲ.
Now, where is the plaint?
Plaint is produced at page number 45, my lord.
Yes.
Defendant number 2, there are no legal representatives.
45, defendant number 2.
Yes,
Yaru Lakshmi.
Lakshmi. Lakshmi has passed away, my lord.
See, so and so, Yaru LRs illa.
ಯಾರು LRs ಇಲ್ಲ.
Now
Yes.
that, who is that? Now, whom you have made a party here?
I've made defendant number 1 and 3 the parties.
2 is not made a party.
2
No
is not a
election.
party.
What is that office objection?
Office objection is why the defendant number 2 is not made a party.
Yes, that is the only office objection.
Yes, my lord.
Yes. What is this matter?
Lord, my impleading application has been rejected by the trial court. Suit for partition. Sale agreement has been executed in my favor. This is the only item in the partition suit, my lord. And the defendants had filed an injunction suit against me. And in that, the compromise decree has been passed in favor of me. Kindly see the compromise decree, my lord, at page number 39.
What is that compromise?
Compromise is that they admit that their sale agreement has been executed in my favor.
Who has executed the sale deed?
Defendant numbers 1, 2, 3. All the defendants.
All the defendants.
All the defendants have executed this sale deed.
That plaintiff is before the
Plaintiff is before the trial court for the suit for partition.
partition, yes.
Since
Now you filed an application for impleading.
impleading on the ground that I've paid already 8,80,000, my lord, of total.
Your application is dismissed.
My lord, reasoning is at page number 22.
Yes.
Admittedly, it is a suit for partition and separate possession which has been filed alleging that the suit scheduled property is ancestral joint family property of plaintiffs and defendants. The third party applicant is alleged to be the agreement holder of the suit scheduled property. According to him, the present defendant number 1, 2, 3 had entered into an agreement with him agreeing to sell the suit scheduled property for consideration of rupees 21 lakhs and already have received an amount of rupees 8,80,000. Admittedly, the plaintiffs are not the party to the agreement. The alleged agreement is executed by defendant number 1, 2, 3 herein. It is also alleged
But
that
that property is the suit scheduled property.
yes, my lord, that's the only property in this partition suit.
Issue notice. Stay of further proceedings in OS number 34 of 2023. Pending in the file of senior civil judge JMFC Tarikere till next date of it.
Grateful, my lord.
Submission is accepted. Office objection is over.
Serial number 37, Guru.
In this case, I prefer the petitioner.
Only one objection which I have completed all objections, my lord.
Copy of the proceedings to be furnished.
Proceeding complete, that is, I produced the online. What is the suit? Suit is for partition, my lord. Suit is for partition.
Who are you? You
I
are
am
the
also one of the daughter of the, my lord.
defendant.
I am the sister of the plaintiff, my lord.
Yes.
Here, I have filed an application order 6/17 to implement some documents. Just to amend the pleadings, just one para. That has been rejected by the court by stating that the no details of that property has been mentioned in the amendment. My only amendment I have asked for only one para of pleading, my lord.
What is that para you want?
That is some document, some properties are not been involved in this case
No, that is
and the
what-
partition.
Now you are saying that they have not included some
Some
of the
properties.
properties ಅಂತ. ಅದಕ್ಕೆ ಕೋರ್ಟರ್ ಏನ್ ಹೇಳೋದು ಅಂತಂದ್ರೆ
Details ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಏನಾರ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಹಾಕಿ ಅಂತ ಅದರ್ವೈಸ್ ಯು ಕಾಂಟ್ go on adding all other properties to the joint family property. That's what they said. What is that document to show?
ಡೀಟೇಲ್ಸ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ, ಬರೀ ನಾನು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡು ಅಂತ ಕೇಳಿದ್ದೀನಿ, ನಾನು ಬೇರೆ ಏನು ಕೇಳ್ತಾ ಇಲ್ಲ.
No, to allow your amendment to show that this is a joint family property, you have to produce the documents to convince the court.
ಜಸ್ಟ್ ಓನ್ಲಿ ಟು ಅಮೆಂಡ್ಮೆಂಟ್, ಬೇರೆ ನಾನು ಕೇಳ್ತಾ ಇಲ್ಲ ಅದಕ್ಕೆ.
ನೀವು ಕೇಳಿದ ತಕ್ಷಣ ಕೊಡ್ಬೇಕು ಅಂತಿಲ್ಲ, ನೀವು ಕೊಡ್ಬೇಕಾದ್ರೆ ಕೋರ್ಟ್ ಅನ್ನು ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಬೇಕು. ಕೋರ್ಟ್ ಅನ್ನು ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಇದು ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಆಗಿರ್ಬೇಕು, ಇಲ್ಲ ಅಂದ್ರೆ ಎಲ್ಲಾ ಪ್ರಾಪರ್ಟಿನೂ ಆಡ್ ಮಾಡಕ್ ಬರಲ್ಲ.
ಮೀನ್ ಮೇಲೆ ನಾನು ಕೊಡ್ತೀನಿ, ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಸ್ಟೇ ಮಾಡಿದ್ರೆ ನಾನು ಕೊಡ್ತೀನಿ.
You produce before me now, this properties is a joint.
ಪ್ರೆಸೆಂಟ್ ಅಲ್ಲ, ಬಿಕಾಸ್ 8th ಗೆ ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಡಿಪೆಂಡೆನ್ಸ್ ಆಗಿಲ್ಲ, ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್, ಮೈ ಲಾರ್ಡ್.
No, unless you produce and prove that, we cannot.
At least try to, let it be posted on 7th, my lord. Try to, 8th ಇದೆ, try ಮಾಡ್ತೀನಿ ನಾನು, try my best.
You produce the documents.
ಮೈಸೂರಿಂದ ನೋಡೋಣ, we'll see that. I try my best to do that.
Yes, leave this matter on.
ಇಲ್ಲದ್ರೆ I'll withdraw it, that's all. 7th, my lord. 7th. Much obliged.
Cell number 38, P. Nataraju.
Lord, the application filed by the petitioner under order 91 rule 21 rule 97 has been rejected summarily at annexure F, my lord.
Then
The appealable level order anta in identical matter this honorable court, when the application rejected on summarily, keeping up with the question of
But
maintainability.
I have passed an order saying that it is not maintainable because you see that section 103, rule 103, it's in a decree.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಏನ ಸಮ್ಮರಿಲಿ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ, ಇಟ್ ಆಲ್ ಅಮೌಂಟ್ಸ್ ಟು ಡಿಗ್ರಿ ಅಂತ ಹೇಳಿ, relying upon the judgment of the honorable, keeping up with the question of maintainability, this honorable court, my lord, entertained.
Now what has happened? Your application is summarily rejected.
Yes, summarily rejected without holding any inquiry.
The issue emergent notice in addition to the judgment is ಇವ್ರದೇ ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ಅಪೀಲ್ ಅಂತ. But only distinction is they here
Is summarily rejected. In this case also, the application is summarily rejected. At annexure, your lordship kindly at annexure, F, my lord, page 35.
F.
Page 35.
Yes.
It has been summarily rejected, my lord, on the ground that, my lord, all the rights are decided in OS number 34/2018.
It's not stable interest in the suit property, the executing court could not have proceeded to recover from the so and so. Issue emergent notice in addition, learned counsel of petitioner directed to serve copy. So and so. But in the documents, there is an objection that the petition is not in the present the first statement of apex court in case of so and so, so and so. And then the summary dismissal of an application under so and so procedure. Established. In respect of office objection, learned counsel for the petitioner has placed an order passed by this court in WP number 29074 of 2024 on 29/10/2024. In view of the above, on the order extract. pass following order. In view of the above, office objection regarding mental liberty is kept open. Issue notice.
Third first stay, my lord, otherwise, my lord,
That what is the stage that?
ಅಲ್ಲ ಅವರು ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿ ADLR ನ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿ ಈ ಸ್ಕೆಚ್ ನ 11 ಸ್ಕೆಚ್ ಪ್ರಿಪೇರ್ ಮಾಡಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಫ್ ಸೇಲ್ ಡೀಡ್ ಗೆ.
What is your interest?
I am the brother of the first dependent, my lord. I have filed a suit for partition.
Stay of further proceedings in execution number 39 of 2021 pending on the file of learned senior civil judge JMFC Malwali till next date of hearing.
Much of.
Till number 39, Sneha Nagraj.
Okay, for the petitioner.
Yes, what is that maintainability, madam?
Maintainability, like the matter had come up day before yesterday. I showed your lordship that this was a suit that got, the 7 to 11 came to be allowed. I filed a regular appeal before the PDJ. Because the pecuniary jurisdiction was below 10 lakhs.
No,
The suit
without,
was,
yes, without your appeal is admitted, that has been dismissed.
no, my appeal wasn't even numbered. Please see annexure A.
No, that's without registration of your appeal.
Without registration,
Yes.
the learned appellate court said the pecuniary jurisdiction doesn't fall within the court.
Now, what is that, your,
I'm only seeking remand of my matter back.
no, what is this suit for?
This suit was for declaration, to
Declaration.
declare that the sale deeds were null and void and not binding on the plaintiff.
You are the defendant or a plaintiff?
I'm the plaintiff in the suit.
Yes, what is that plaintiff is valued in before the trial court?
1,000 rupees, your lordship.
1,000 rupees. It is filed
Because
in
the sale deeds that I'm seeking null and
filed
void
in which court?
before Senior Civil Judge Nelmangla.
Yes, where is that, this thing? Judgment and degree.
Please see, your lordship.
What is
Annexure
that,
B. Annexure
value of
B,
the suit in that trial court?
1,000 rupees.
No, if it is, if you have filed in a suit before that senior civil judge, means it should be in a more than 5 lakhs.
No, your lordship. There they admitted, they said it comes before Senior Civil Judge and that's how it was.
See, if it is in a less than 5 lakhs, it has to be go before the junior division. Only a 5, more than
How this got admitted before came Senior Civil Judge.
where is that plaintiff?
Please see, no, please see Annexure B, which is an order passed by the Senior Civil Judge Nelmangla.
I want to know the plaintiff.
Plaintiff.
What is that value you have made it?
Valuation slip is at page 84, your lordship. Declaration suit, total is 1,025.
No, this is for valuation for the purpose of court fee.
Court fee,
Where is
please.
that plaintiff?
Plaint is at page 74.
For the purpose of jurisdiction, you have to say what is the value of the suit, madam? 80?
That at para 20 of the plaint, it says for the purpose of court fee, the suit is valued as per separate valuation slip annexed herewith.
Where is that?
At page 81 of the plaint.
Yes.
So as per the valuation slip,
The suit is valued as per the separate valuation slip annexed herewith. Court fee is paid accordingly. For the purpose of court fee, for the purpose of jurisdiction. Cause of action, defendant weak situated, so and so, Nelamangala within the jurisdiction of this court. Plaintiff recently came to know that defendant number 5 to 6 developed their property 1 week back situated in.
there is nothing specific on jurisdiction, your lordship.
No, if it is, properties is valid to less than 5 lakhs, it has to go before the junior division, is it not?
That is my understanding because in Bangalore Rural Court, that is the rule they follow.
No,
But
that- there is
in
no
Nelmangla,
Principal civil judge. Where is that,
the 7 to 11 order, your lordship will find it at annexure B, page 44.
order?
Annexure B, page 44.
Yes.
This 7 rule 11 came to be allowed on the ground that the court doesn't have jurisdiction or the jurisdiction of the court is barred under section 430 of the Companies Act.
The applicant, here filed application under order 7 rule for rejection of the plaint on the ground that there is no cause of action for the suit and the plaint is barred by law. under 430 of the Companies Act in support of this so and so. This order you have challenged before that.
Before the learned PDJ, which
That is
you are-
what is that, see, valuation for the purpose of jurisdiction is different, madam.
Your Lordship may kindly look at the Karnataka Civil Codes Act.
Yes. No, but that order 7,
Section 19.
you see order 7, rule 1. Statement of value of the subject matter of the suit for the purpose of jurisdiction of the court so far as. Yes, what is that?
We filed the appeal. Please see Section 19, Your Lordship. It says appeals from senior civil judge. Appeals from the decrees and orders passed by senior in original suit and proceedings of civil nature shall, when such appeals are allowed by law, lie.
The appeal from the degree of the order passed by civil judge, so and so. Jurisdiction is mentioned, madam.
Please, Your Lordship. It's in subclause 1, it says to the district court where the amount of value of the subject matter of the original suit or proceeding does not exceed 10 lakhs. The interpretation, in fact, the learned appellate judge has not even addressed this, even though this was argued.
Civil judge, 5 lakhs, up to 5 lakhs, you see that the civil judge has a power. That is 17.
Please, Your Lordship. But I don't know why in Nelmangla they took it before the senior civil judge. That allotment.
Anybody knows? Anyhow, you take notice now. Let that.
Summarily, sometimes declaratory suits go before senior civil judges as well.
No, is it that this thing?
In Bangalore rural courts, there's a process. I'm aware that whatever your Lordship is saying, in fact, I think now it is 15 lakhs. If it is above 15 lakhs, it goes before senior civil judge. Below goes before civil judge. But I'm not aware of the protocol that is followed in Nelmangla, your Lordship.
Yes, now anyhow you take notice in this. Yes. Issue emergent
It's,
notice.
in fact, the parties are not even served. I'm on a very limited point on jurisdiction.
When that order is in their favor of that parties, they should be heard before passing that order.
Please, your
Even-
Lordship, I'm only on jurisdiction. It's not even, I'm not on facts.
No, if that your appeal is dismissed, they are beneficiary under that order.
They are on caveat before the RA.
Caveat, that order which is, even though they are not in a party, but they have to be heard before. See, they come to know now that there is an order my favor. Now that without giving in a notice.
No,
you
I
can't-
understand.
Yes,
I'll take notice.
notice.
Great.
Regarding office objection is kept open, issue emergent notice. Yes.
The matter may be had next week.
No, you have to be served, so many
We'll,
response.
we'll serve your Lordship.
Yes, you want to take hand summons?
2 weeks. Yeah, hand summons. I may be permitted.
Permitted to serve a council, party is permitted to take out hand summons to the respondent.
Your Lordship may kindly out on 15th.
Service, you move that matter.
Great.
Yes.
Yes, if appearing for petitioner, my Lordship, only 2 office objection, my Lordship. Kindly see page number 47. The 3 lines of illegible.
What is this matter? Yes.
My Lordship, petition, suit for declaration and mandatory injunction damages by respondent, my Lordship. In this petition, we are challenging for order dated 21 to 2025, my Lordship. On our.
May I submit, my lord?
On,
My lord,
on
I
order-
take notice for respondents, my lord.
The application filed by the.
Yes, yes, yes.
I'll
Let
file
us
my
see
objections,
what
my
is-
lord. This application for filing of written statement has been rejected, my lord.
Yes.
They remained silent.
Your application for filing a written statement is rejected.
Yes, my Lordship.
Now,
I'll file my objections, my lordship.
My lordship, next matter posted for 9/4/2025, my lordship, for final hearing.
Nine?
9/4/2025.
Yes, yes, Mister, we'll stay further proceedings till then.
My lord, it may be posted on 7th, my lord. By then I'll file my objections and
What
wakalatnama. It may
objection
be.
you can file for an
My lord,
petition?
they kept quiet for a year, my lord. 1 year they kept quiet. They are
That is objection
participating
you
in
have
the
filed before
proceeding.
the trial.
Yes, my lord, I have filed my objection. Detailed order has been passed.
What do you want?
My lord, dismissal of the application, my lord.
Yes, yes, we'll hear that, yes. Submission is accepted, office objection is overruled. Is this matter? What is the next date?
My lordship, 9/4/2025, the matter is
This
posted.
matter on 8th. Yes,
Grateful, my lord. Grateful.
On 8th, cell number 41, Venkatesh R. Kotak.
My lords, the office objection is, my lords, two persons are not made as a party, my lords. I will take your lordship to page annexure A, page 12, my lords.
Yes.
Left hand side, my lord, order sheet. Nanjamma deceased by Girijamma. She is also died. Raju also died.
Our LRC.
They are not made. ಅವ್ರಿಗೆ ಪಾರ್ಟಿನೇ ಮಾಡಿಲ್ಲ ಅವರಲ್ಲಿ. ಅದಕ್ಕೆ ನಾನು ಯಾರಿದ್ದಾರೆ ಬದುಕಿದವರಿಗೆ ಅಷ್ಟೇ ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀನಿ.
No, if they are beneficiary under that order, you have to make them LRC as a party, Mister.
They are not beneficiary, my lord. They are not having anything now. That's
what is
a
the
receiver has been appointed, my lord. That appointment of the receiver order, despite the stay order of this honorable court in RSA, that has been challenged, my lord.
No, that,
I'll take your lordship to the order, a cryptic
the
order passed at page 13, my lords. That order may be kindly seen, my lord, order 40. Page 13. No finding recorded at all. No reasoning.
What is that order?
Page 13.
Yes, read.
Application is filed under by the petitioners under Order 40 Rule 1 of CPC appoints receiver to collect rent. On the contrary, objection is filed by the party to dismiss the application. On perusal of the entire material, this court finds that it is just and convenient to appoint a receiver for collecting the rent with respect to the property which is in dispute, and it is necessary to confer upon the receiver all powers for realization of the relief as sought by the application in order to protect the interest of the parties and ensure the preservation of the property
is the
during the
suit
pendency
for?
of the petition.
What
Suit
is the
for
suit?
partition. Suit for partition, my lord.
Yes, order 40 rule 1 kodi.
And this honorable court has granted stay, my lords, for that decree. I will take a lordship to the stay order, my lords.
Degree is stayed.
Yes, my lord.
This order is
I
passed.
will take a lordship.
In final degree proceedings.
Yes, my lord. Annexure E, my lords. Page 72.
Yes, yes. Heard issue notice stay of impugn order dated 22/1/2025 passed by Senior Civil Judge JMFC Chandrapatna in FDP 10 of 2016 till next date of
Yes.
Yes. Office of
Much obliged, my lord.
Yes. Yes. ಏನಮ್ಮ ಹಾ ಯಾವುದು ಇನ್ನ ರೀಚ್ ಆಗಿಲ್ಲ ಅರ್ಚನೆ ಇಲ್ಲ ಬಿದ್ದೋಗುತ್ತೆ ಹೇಳಿ ಹಾ ಇಲ್ಲಪ್ಪ
ಇದು 40 ಇದಾಯ್ತಲ್ಲ ಮತ್ತೆ ರಿಲೀಸ್ ಆಯ್ತಲ್ಲ 8 40 ಸೀರಿಯಲ್ ನಂಬರ್
ರಿಲೀಸ್
ಹಾ ಸರ್ ಇದು ಅವರು ಯಾರೋ ಇಂಟರ್ಫಿಯರ್ ಆದ್ರು ಇದು ವಿಸಿಲಿ
ಇದೆ
ಸರ್ ಇದು 40 ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್
ಹೌದಪ್ಪ ಅದಾಯ್ತಲ್ಲ 8ನೇ ತಾರೀಕು ಇನ್ನೇನು ರಿಲೀಸ್ ಅಂತ ನಂಗೆ ಅರ್ಥ
8ನೇ ತಾರೀಕಿಗೆ ಮತ್ತೆ ಇದಾಗತ್ತಲ್ಲ ಸರ್
ಯಾರು ಹೇಳಿ ಯಾರು ಹೇಳಿ
ನೋಟಿಸ್ ಆಯ್ತಾ ಸರ್
ಯಾರು ಹೇಳಿರ್ಬೇಕಲ್ವ ನಾನು ನೋಡಕ್ಕಲ್ಲಿ ಆತರ ಯಾರು ಪಾಸ್ವರ್ಡ್ ಜಾಸ್ತಿ ಎಲ್ಲ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಆಚೆ ಏನಂತ ಜೋರಾಗಿ ಹೇಳಿ ಸರ್ ಏನು ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ ಹೇಳಿ ಜೋರಾಗಿ ಸಾಹೇಬ್ರು ಇಲ್ವಲ್ಲ
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸಾಹೇಬ್ರಲ್ಲ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹಲೋ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 49 ಏನಾದ್ರು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಆಗಿದೆ ಸರ್
ಹೇಳಿ ಸರ್ ಯಾರು ಹಾ
ಸೀರಿಯಲ್ ನಂಬರ್ 49 49 ಹಾ
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ
ಇಲ್ಲ ಓಕೆ ಓಕೆ ರೈಟ್ ಸರ್ ಓಕೆ ಸರ್
ಯಾವಪ್ಪ ಪ್ರೊಸೀಜರ್ ಆಗಿದೆಯಾ ಇಲ್ವಾ ಅಂತ 1:40 ಊಟ ಕೂತ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ ಡೈಲಿ ಇದೇ ಕೆಲಸ ಆಗೋಗಿದೆ ನಿಮ್ಗೆ ಏನ್ ಹೇಳಿ ಇಷ್ಟು ಕೇಳಿಸ್ಕೋಬೇಕು ಇಷ್ಟಿದೆ ಎಲ್ಲರಿಗೂ ಹೇಳ್ತಾ ಕೂತ್ಕೊಳ್ಳ ಯಾವುದು 66 ಇಲ್ಲ ಆಮೇಲೆ ಬರ್ಬೇಕು ಯಾವ್ದು ಮಾಡಲ್ಲ ನಿಮ್ಮ ಅನುಕೂಲ ಅಷ್ಟೇ ನೋಡ್ಕೊಂತೀರ ಬೇರೆ ಸ್ಟಾಫ್ ಹೆಂಗಾದ್ರೂ ಹೋಗ್ಲಿ ಬೆಳಿಗ್ಗೆಯಿಂದ ಇಲ್ಲೇ ಕುಂತಿರ್ತೀವಿ ಸರ್ ರೆಸ್ಟ್ ರೂಮ್ಗೂ ಸಹಿತ ಹೋಗಿರಲ್ಲ ನೀವು ಅರ್ಥನೇ ಮಾಡ್ಕೊಳಲ್ಲ ನಿಮ್ದು ಆಯ್ತಾ ಕೆಲಸ ಅಷ್ಟೇ ಒಬ್ರಿಗೆ ಹೇಳಕ್ ಶುರು ಮಾಡೋದು ನಾನು 130 ಜನ ನಮಗೂ ಹೇಳೋದು
Court officer.
ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ ಅವನ ಹತ್ರ ಕೊಟ್ಕೊಳ್ಳಿ ಇಲ್ಲಿ ಕೊಟ್ಕೊಳ್ಳಿ ಸರ್. ಹೇಳೋದು ನೀವು ಕೇಳಕ್ಕೆ ನೀವು ಯಾರು ಹೇಳಿದ್ರಲ್ಲ ಪೆಂಡಿಂಗ್ ಅವನ ಹತ್ರ ಕೊಟ್ಕೊಳ್ಳಿ. ಅದೇನಂತಾರೆ
43 ಕರೆದಿದ್ದಾರೆ. 43. ಹೌದಾ?
Court officer? Court officer? Court officer?
ಹಲೋ
Court officer?
ಹೇಳಿ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
Sir, past hour matters ಎಷ್ಟಿದೆ ಸರ್?
ಜಾಸ್ತಿ ಇದೆ ಸರ್, ಎಲ್ಲ ಸ್ಕೂಟನಿಗೆ ಹೋಗಿರುತ್ತೆ, ಬರ್ಬೇಕು.
ಏನ್ ಸರ್?
ಸ್ಕೂಟನಿಂದ ಬಂದಿದ್ದು ಯಾವ್ದು ಫೈಲ್ಗಳಿಲ್ವ, ಇನ್ನೂ ಬಂದಿಲ್ವಾ? ಅದೇ ಅದೊಂದು ಬಿಟ್ರೆ ಇನ್ಯಾವುದೂ ಇಲ್ಲ. ಬಾಗ್ಲು ಅಂತ ತೆಗೆದುಬಿಡಿ ಗಿರೀಶ್. ಒಂದು ಬ್ಯಾಂಕ್ ಕೆಲಸ ಆಯ್ತಾ? ಆಯ್ತಾ ಒಟ್ಟಲ್ಲಿ? ಆಗಿದ್ರೆ ಆಯ್ತು. ನಾಳೆದೊಂದು ಡೇಟ್ ಮಾಡಿದೆ ಗಿರೀಶ್. ಆ, 5758 ಸೀರಿಯಲ್ ನಂಬರ್ 19, ಒಂದು ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ, ಸೀರಿಯಲ್ ನಂಬರ್ 13. ಚೆಗೆ ಇವತ್ತಿತ್ತಾ? ಇವತ್ತು ಯಾವ್ದೋ ಹುಡುಗಿ ಡೌಟ್ ಕೊಡ್ತಾ ಇತ್ತು, ಹೇಳ್ತಾರೆ ಸರ್ ಅವರು. 74 ಅದು ಡೇಟ್ ಇದೆ ಕಣ್ರಿ. ಅದೊಂದು ಡೇಟ್ ಕರೆಕ್ಟ್. ಅಡ್ವೊಕೇಟ್ 10 ನಿಮಿಷ ನಾನು ಹೇಳಕ್ಕಾಗಲ್ಲ ಸಾಹೇಬ್ರು ಏನ್ ಹೇಳ್ತಾರೋ ನೀವ್ ಹೇಳಕ್ಕಾಗಲ್ಲ ಯಾರಾದ್ರೂ ಅಡ್ವೊಕೇಟ್ ಹೇಳ್ಬೇಕು. ಎಲ್ಲ ತಪ್ಪದಪ್ಪ ಫೈಲ್ಸು ಇವತ್ತಿಂದಲೇ ಅವತ್ತು ನಾವು ಕೇಳಂಗಿಲ್ಲ. ಫಸ್ಟ್ ಬಂದಿದ್ದಾರೆ ಇನ್ನೂ ಬಂದಿಲ್ಲ ಕರ್ಸ್ಬಿಡಿ ಯಾಕೆಂದ್ರೆ 3:30 Serial number 43 M Siva Prakash for petitioner connected matter avoid service.
Yes. Avoid service of notice.
Serial number 44 urgent. Serial number 45 Shrikant VK counsel on the subsection 4.
Get submission in this case. In serial number 11, they had asked about the wakalat. Wakalat have filed at the end of the file. And in serial number 27, they have told to make list of authorities as an annexure. It is stitched separately.
Before honorable court leaves this authority, this authority. ಎಲ್ಲಿದೆ ಆಫ್ ಸಬ್ಜೆಕ್ಟ್ ಯಾವ್ದು ಆಫ್ ಸಬ್ಜೆಕ್ಟ್ ಇವ ಎಷ್ಟಿದಾವೆ 11 ತೋರಿಸ್ತಾನೆ ಇಲ್ಲಿಲ್ರಿ ಇದು ಬಿಫೋರ್ ಹಾನಬಲ್ ಕೋರ್ಟ್ ಅಂತಾರೆ ಎಂತದ್ದು 214 ಹಿಂದ್ಗಡೆ 214 ಅಂದ್ರೆ ಹಿಂದ್ಗಡೆ 2 ಬಿಫೋರ್ ಹಾನಬಲ್ ಕೋರ್ಟ್ ಅಂದ್ರೆ ಎಂತದ್ದು leaves this authority stitched together as a citation before honorable court ಅಂದ್ರೆ ಏನಂತದ what is the office objection mister before honorable court ಅಂದ್ರೆ ಏನು what is this
ಆತರ ಏನಿಲ್ಲ
ಈ ಕಡೆ ಇರಬೇಕು annexure of the respondent number 1 to be stated in this cast act remove all the office objection what is the office objection mister I didn't understand
Lordship, it is in serial number 27. ಈ ಲಿಸ್ಟ್ ಆಫ್ ಅಥಾರಿಟೀಸ್ ನ ಫೈಲ್ ಮಾಡಿದ್ದೆ
ಎಲ್ಲಿ ಏನು ಸೀರಿಯಲ್ ನಂಬರ್ 27 ಏನು
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ serial number 27.
27 is not there.
They are asking list of authorities to be made as annexure. List of authorities na annexure ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ, so have stitched it separately.
But ಎಲ್ಲಿದೆ 27
45
ಅದೇನಂತೆ before honorable court ಅಂತ ಆಯ್ತು yes what is this
This is a suit for declaration, your lordship, which was filed by plaintiff. And in this I have challenging two impugned orders. Order on IA number 11 and IA number 18, your lordship. IA number 11, your lordship. If you kindly come to page number 34.
yes
In this, your lordship, they applied, they filed application to mark one additional document. Your Lordship, our contention is that they want to mark the authorization letter.
Yes.
They want to mark the authorization letter given by the company to this PW2. But actually the thing is, in Annexure P, if your Lordship kindly come to Annexure P, it is one more authorization letter
Yes.
produced at Honorable NCLT, and it was proved to be forged one. So this authorization letter also, it is completely a forged one, because that particular director, he resigned before.
Where is that application?
It is in 62 to 71, Annexure C.
62, for reasons shown in the please to recall that article for further examination of chief, the above case in the interest of justice. Yes. Recalling. Now, what is that order of the trial court?
The order of trial court is, they have not considered our submission that document itself is a forged one. And it is not brought in the order also.
Recalled only the purpose of marking of the. Yes, it's subject to that objection, it will be marked.
But your Lordship, that we have raised that objection. This authorization letter is not a original one, it is a fake one, forged one. Already one such forged authorization letter of the same person, Bhujangrao, it is produced at NCLT, and it is proved to be a forged one. We have submitted even forensic report also.
No, that all you can address at the time of final hearing. All document marking is subject to that objection. It will be decided in the final hearing. That's what Supreme Court said.
But this,
by marking itself, it is not that it is proved, is it not?
But this person, he was not a director to represent the company. He was just an employee of the company, and he was added under Order 3, Rule 2. Once the original director got resigned from his job, he came under by filing application under Order 3, Rule 2.
Yes.
But there, your Lordship, he has not filed his wakalat itself.
Who?
This is the person, PW2. There's no wakalat of this person. No one is representing this company, and all of us, they just want to mark this document.
No, see, he has been impleaded.
Yes.
Who is that person?
Bhujangarao. That is PW2. He has been implemented on Order 3, Rule 2. He has filed application.
That is allowed.
It can be allowed.
But that you have not challenged.
That I am not challenging.
Then
that it is not challenged.
Now you can't say that.
But later we came to know that he has not filed wakalat itself. Without filing wakalat, how can that document can be marked?
No, see, have you challenged that he has been made as a party to the proceedings?
No.
Then where is that order?
Annexure K, your Lordship.
They want to examine who is PW2.
PW2 is Bhujangarao.
Bhujangarao.
Yeah.
He's a plaintiff.
Yeah, he is representing plaintiff company.
The Bhujangarao anta. Having register office, industrial area, represented by CTO authorized signature.
He resigned. And he went. First he deposed. He gave his deposition, CTO. Well, later we filed perjury application. The moment we filed perjury application, he gave resignation from the company, and he filed memo before the trial court judge to defer his deposition. So his deposition was not taken into consideration. Later PW2 came. He filed Order 3 Rule 2 application, and he says, "I'm ready to mark the document." And which is the document? The document is nothing but a forged one. It is already produced before NCLT. It is proved.
Marking itself not be proved that it is all subjective or objection.
Definitely, that we wanted to even to cross-examine him.
That
so
can be done.
We filed that application for that.
Where is that application?
It is Annexure B. Annexure B, that is the Annexure B order, which we are challenging subsequently.
Where is that?
Page number 50.
IA filed by the defendant under so and so read with
IA number 18.
Cross examination. No, your application is dismissed.
Yes, my application is dismissed, sir. In annexure B.
You want to cross-examine.
Yes, I want to cross-examine him
After
because,
this as marking.
because he has deposed that,
Why it is dismissed your application?
because your lordship, uh, their learned judge is not considering the merits of the
Are you
application.
challenging this also?
Yes, I'm challenging that also.
Where is that?
Annexure A and annexure B, both I'm challenging in my prayer.
Yes. Now what is the stage?
It is defined evidence.
Yes. Or issue notice. Stay of further proceedings in OS number. What is that OS number?
2
2 of 2021, pending in the file of principal district and session judge, Bangalore till next date of it.
ಇದರಲ್ಲಿ ಎಕ್ಸಿಬಿಷನ್ ಕೇಸು 12 ವರ್ಷದಿಂದ ಏನು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿಲ್ಲ ಅಂತ ಬಂದಿದ್ದು ತಾವು ಕೇಳಿದ್ರೆ ಮೊನ್ನೆ 1ನೇ ತಾರೀಕು ಸಹ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ ಹಾಕೋತಾರೆ 23ನೇ ತಾರೀಕು ಅದಾದ್ಮೇಲೆ ವೆಕೇಶನ್ ಹೋಗುತ್ತೆ 12 ವರ್ಷ ಆಯ್ತು.
Yes, now we will hear what is this.
That is execution petition we have filed it, my lord. Against the decree, the JDR had filed in RFA. RFA is also came to dismiss. There is no grounds for the JDR also. Execution petition ಗೆ ಡೇಟ್ ಹೋಗ್ತಾನೆ ಇದೆ 4 ಸತಿ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದೀವಿ. Yes, argument other side also argued. Both we said pass orders. Order ಮಾಡ್ತಾ ಇಲ್ಲ.
Yeah, execution main petition.
ಅಲ್ಲಿ execution main petition ಮೇಲೆ.
Where is that order sheet?
Order sheet complete ಹಾಕಿದೆ ಸರ್.
Source it was.
Yes. Order sheet copy I filed it now. From annexure of page number
Degree order 6
18 in the page 20 and page number 18 in the order sheet copy, sir.
For argument fully on one side, for arguments on side by the judgment letter by 2924.
ಎರಡು ಮೂರು ಸತಿ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೊಟ್ವಿ. ಆಮೇಲೆ ಸೈಟೇಷನ್ಸ್ ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೈಟೇಷನ್ ಕೊಟ್ಟೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೇಸ್ EP should be disposed of within 6 months.
Yes, Mr.
Even we have filed a memo stating that we have no objections to pass orders here.
No, both of them.
Yes, your lordship, we both have submitted.
Then that.
Yesterday we have filed a memo stating that so and so petition is being filed before this honorable court for so and so reasons. ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಒಂದು ಮೆಮೋನು ಕೂಡ ಹಾಕಿ WP ನಂಬರ್ ಕೋಟ್
ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ.
We have heard ಅಂತ ತಗೊಂಡು ಫರ್ದರ್ ಹಿಯರಿಂಗ್.
ಯಾವತ್ತು next date?
23/4 your lordship.
ಅಗೇನಾತ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹೋಗ್ಬಿಡುತ್ತೆ ಮತ್ತೆ.
Yes, ತಗೊಳ್ಳಿ.
Let there be direction to pass order within before 20th ಆ ತರ ರೀತಿಯಲ್ಲಿ ಕೊಟ್ಟರೆ. ಯಾಕಂದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ನಲ್ಲಿ ಏನಿಲ್ಲ ಸರ್, ಡಿಗ್ರಿ ದೇ ಚಾಲೆಂಜಿಂಗ್ ಬಿಫೋರ್ RF ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ obey the orders of the court.
No, now that after hearing, now you are seeking for an execution of what is that order? Which is the degree?
Execution of
Decree we have mentioned that annexure B ಮೇಲೆ annexure B amended complaint ಅಂತ ಹಾಕಿದೀವಿ ಸರ್. ಎಕ್ಸಿಕ್ಯೂಷನ್
That annexure B.
Page number 71 ನಲ್ಲಿ that is EP what we have filed it. Directly Judicial Holymouse Police Station to assist the decree holder to prevent any person
Degree
from.
ಏನಾಗಿದೆ ರೀ?
Sami?
ಏನ್ degree execution?
Decree injunction suit sir.
Injunction suit.
Very injunction. We are all owners. The owner sold to sites to us. After 10 years again say sells the site to somebody else.
Yes.
At that point of time we filed injunction suit. A batch of petitions. 8 petitions are there.
This petition is filed by
The decree holders.
Yes, in this writ petition, petitioner sought directing the petitioner is the degree holder, seeking direction to the trial court to dispose of that execution petition. ಎಷ್ಟಿದಾವೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್?
ನಮ್ದು 8 ಇದೆ ಸರ್.
ಎಕ್ಸಿಕ್ಯೂಷನ್
5 ಇದೆ ಸರ್. R ಮೆನ್ಷನ್ ಆಗಿದೆ.
ಪಿಟಿಷನ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಆ ನಂಬರ್ ಹಾಕೊಳ್ಳಿ.
ಆ ನಂಬರ್ ಕೊಡ್ತೀನಿ ಸರ್. ಲಿಸ್ಟ್ ಆಫ್ ಕೇಸ್ ಕೊಡ್ತೀನಿ ಸರ್.
In view of that prayer, service of notice to unserved respondent is dispensed. Plaintiff has filed a suit for bare injunction. Suit was decreed when re?
Suit was decreed on 28/8/2010.
28,
8/2010.
28/8/2010.
ಆಮೇಲೆ RFA ಹಾಕಿದ್ರು, RFA ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. Then we filed execution.
10/2010, being agreed by the same. The defendant has filed regular first appeal
Regular first.
ಅಥವಾ RFA, High Court ಈಗ
RFA.
has filed a regular
RFA.
first appeal before this court in RFA number.
ಅದು details ಇಲ್ಲ ಸಂಗೀತ.
Details.
I'll give the RFA number, I'll give the details.
Para number 7 ಅಲ್ಲಿ ಇದೆ ಸರ್. 1807 of 2010, 1808 of 2000.
1807 and 1808 ಎರಡೇ ಹಾಕಿದ್ರು, ಮಿಕ್ಕಿದ ಯಾವ್ದು ಹಾಕಲಿಲ್ಲ ಅವರು.
In OS number, para 4 ಅಲ್ಲಿ petition ಅಲ್ಲಿ OS number 6 ಇದಾವೆ, OS number ಹಾಕಿ. Challenging by filing an RFA before this court in RFA number
1807 of
2010 to 1808 of 2010. The same came to be dismissed. Thereafter, the petitioner degree holder has filed an execution petition in 2310 of 2013. Even from 2013, one or the other reason, the matter is urgent even after conclusion of the arguments of both the parties. The matter was urgent from one or the other reason for further arguments. No final order has been passed. No order has been passed in that execution petition. Hence, the petitioner sought for early disposal of that execution petition. Counsel appearing for respondent number 2, 3, 4, 5 also submits that argument of both the sides has been concluded. No order has been passed. In view of the above, without expressing any opinion on the merit of the case, the trial court is directed to dispose of that, to pass to dispose of that execution petition on or before end of April 2025.
Before vacation.
End of April or before vacation?
ಅದೇ before vacation.
Serial number 47, Balraj MUV for petitioner H. Manjunath.
For the petitioners, Lord, we have served the copies to all the respondents. Who are appearing before the trial court, my lord.
You are appearing all respondents?
No, madam. Only for the plaintiff, the defendant.
You are appearing
For the defendant number 1 and 2.
1 and 2.
Yes.
He is the plaintiff. You are the contesting.
They are the contesting.
Yes.
My lord, the plaintiffs, it's a plaintiff's petition. The plaintiffs have filed a suit for permanent injunction before the trial court, wherein they have filed an application for amendment of plaintiff. Taking the consideration of the subsequent events which has been happened after the filing of the suit. Suit for permanent injunction, my lord. Restraining the defendants from interfering peaceful possession.
When the application has been filed, what was the stage?
My lord, before the commencement of trial, that application is came to be filed, and we have sought for an amendment saying that since there is a cloud with respect to the title of the property, and since we have filed the suit, the respondents are the caveators before the trial court, my lord. After service of this, kindly see the order sheet that is in page number.
Yes, you read that order. What is the reason? Reasoning.
Not the page number 136, please, my lord.
Yes.
In 136, please, my lord. Initially, we filed a suit. Since they are the caveators before the trial court.
Impugn order ಎಲ್ಲಿದೆ ಓದಿ.
Impugned order, the trial court has taken a view that since due diligence, we have not filed the amendment of plaint before trial.
Which is that? Annexure A.
Annexure A, please.
Read.
Annexed,
Para 12.
para 12. sir. Apart from above in the plain, they are contended that they are the owners of the in possession and enjoyment of the suitable property and defendants are interfering. Therefore, based on the cause of action for interference, this suit for permanent injunction was filed. The proposed amendment para 13AB stating that on 26/12/2022, the defendants have demolished the structure of the suitable property, forcibly taken possession and police complaint was filed. Whereas the suit was filed on 11/11/2023. That is not 11/11, my lord, that is 11/1/2023. Wrongly it has been mentioned.
Yes.
The proposed para 13A facts were held before the filing of the suit, which were within the knowledge of the plaintiffs. As on the date of the said suit, the relief of declaration and possession was available but not sought. If thus the proposed amendment is allowed, which are inconsistent and contrary to the existence of blind pleadings and the nature of the suit would change.
That is what the purpose of Article 6 Rule 17 is to avoid multiplicity as a proceedings. ಇಲ್ಲಾಂದ್ರೆ ಅವ್ರು ಇನ್ನೊಂದು suit ಹಾಕ್ಬೇಕಷ್ಟೇ.
ಅಷ್ಟೇ.
That way, kindly consider the findings. Only after the framing of issues, the application has been made. And even according to the plaintiff, the incident taken place before filing of the suit. And according to the plaintiff, my lord, as on the date of the filing of suit on 11th January 2023, he is in physical possession of the property. Now he has come up with the amendment application saying that he was dispossessed long back.
Now that entire suit is converted as suit for declaration and possession.
Yes, recovery of possession.
Yes, my lord,
has
he
been
cannot. My lord.
ಏನಂದ್ರೆ ಇನ್ನೊಂದು ಸೂಟ್ ಹಾಕಿ ನಿಮಗೆ ಮತ್ತೆ ಪ್ರೋಸೆಸ್ ಹೋಗಿ ಅದನ್ನೆಲ್ಲ ಅವಾಯ್ಡ್ ಮಾಡಬಹುದು ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದ ಆರ್ಟಿಕಲ್ 6 ರೂಲ್ 17 unless it is prejudiced. Even if suit is barred, Supreme Court said amendment allow, frame the issue, it will be decided in that issue, but unless it is prejudice to you,
My lord, in this present case,
to avoid that multiplicity.
my
Otherwise
lord, here the pleadings.
ಅವರಿಗೆ ಇನ್ನೊಂದು ಸೂಟ್ ಹಾಕಕ್ಕೆ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ ಮಾಡಂಗೆ ಇಲ್ಲ ಅಂದ್ರೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಕೆನಾಟ್ ಬಿ ಅಲೋ. Here he has to file another suit.
Yes, my lord.
Then notice has to go. Therefore, to avoid that, Order 6 Rule 17 ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ.
My lord, here he cannot maintain the divergent pleadings in the plaint. In one paragraph, he is saying that as on the date of the suit, he is in physical possession of the property.
Now that suit itself is for a possession. Then that pleading cannot be, that has to be ignored. Now he can't say that I am in the possession. He has to say that you are in the possession. He has to prove that he is the owner. Then declaration and possession will become.
My lord, as on the date of filing of the suit, he has taken the chance, even though he was not in possession of the property.
ಮಾಡಿದ್ದಾರೆ ನೋಡೋಣ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಂತ. But again, that issue is that he has to file another suit.
That they also made the memo before the trial court seeking for filing this fresh suit.
ಅದನ್ನೇ ಮಾಡಿ
ಇಲ್ಲ sir.
ಹಾಕಿದ್ದಾರೆ, I will fail place.
Memo
Judgment.
ಸಿನ್ಸ್ ನಾಳೆಗೆ ಶಾರ್ಟ್ ಡೇಟ್ ಇದೆ, ಫೈನಲಿ ನೀವು ಮಾಡಬೇಕು ಅಂತೇಳಿ ಲಿಸ್ಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಹೈಕೋರ್ಟ್ ಮುಂದೆ ಅಂದ್ರೆ ಇಲ್ಲ ಇಲ್ಲಿ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ ಇಲ್ಲಿ
withdraw with liberty, file a fresh suit ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ.
ಇಲ್ಲಿ kindly see, even passing the expert status quo order after hearing both sides, my lord, the trial court has come to the conclusion that the plaintiff has to file a suit for declaration and recovery of possession. Even in the issues framed by the trial court, my lord, kindly see, the issue itself is.
Now he is also no objection. You can plead properly and file
No, my lord, the facts are one and the same. There is no difference in the facts of the case and title or the property. My only thing is we have sought declaration relief, that's all, and recovery of possession instead of permanent injunction, my lord, to avoid the multiplicity of proceedings, my lord. It has.
Still while
Illa sir.
Stay of further proceedings in verse number
336 of 23.
336
Of 2023.
Pending on the file of 6th Additional City Civil and Session Judge Bangalore till next date of hearing. In the meantime, other defendant also served. Yes.
Sir, much.
Serial number 48, Asha Rani V for petitioner, Narasimha Murthy.
Yes.
This is the suit for partition, my lord.
Yes.
Directly I'll go to page number 220, my lord.
What is this suit? Suit for?
Suit for partition, my lord.
Who are you?
I'm the plaintiff in suit.
Plaintiff. Yes. What is that order you are challenging?
Annexure A.
Impleading application file ಮಾಡಿದ್ರು, respondent number 12 and 13. ಅದು order ಆಗಿದೆ. That order I have challenged.
What is that? Who are that impleading applicants?
Impleading applicants ಅವರು ಕೂಡ ನಮ್ಮ ಮಾವನ್ನ
Family members.
ಅಣ್ಣನ ಮಕ್ಕಳು ಅವರು.
They are not claiming purchaser. They are the family member.
Yes, my lord.
Where is the genealogical tree?
Genealogical tree I have not produced yet.
That
Page
you
66.
I'll produce mine.
Page
Out of
66.
that, where is that possession and all?
I'll
Whether
produce
they are
it.
entitled for the partition and all, then we can.
ಅಲ್ಲ
They're
ಇದ್ರಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಅವ್ರನ್ನ ಬಿಟ್ಟು ನಾವು ಫೈಲ್ ಮಾಡಿರುವಂತದ್ದಲ್ಲ. ಇದ್ರಲ್ಲಿ ಇವಾಗ ನಾವು ದೇ ಹ್ಯಾವ್ ಕಮ್ ಅಪ್ ವಿತ್ ದಿ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಮೈ ಲಾರ್ಡ್. ಬಟ್ ಇನ್ 2016 ನಮ್ ಚಿಕ್ಕಪ್ಪ ಆಗಿರೋದ್ರಿಂದ ಚಂದ್ರಯ್ಯಪ್ಪ ನಮ್ಮ ಮಾವ ಅವ್ರ ಹೆಸರಿಗೆ ನಮ್ ಚಿಕ್ಕಪ್ಪ ಆಗಿರೋದ್ರಿಂದ ನಮ್ಗೆ ಯಾವುದೇ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಅವ್ರ ಹೆಸರಿಗೆ ಖಾತೆ ಮಾಡ್ಕೊಡೋದಕ್ಕೆ ಅಂತ ದೇ ಹ್ಯಾವ್ ಗಿವನ್ NOC.
No,
Later on in
ಅವ್ರನ್ನ
2007
party ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ನೀವು ಕ್ಲೈಮ್ ಮಾಡಿ ಅವ್ರು ಗಿವ್ ಅಪ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಅಲ್ಲ
ಅಲ್ಲ ಅವ್ರಿಗೆ
another thing my lord, one more thing what happened in 2017, that is annexure my lord.
No, now you are admitting that they are also entitled for the share in that property.
No, they have
No.
executed and registered the release deed also.
ಅದನ್ನ ನೀವು ಕೇಸ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕು. ಅವರಿಗೆ ನಮ್ ಫ್ಯಾಮಿಲಿ ಯಾರ್ಯಾರ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಎಂಟೈಟಲ್ ಫಾರ್ ದ ಶೇರ್ ದೇ ಶುಡ್ ಬಿ ಅ ಪಾರ್ಟಿ. ಆಲ್ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಶುಡ್ ಬಿ ಇನ್ಕ್ಲೂಡೆಡ್. Then you have to be argued saying that they have given up their right. Therefore, this share has to be allotted to me. That is what that. ಅವ್ರನ್ನ ಹೊರಗ್ ಬಿಟ್ಬಿಟ್ಟು ನೀವು ಹೇಳಿದ್ರೆ ಸತ್ಯ ಹೌದಲ್ಲ ಅಂತ who has to say?
When they executed and registered
Then you
release deed in the
yes,
year
you
2017
produce
my
that
lord.
genealogical. Yes,
That is the finding of the trial court.
yes, sir.
Date may be fixed your honor.
Yes, it will come after vacation. Yes,
ಅಲ್ಲ before vacation if possible.
before vacation andre this is the final order. If you say I will pass this, yes, yes, after vacation, yes.
Cell number 49, Venkatesh S. Arabatti for petitioner, Deepak B.
Yes.
For rejoinder, that has been rejected. Against that, we are before your lordship.
Yes.
Can I persuade your lordship just look at my lord the impugned order at page 70. Suit my lord for declaration, partition, declaration, etc. my lord.
Yes.
What has happened is there was an association of persons.
Hmm.
Then, my lord, my lord, we had purchased properties, my lord, in the name of all the partners of that association of persons. My own brother-in-law, my lord, he started saying, this is my own property.
Yes.
So, my lord, we had, and he entered into an agreement with sale.
Yes.
In the meanwhile, my lord, we also filed an application for amendment.
Yes.
Sorry, replication. That, my lord, has been rejected.
Yes.
If your lordship come to my lord page 13, my application, my lord, for
1-3.
yes, ma'am.
ನಮ್ದೊಂದು ಕೇಸ್ ಮಾಡಿಸ್ಕೊಟ್ಟಿದ್ದೀವಿ ಸರಿ.
Yes.
At my lord 15,
Yes.
permit the plaintiff to file a rejoinder in the above suit.
Permit the plaintiff.
And my lord, I have given reasons.
ಕಾಮನ್ ಕೌನ್ಸಿಲಿಂಗ್ ಕಾಮನ್ ಕೌನ್ಸಿಲಿಂಗ್ ಮಾಡಬೇಕು.
ಸ್ಟೇ ಆಲ್ರೆಡಿ ಆಗಿದೆಯಲ್ಲ ಸರ್. ಐ ಥಿಂಕ್ ಡಿಸ್ಪೋಸಲ್ ಅನ್ಸುತ್ತೆ. ಇಂಟರ್ಪ್ರೇಯರ್ ಇದೆ ಸರ್. ಟು ಸ್ಟೇ ದ ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
ಅದು ಅವ್ರು ಇದು ಮಾಡಕ್ ಬರಲ್ಲ ಅದು ಏನೋ ಅವ್ರು ನೀವು ಪರ್ಮಿಷನ್ ಕೊಡ್ದಾನೆ ಇದು ಎಂಟ್ರಿ ಆಗಂಗಿಲ್ಲ ಅಂತ ಏನೋ ಒಂದು ಮಾಡಿದ್ರಲ್ಲ.
70, my lord, is the order. 70.
70.
Yes, ma'am.
Yes.
Can I persuade your lordship to come to my lord?
Yes.
Paragraph, my lord, 10 at page 76. What the learned judge says is, I should file, my lord, amendment application, not a replication. 76, my lord.
76, yes.
Insofar as hardship and injury is concerned, it is pertinent to note that if the application is rejected, plaintiff will have the option of bringing the fact pleaded in the rejoinder by way of amendment. Whereas if the same is allowed, defendants lose a right to file additional written statement. Additional written statement, nobody can argue.
Is it permissible to file in a rejoinder?
Rejoinder, my lord, I can always, with the leave of the court, my lord, I can always seek, my lord. Can I persuade the lordship, my lord?
Which is the provision?
Order
Otherwise that filing in a amendment, nobody will file an amendment. Everybody will file in a rejoinder to.
Can I persuade your lordship? Just look at, my lord, order 8, rule 9 for a minute. With the leave of the court, my lord, I can always file a rejoinder, my lord.
Yes.
My lord, order 8, rule 9,
Yes.
CPC inventory. What do you? No pleading, Lord,
Yes.
9. No pleading subsequent to the written statement of a defendant other than by way of a defense to set off or a counterclaim shall be presented except by leave of the court and upon such term as the court thinks fit. But the court may at any time require a written statement or additional written statement from any other parties and fix a time of not later than 30 days for presenting the same.
No pleading subsequent to the written statement of the defendant.
Correct. That is what I sought. What, my lord, the other side is saying is, these are new facts, so I will not have a right of filing anything more. That, my lord, the court can always, my lord.
Filing an objection can be permitted. First thing is that, can it be permitted because that order 6 root 17 is there? Amendment of the pleadings. This is not an amendment again.
This is, my lord, additional.
Additional is an amendment. It should,
One
two will not go together, I think. Any judgment you have on that?
One judgment ತೋರಿಸ್ತೀನಿ ಆಮೇಲೆ of course it's my lord even.
That too in that commercial suits. Yes.
ಅಲ್ಲ ಇದು order 8 rule 9 my lord is not my lord deleted my lord as far as commercial suit is concerned. Please come to my lord paragraph 8. Sorry, would you also come to my lord page 2096? 2096 my lord.
Yes.
That is
Yes.
last but one page.
Yes.
Order 8 rule 9 would deal with subsequent pleading which is filed subsequent to the filing of the written statement of a defendant. It is not a case where the rejoinder is being filed to claim a set off or a counterclaim. It is in the nature of replication filed to the written statement which is always permissible under law. Code of civil procedure, far from pinning down the plaintiff to the plaintiff and the defendant to the written statement, does contemplate further pleading. It is permissible to the plaintiff petitioner to file a replication to add to his pleas already made in the plaint. Only condition is leave of the court. It is only meant for denying or clarifying the facts stated in the written statement. Fresh cause of action or fresh case is not brought about by
No, only additional pleading.
How do?
It should not be that different. Whether it is an additional pleading or something else has been added.
This is, my lord, more facts are added.
Now that subject to what he says. We have to. Yes,
Avru,
I am for the defendant number 4, respondent number 4. I
They
am
are
sailing with the
virtually
plaintiff in the
sailing
suit.
Then who is the contesting?
Lords, I pay for respondent number 2, my lords.
Yes.
Lords, I request for a short accommodation, lords. Seniors,
Yes. When do you want?
can you have it next week, my lords?
Yes. At the request of respondent number 2, read this matter next week.
Oblige me.
Great.
my lord, next week ಅಲ್ಲಿ 8th ಆಗ್ಬೋದಾ? 9th, my lord, that's the only day. Then, my lord, we have holidays. 9th, I have some difficulty.
16th?
15th, 16th.
Yes.
15th ಆಗ್ಬೋದು.
Yes, 16th.
Great.
Serial number 50, Kashyap and Nayak for petitioner. Yashu Mishra.
For the respondent.
Yes.
I seek for a short passover, my lords.
Yes. Affidavit to be filed by that petitioner for vacating. Yes, Mr.
My lord, what has happened? They have,
Passover. They want Passover.
very well.
Yes, Passover.
Great.
Serial number 51.
Or any date. Passover may not be reached. Today we have-
There is, they have committed a contempt. I have filed an affidavit.
Yes.
What they have done is, my lord, the subject matter of this writ petition is an immovable property, attachment of an immovable property which was stayed. And the sale also has been subsequently stayed by my lords,
Yes.
by a recent order. Now, what they did was, at some point of time in October, they said, we will sell the machinery which has been attached. That is not a subject matter of the writ petition. So I said, if they are offering a good price before the court, I have no.
No, any.
ಇವಾಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ, they have sold that property. ಒಂದು affidavit file ಮಾಡಿದ್ದಾರೆ. They don't even state for how much they are selling. And they have sold, they have taken away the attached property, attached by the trial court in the execution.
Yes.
Interpreting the order of this court as though they have been permitted to sell.
Yes. Yes.
My lords, I am seeking a passover only to deposit that DD before this honorable court. My intention, my lords, was to sell the equipment, give the money to the
Now, where is the
respondent.
DD?
My lords, it's on its way. Petitioner is getting it. I just need a short passover. I'll give it to the
Money is
respondent.
coming, wait.
Allah, but money is coming. I don't know how much money. My lord, attached property, if they sell it without notice to the court, without notice to
No,
me.
contempt, if it is committed, it's always contempt. We are not disposing of that. Whatever that money is coming, let it be
Very,
deposited.
very.
Yes.
Cell number 51, Shankar Narayan Bhatt,
For petitioner in this matter.
SV Prakash,
Yes.
Lord,
Non-furnishing of PF issue notice to R6. Third time, who is R6?
my lord, respond number 6 intentionally avoid the court notice, my lord.
No,
For that
he said-
reason, my lord, I filed an application, my lord, or file rule 20, my lord, on 11/2/2025
Hmm.
for substitute service, my lord.
We have filed a paper publication.
Yes, my lord.
What has happened to that application?
I'll put up ಆಗಿಲ್ಲ ಸ್ವಾಮಿ ಅದು.
Put a application ಇದೆ. We'll pass an order. Please take. ಇದೆ ನೋಡ್ರಿ.
ಹೌದು 18/2/2025 my lord, I have filed application.
Notice issued to the to 2 times only. Yes, only 2 times. I will permit you to take public.
Please.
Yes.
Kannada Prabha daily news.
1 of 2025. Filed seeking leave of this court to take out notice to the defendant number. Respondent ಎಷ್ಟು ಇಲ್ಲಿ
6 ಸ್ವಾಮಿ.
Defendant ಅಂತ ಹಾಕಿದಿರಲ್ಲ. Take out notice to respondent number 6 by through paper publication in Kannada Prabha daily newspaper. For the reason stated in that accompanying affidavit, petitioner is permitted to take out notice to respondent number 6. Respondent ಮಾಡಿ ಅದನ್ನ. Respondent number 6 by way of paper publication in Kannada Prabha daily newspaper on or before
2nd May,
hearing date.
2nd May.
Yes.
ಮತ್ತು
Cell number 52, Ravish party in person,
Yes, Mr. Ravish.
14% petition.
Who is that respondent number 1 to 3?
1 to 3,
Service, you have to pay the process for others.
already I have paid, sir.
Notice is not, ಏನಾಯ್ತು notice?
no such person ಅಂತ.
No such.
ಅಲ್ರಿ, process second time person.
ಕಟ್ಟಿದ್ದೀನಿ.
Second time, first time ಎರಡು no.
Second time, no such person. Who is no such person?
Respondent,
Party?
respondent number 1 is in. I have also served in open court, in trial court.
No, you are a plaintiff or in a.
In trial
defendant.
court in a defendant file.
You are the defendant.
Defendant.
Now, ಅವ್ರು ಯಾರು defendant respondent number 1 ಯಾರು plaintiff?
Plaintiff ಅಲ್ಲಿ, trial court ಅಲ್ಲಿ.
You are appearing for whom?
2 to 5 my lord.
2 to?
2 to 5.
No, you are not contesting. He is the contesting sir. You have to serve him.
No, they have filed the ವಕಾಲತ್.
ಇವರು ಅವ್ರಿಗೆ ಅಪಿಯರ್ ಆಗಲ್ರಿ. Plaintiff is the contesting in your case.
Yeah.
ಅವ್ರಿಗೇನು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೊಳ್ಳಿ ಇಲ್ಲಾಂದ್ರೆ ಸರ್ವ್ ಅಂಡ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್. ವಾಟ್ ಯು ವಾಂಟ್?
ಅವ್ರು ಅಪಿಯರೇ ಆಗ್ತಾ ಇಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗ್ತಾ ಇಲ್ಲ, ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೊಳ್ಳಿ.
ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ, ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್. Yes.
ಶಾರ್ಟ್ ಡೇಟ್ ಹಾಕಿ ಮಾಡಿ.
Yes, at the request, leave this matter next week. Yes.
Interim order action.
Interim order granted earlier is extended till next date of the.
53, Arun Ashok Gadak,
Lord, it's an FTP proceedings which I am challenging. There is a council submission, Lord, with respect to 5 and 6.
Office objection 5.
Yes,
ಏನದು?
Lord.
Non-compliance of office objection, not below cost title.
They are asking for FDP amended petition, Lord.
Of the amendment to be furnished to that verifying the cost title.
Yes, Lord. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, if Lord takes the impugned order, annexure A 15, ಅದರಲ್ಲಿ ಚಿಕ್ಕ ಕರಿಯಪ್ಪ ಅಂತ ಏನಿದ್ದಾರೆ, ಅವರು subsequent to order passed by the court has been passed away. So there cannot be a amended FTP.
Yes. Yes.
My Lord, if my Lord takes the page number 15, the
Yes,
petitioner
what is
Chikka
that?
Kariyappa is passed away after the order passed by the court.
ಆಯ್ತು, ನೋಟಿಸ್ ಆಗಿಲ್ವಾ ಇದ್ರಲ್ಲಿ ಇನ್ನು?
ಇಲ್ಲ ಸ್ವಾಮಿ, there is a misrepresentation which is being made.
What is
I will
this
just show it to you. My Lord, this is an FDP proceedings in a partition suit. My Lord, during the proceedings of the case, Again, a commissioner was appointing a tahsildar as a commissioner of the court. And also one memo filed by the petitioner is taken on record as in gospel truth, misrepresenting the court that the item number, kindly impugned order page number 21 may be taken, my lord. My lord, if my lords take the last line, the petitioner is hereby dismissed in respect of the petition scheduled property, item number 1, 2, 4 and 7. My lord, kindly, idರಲ್ಲಿ ಏನಾಗಿದೆ 1, 2, 4 and 7 are very much available for partition. But court, considering the report and as well as memo filed by the petitioner Chikka Kariyappa, has dismissed the partition with respect to this, my lord. With respect to misrepresentation, I will show, my lord, kindly, page number 18, paragraph number 10.
1822 read with CPC hereby partly allowed the partitions scheduled item 3 to 6. Commissioner report. Yes, where is that preliminary degree?
Preliminary decree, my lord, is at page number 26, annexure C.
ಅದರಲ್ಲಿ ಎಷ್ಟಿದಾವೆ ಪ್ರಾಪರ್ಟಿ?
ಅದರಲ್ಲಿ 7 ಇದೆ ಸ್ವಾಮಿ.
7.
ಹೌದು ಸ್ವಾಮಿ. I have also produced a petition at page number 24. My lords can see total 7 items.
Who has filed this application?
The very same plaintiff has filed a FDP petition. My lord, ಇದರಲ್ಲಿ kindly page number 18, paragraph number 10. How they have misrepresented ಅನ್ನೋದನ್ನ ನಾನು ತೋರಿಸ್ಕೊಡ್ತೇನೆ. My lord, if my lords got it, I will read it, my lord. It is the fact that the court commissioner appointed as per the order dated so and so effect the division with respect to this. Notice. My lord, ಇಲ್ಲ ಇದರಲ್ಲಿ I want to file a memo. ಅದನ್ನ ಚಿಕ್ಕ ಕರಿಯಪ್ಪನೇ ಸೇಲ್ ಮಾಡ್ತಾನೆ.
ಆಯ್ತು, ನೋಟಿಸ್ ತಗೊಳ್ಳಿ. 4 ವರ್ಷ ಆಗಿದೆ.
There also I need not to alienate, my lord. Encumbrance ಯಾವುದು ಕ್ರಿಯೇಟ್ ಆಗೋದು ಬೇಡ ಅಂತ. Kindly, my lord, 5 minutes, my lord, I will convince your lordship. They have misrepresented.
Order has passed in 2020.
Please, my lord.
4 years.
My lord, they are all villagers. And my lord, secondly,
Mister, it is a final degree proceedings. I think it may be completed now.
my lord, there is an extreme urgency because, my lord, they have misrepresented the court. ಅವರೇ ಚಿಕ್ಕ ಕರಿಯಪ್ಪನೇ ಪ್ರಾಪರ್ಟಿನ ಸೇಲ್ ಮಾಡ್ತಾರೆ. That I have shown it in the this thing, my lord.
Mister, it is a 4 years delay. I will not grant any interim order. If you want to take notice, take notice. If you want to argue, I will consider on merit.
My lord, because ಅವರು 1 to 7 ಗೆ ಪ್ರಾಪರ್ಟಿ ಅವರು ಏಲಿನೇಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ನೋಡ್ತಾ ಇದ್ದಾರೆ. There is a fraud played on the court. That is why, my lord, that's all. My lord, second property, 1 minute. My lord, only one submission.
Yes, will pass.
Only one submission, my lord. I'm sorry.
No, mister, after 4 years, you are coming before the court, you are insisting for an interim order.
Now, my lord, they are trying to alienate, my lord, because I'm trying to protect the property, my lord.
See, after 4 years, you are not explaining as a party, you are coming before the court, then you are seeking for an interim order. I will pass an order on merit. Yes, you argue that. Yes.
My lord, kindly, page number 18 may be looked into, my lord.
Yes.
Paragraph number 10. A commissioner was appointed. I will read, my lord.
Yes.
It is the fact that the court commissioner is appointed as on so order dated so and so affect the partition in respect of the schedule item.
You are a party there.
Yes, my lord.
Then what are you doing for an
was not considered.
ಆಯ್ತ್ರಿ, ಆರ್ಡರ್ ಆಗಿದ್ದು ಯಾವಾಗಲೂ ರೀ?
My lord, it's ordered in 2020. I agree, my lord. Now they are trying to alienate it, my lord. That is the reason.
Then you have to wait till that alienation has to be taken place, or you are agreed by that order?
No, my lord, I'm trying to protect the property ashte swami.
To take hands. Yes.
My lord, they have played a fraud. Adikke nanu kelta.
Yes, we'll see that. Yes.
Pastor matter, serial number 27, Gopala BV.
Yes. Yes, mister, what is?
Yes, my lord, respondent number 2 to 6 have approached the civil court and filed a petition, civil miscellaneous petition, under 13th class 3 of birth registration of birth and death act 1969, my lord, under section 13 class 3, my lord. After the publications, my lord, we are the original legal heirs of the one.
Where is that order?
Order, my lord, annexure.
Now you are challenged, you have filed an application for impleading.
Yes, my lord. Annexure D, my lord.
Annexure?
Annexure D, my lord. Page number 26.
Yes.
The only contention of the proposed respondent is that they are the actual legal heirs of deceased person. In support of their contention, they have produced genealogical tree and Aadhaar cards. On perusal of the genealogy tree which has filed by the proposed respondent, it appears that Guruvaya is the third son of Chalkaraya, and his mother name is Chaudamma, wife name is Ramakka. The father name of the said Guruvaya and the petition schedule Guruvaya looks like similar, but not same. Further, the mother and wife
Now, who has
name
filed this petition?
by the rival claimant of the Guruvaya's matter. Guruvaya is, we are claiming that he is
No,
our legal.
you come to that annexure A, page 17.
Yes, madam.
This is the petition.
Yes, madam.
Murthy.
Yes, they have filed, the,
And now you have filed an impleading to you.
in this petition, yes.
What is that relationship between that petitioner and your client?
Well, they are the grandfather of our client, madam.
Yes. Now what is their?
And also there are several litigations are pending, and also one petition is in the writ appeal, the status quo was granted. They are all the parties to that.
Now they are seeking ನ್ಯಾಯಾಲಯ ಪ್ರಾರ್ಥಿಸಿಕೊಳ್ಳಲು 1ರಿಂದ 3ನೇ ಅರ್ಜಿದಾರರು ದೊಡ್ಡ ತಾತ ಮತ್ತು ಅರ್ಜಿದಾರ 4, 5ನೇ ಅವರ ದೊಡ್ಡ ಗುರುವಯ್ಯ ಚಿಕ್ಕವರು 87ರಂದು ಅರ್ಜಿದಾರ ಸ್ವಂತ ಮನೆ ಇರುವ ನಗರ ಚಳಿಕೆರೆ ಮರಣ ಹೊಂದಿದ್ದಾರೆಂದು ನೋಂದಾಯಿಸಿಕೊಳ್ಳುವಂತೆ. They are seeking for an death certificate.
Death certificate, madam. Under 13 class 3, madam.
Yes.
They
issue notice, stay of 9 of 20, 1139 of 2024, pending in the file of which court this is?
Civil judge, principal civil judge, junior division and JMFP Chalkere.
Till next date of hearing.
Still number 28, Nagamala.
Number 8 to 10 and 26
to be clarified, the cast title trial court who are brought before the trial court. What is this?
They are not a necessary party in that.
Yes.
In the trial court matter, the appellant is the petitioner before this honorable court. The appellant has filed the suit for declaration and the injunction. The suit was dismissed. Subsequently, my lord, the petitioner has preferred an appeal before the appellate court. In the meantime, my lord, the respondent number 2 has alienated the property in favor of proposed respondent. Suit for declaration and injunction, my lord.
That is decreed.
Dismissed, my lord.
Dismissed. You have filed an appeal.
Please, my lord. During the pendency of the appeal, my lord, the respondent number 2 has alienated the property.
During the pendency of that suit, you have any injunction order?
Injunction, there is no injunction.
Then?
In respect of alienation is concerned, my lord, I have filed an application for impleading of the proposed respondent number 21.
A person who has purchased.
The trial court has, appellate court has rejected page number 24, my lord. Page number 24, last line.
20?
Last 24, my lord.
Yes.
In the instant case, the suit is based on the declaration and injunction. At this stage, it appears that the respondent number 2 is adequately participating in the suit. Since the purchaser falls under section 52 of Transfer of Property Act, it follows that the proposed respondent number 2 is not necessary.
No, it's a bare suit for injunction.
No, my lord. Declaration and injunction.
Declaration and
Please,
injunction. Yes. You take notice.
I will take notice, my lord. In the meanwhile, the matter is posted for the final argument.
Final argument.
Yes, please, my lord. The trial court is very hurry to dispose the matter. And there is if the stay of further proceedings is not granted, there is a possibility of multiplicity of proceedings. The proposed respondent also is trying to alienate the property.
No, alienation you can file. See, now you are sued for declaration.
Please, ma'am.
Even if he is not a party, how will you affect your right?
Because if goes on selling the property, my lord.
No, therefore you should have asked earlier not to create third party interest stay. Even then 52 will be hit.
Yes, please, madam.
Suppose if you are impleading him here,
please,
will sell. Everybody you can't go on impleading. Therefore, section 52 Transfer of Properties Act.
List pendency is applicable.
No,
yes,
here he cannot come and defend anything. ಡಿಕ್ಲರೇಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ಅವ್ರು ಯಾಕಂದ್ರೆ ಅವ್ನು ಪರ್ಚೇಸ್ ಮಾಡ್ಕೊಂಡಿರ್ತಾನೆ ಅವನೇನು ಹೇಳೋದಿಲ್ಲ.
If he
ಇಸ್ ನಾಟ್ ಎ ನೆಸೆಸರಿ.
if he comes in a suit appeal, my lord, then I will file an application, necessary application not to alienate the property. Therefore, he is the necessary party.
No, for that you can't implement, Mr.
Otherwise, my lord, without impleting the proposed respondent number 21, it is not possible to
Two
file.
things. In the appeal itself, he could have taken an injunction order against the defendant. He should not. Suppose if there is no order, if there is an alienation, therefore that 52 said it will be hit by that section 52.
52, my lord, then multiplicity of proceedings will be.
No, for that you can't
Your lordship-
implement them.
Your lordship, your lordship, whenever that,
You want to stay your own appeal.
please, my lord.
Yes, after that appearance again we will dismiss you will waste your time. That's all. Third, stay of further proceedings in area number 80 of 2018 passed by second edition pending in before district and session judge Davangere. After service, please, if you dismiss this petition, then your appeal simply pending from last.
In the meanwhile, I will file application, necessary application.
Yes. Yes, submission is accepted.
Public.
Submission is over.
Cell number 29, MS Nagaraja.
Yes, Mr.
Plaintiff, this, Lord, it is the defendant's petition, Lord, agreed by A number 6 and 7. My Lord, the first respondent who filed a suit for partition. These petitioners are only the contesting defendants, my Lord, contending that this is self-acquired properties and all. My Lord, he has examined and later, my Lord, he is giving one of the GPA in favor of the respondent number 10. She is also one of the party to the suit, my lord. We are opposing that. That cannot be maintainable because that she is a party, cannot be given to the, she cannot be give evidence on behalf of the plaintiff. She is a defendant in that. My lord, later, my lord, after we are opposing, she filed she is placed expert, she filed an application. She is a GPA holder, she come on record as a plaintiff, appearing as a plaintiff. She filed an application set aside the expert order against the defendant and also sought for a transposing herself as a plaintiff to the suit. That we are opposing because that, my lord, the reason is that, my lord,
You are also defendant.
I am also defendant.
She is also defendant. She wants to transpose.
Transpose because she is already GPA holder unless she is withdrawing. The GPA holder, she has to withdraw it.
GPA holder of whom?
Plaintiff.
Now you come to that plaint annexure A.
Yes, my lord.
Who is that applicant seeking for a transpose?
10, my lord. Serial number 10, Bhagya.
Bhagya. She want to transpose as an
yes.
Why that petitioner is
She is plaintiff, my lord. He is unable to conduct the suit.
now the
In the
plaintiff,
GPA.
plaintiff is that Anand.
Ah.
Now he wants to withdraw the suit.
Not, my lord. He is not withdraw the suit. That's what, my lord, 23 rule 1A is coming to play only, my lord. Transpose arises under 23 rule A, my lord. When suit is either he withdraw 23 rule 1A.
Now what is that order of the trial court?
Trial court simply that allow the application in spite of my objections, my lord.
Where is that order?
I read the order.
Where is that application first? for
Application, my lord, at annexure D and E, my lord. Annexure E, my lord, please.
transport? Annexure E.
Annexure E, my lord.
Reasons
Page
stated by the
48.
Defendant in the above case most respectfully pledge the sum of please to permit that any defendant transpose as an to the prosecution for the interest of justice. Yes.
23 rule 1A. my
No,
lord.
you come to that order 1 rule 10-2.
Yes,
Order 1 rule 10-2.
yes, in page number, my lord. 63, 64, my lord. Reasons assigned. I take your lordship page 63, para 3 of the
Now you will see that order 1 rule 10-2.
1A, my lord, please.
10-2 ಹಾಕಿದ್ದಾರೆ.
10 to 23 rule 1A, that when question will arises for transposing.
First we'll see what is that order 1 10-2. Court may strike out and add the parties. The court may at any stage of the proceedings without application either parties consent. Second number to name any parties to the whether plaintiff or defendant strike out or yes. Section order 23.
1A, my lord, please. When transposition of defendants as a plaintiff may be permitted.
23 1A.
Yes.
Yes.
Where a suit is withdrawn or abandoned by the plaintiff under Rule 1,
As a defendant applies to the transpose.
and a defendant applies to transpose as a plaintiff under Rule 10.
Now, what is the reason given by the trial?
Simply, that's the reason. I oppose that application on the ground, my lord. In phase number 63, my lord, please. Running phase 63, parrot 3.
Yes.
Impugn order. The defendant 12, 3 and 16 petitioner said, my lord, have filed a common objections
Now
wherein
you
they
come to that reason.
reasonings,
Yes.
please, 64, please. Reasonings, my lord, I have gone through the plaint governments. In the plaint governments, plaintiff B.A. Anand stated that the suit properties are joint family property, family properties belongs to Ashwath Narayana Swami. He had 7 children. There was no partition in the joint family. The defendant number shown to his wife, she examined as PW2. There is no conflict interest between the plaintiff and defendant number 10. Because they are the husband and wife, there is no impediment to transpose the defendant number 2 as PW2. Because she has already gave her evidence PW2, being a SPA holder of the plaintiff. Therefore, I answered in property. My lord,
This is
suit for partition.
No, that partition suits, even plaintiff and the defendants are one and the same.
But my lord, the question, my lord, she has no any substantial question against the other defendants. My lord, she has no interest in the property.
No, either way, if the family members, then all the dependents are the plaintiffs are the defendant.
That is not in dispute. But the question
was.
was.
Provision you are applying to that other provisions and that partition suits is a different.
Yes.
Partition
All
suits, I
suits, my
don't
lord.
think there is no
Relating
bar
to
for-
all suits. Here, my lord, she is already GPA holder. We are opposing that she cannot become a GPA holder. They filed an application.
No, that is what that. See, in other suits, transpose only if that plaintiff is given up. For the partition suits, all our defendants are plaintiff or a defendant.
But here, my lord, she is having contending that she has any right, my lord, in the properties against other defendants.
Yes. Will
Then
stay
she
for
is.
further proceedings of the suit, that order will not yes. Stay of further proceedings in OS number 4979 of 2018, pending in the file of 35th Additional City Civil and Session Judge Bangalore till next date of hearing. Yes, office objection is complied.
Serial number 34, Sunil S. Narayan.
Plaintiff's
Yes.
petition. Agreed by the annexure also.
Yes.
Orders on IA number 20, wherein I filed clubbing application to club 2 more suits along with the present suit. My father during his lifetime filed suit for partition, comprehensive partition with respect to claiming 1/4 share against his brothers, children, entire family.
Yes.
Wherein 33 items were as a scheduled property.
Yes.
Thereafter, after his death, petition number 1 and petition number 2 came into record. Thereafter, my sister and my brother's wife, so they were implicated as the defendants to the present suit, which is of year 2016. Thereafter, my sister-in-law, she filed a suit for partition.
Yes.
My sister also filed a suit for partition, wherein 8 and 11 properties, which are part of these properties. ಅಂದ್ರೆ ನನ್ನ ಶೇರ್ ಇನ್ನು ನನಗೆ ನನ್ನ ತಂದೆಗೆ ಇನ್ನೂ ಡಿಕ್ಲೇರ್ ಆಗಿಲ್ಲ, ಹಾಗಾಗಿ ಅವರು ಪುನಃ ಶೇರ್ ಅದ್ರಲ್ಲಿ ಕೇಳಿದ್ರು. Meanwhile, I filed clubbing application to club those 2 cases. But one of the case filed by my sister that has already been disposed of. Now the suit filed by my sister-in-law, it is pending. It is for defendant evidence.
Where is that order for rejection of your?
Rejection. Page number 78.
78.
IA number, order on IA number 20.
Yes.
Plaintiff number 1A TV Chandrakant has filed this application under 151 of CPC to club OS number 41 of 18, filed by D13 ಅದು T3 ಅಂತ ಆಗಿದೆ ಸ್ವಾಮಿ, D13, and OS number 28/17 filed by D14. That OS 28 of 17 has already been disposed of. Now only OS number 41 of 18 is still it is pending.
What has happened? Disposal ಏನಾಗಿದೆ?
It has been partly decreed.
Yes.
Then D1A and D13 have filed objection and simply denied the praise to dismiss the application. In the affidavit annexed to the application, it has been
stated that the present suit is for comprehensive suit and all our family properties have been included in the present suit. The judgment pronounced in OS 2817 and 4118, there is probability of conflicting judgment, hence the applicant prays to club 3 cases. All these suits are for the relief of partition and separate pending before the same court. But only the reason for dismissal is that OS 41 of 18 is filed in respect of 8 properties. OS 28/17 is filed in respect of 26 properties. The OS 28/17 is set down for main arguments on defendant side, whereas OS 41 is set down for cross-examination of defendant number 1. Present suit is filed in respect of 32 properties, and when the case is set down for cross-examination of defendant, plaintiff has filed application to implead one person as D14, and the application came to be allowed, and it is ordered to implead the said defendants. After appearance of D14, the case go back to file WS and de novo trial. Thereby, there is every chance of delay in dispose of the present case, which is already to the 8 years old. If the suits are decided separately, there will be no chance of difference of opinion, since all the suits are for relief partition and separate position. Therefore, application cannot be allowed. But again, the only reason is that if my suit were the first suit of year 2000, if it is not partly decreed, if I do the shares what I have sought, it is not been, then if the other 2 suits wherein it has been decreed means, hence properties are the same, plaintiff and defendants are the same.
What is that order to implead that said defendant?
Well, that has been allowed. That is not the order in question.
So who is D14?
D14 is my sister. Her suit is came to be already decreed.
In 41 of 80.
No, not 41. 28 of 17. Yes. 41 of 18 is filed by my sister-in-law.
Or issue notice. Now, why you are seeking a stay of further proceedings in 41 of?
If not means they will continue. Evidence or cross ಮಾಡಿದ್ರೆ arguments ಮಾಡಿ order ಮಾಡ್ಬಿಡ್ತಾರೆ.
But ನಿಮ್ case proceed ಆದ್ರೆ?
ಅಲ್ಲ, ನನ್ನ ಕೇಸು 2016 ಕೇಸ್, ಅದಿನ್ನು ಡಿಫೆಂಡ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇಲ್ಲ. ನಂದು
It cannot be only one.
both the cases.
Yes. ಅದು ಎರಡು ಬರ್ದ್ಬಿಟ್ಟು ಆಮೇಲೆ ಕಟ್ ಹೊಡ್ಕೊಂಡಿದ್ದೀರಾ?
ಅದು ಇನ್ನೊಂದು ಸ್ವಾಮಿ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೆ, ಇನ್ನೊಂದು ಸೂಟ್ ಡಿಸ್ಪೋಸ್ ಹಾಕ್ ಮುಂಚೆ ಫೈಲ್ಡ್ ಇಟ್.
OS number 41 of 2018
and OS number
10 of 2016 pending in the file of senior civil judge JMFC Priyapatna till next date of hearing.
Sorry to intervene, my lord. Serial number 31, my lord, was also passed over. I'm appearing in that.
No, that is not yet complied, Mr. Officer.
I'm sorry, my lord. Would your lordship then please keep it on Monday or Tuesday, my lord? Any day. I'll see that it's done in the meantime. I'm sorry, my lord.
Tuesday.
I'm so great.
Tuesday.
Grateful, my lord. I'm sorry about the inconvenience. Sorry.
Bill number 35, Manikanta HB.
Go ahead before your lordships. This raises 2 important questions of law. I can point out why it is not restricted. Not, I would only rely on the judgment of the Supreme Court, where the Supreme Court distinguished what is res sub judice and res judicata in cases where there is a decree and an appeal.
If you are on merit, then I have to send it to the CRP. I can't decide here. That's what I said.
They just wanted to seek.
We can go ahead with the writ itself. Here itself, I can point out.
No, you can go ahead. I can't decide. If I decide, it will be the precedent. Now all matters, they will be filed in a writ. If both are considered for sending back, I said I can decide. Otherwise, tomorrow this judgment will be shown that this.
No, their plea is only on the fact that the trial court has held that it is not res judicata anta.
Yes, the learned counsel for respondents objected that.
I think we can go ahead with the writ.
No,
it's in a very small part we can go ahead with the writ. I can point out.
Yes.
The issue is res sub judice. The decree what he is referring to, Manoj, a miscellaneous has been filed. I would only require 2 minutes if your lordship.
No, not on that merit. Wait.
Not minutes, only 2 minutes. Only 2 facts.
See, now you have brought to the notice of the court, writ is not maintainable. Then
But that not only 2 facts. Only 2 facts.
Facts for what?
Only 2 facts.
No, are you arguing that writ is maintainable?
Not I'm pointing out not the.
No, I am not on that merit. I am asking that are you arguing that writ is maintainable and convincing me that it is maintainable?
We can go ahead on the writ side
no,
also.
Go ahead with, no, it is not that we are doing any this thing.
Writ side nallu tagobardu antilla idu.
226 is different.
Correct.
227 is different.
Correct.
Yes. Since order impugn herein is rejection of
Application for res judicata, for dismissing. the
Section
suit.
11
Section
application.
11
Section
application.
11 application. The remedy available for the party is to file a revision under 115 of CPC.
Kindly.
You want to convert this
Yes,
or you
ma'am.
want to withdraw and do it?
We will convert it. Madam.
Yes, learned counsel for the petitioner has filed a memo seeking leave of this court to convert this writ petition into civil revision petition. Memo is taken on record. Petitioner is permitted to convert this writ petition into civil revision.
Kind, great.
Satisfies purpose writ petition.
Serial number 50, Kashyap and Naik for petitioner, Yashu Mishra.
Yes.
Because I have a DD, I'm finding.
How much? You will take that, mister.
My lord, I'll take, but
Subject, yes, you will.
my lord
permitted
may
to take
mention that,
without
my lord.
prejudice to your right.
No prejudice to my right, and my lord, that machinery that has been sold, according, they have not reported it to the court till today.
No, that you will take that when.
Very well.
Yes. Learned counsel for the petitioner has handed over a DD the number record. So and so to that respondent. Learned counsel for the respondent has submitted that. You will receive the same without prejudice to that contention taken in that application and the petition.
About the contempt, my lord.
Yes, that, what is that application I am saying?
My lord, I have filed an affidavit
Yes.
contending that they have sold the property.
Prejudice to that. Is affidavit filed?
Objections, my lord, objections,
Yes,
objections to their affidavit.
yes. Without prejudice to that. Contention taken by that defendant. Yes. The DD number is after. Yes. Let us see. Other matter will take.
My lord, a date may be fixed.
Yes.
Days pending.
22nd, 23rd.
Serial number
Fifth.
66, my lord. Mold, my lord.
All matter. ನಾಳೆ ಆಗಲ್ಲ.
22nd or 23rd, andru, 26th.
Tuesday, Wednesday, any date you can.
My lord,
take.
my lord. Mold, my lord, mold due to the interim order, my lord, mold ಇದು ಮಳೆ ಬರ್ತಾ ಇದೆ, close ಮಾಡಕ್ ಬಿಡ್ತಾ ಇಲ್ಲ petitioners.
No, have you filed an application?
Please, file the serial number 66, my lord.
You will have it on Monday.
Sir, Monday, serial number 66.
ಯಾವ್ದು? Hmm. 46, we have said that execution petition may be disposed of. ಅಲ್ರಿ ಸೂಟ್ ಡಿಗ್ರಿ ಆಗಿದೆ. ಹಾ, ಸೂಟ್ ಡಿಗ್ರಿ ಏನ್ ವಜಾ ಆಗಿದೆ? ಅಲ್ರಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಹಾಕಿದಾರೆ ತಾನೆ. ನಾವು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ರಿಸರ್ವ್ ಫಾರ್ ಆರ್ಡರ್ಸ್ ಆಗಿದೆ ತಾನೆ. ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದೀವಿ ಅಷ್ಟೇ. No, only direction is to dispose of that. Yes.
My lords.
Other matters. Date and interim order will be extended till next date. Date ಕೊಟ್ಟಿದ್ರಾ? ರೀಚ್ ಆಗದಿಲ್ದ್ರೆ ನಾನೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ. No, that you want to allow that writ petition. Which is that serial? No, which is that serial number? 70. No, 70, who is appearing for other side?
71, it is my matter, I think.
70, you are appearing for whom? Yes, but it will be having Monday. Monday, if it is not reached at 5 o'clock, you mentioned. Today I have that reference.
My lord, serial number 63.
We have no
It may be
objection.
taken on Monday, my lord.
Only thing is that we have no objection for allowing. Otherwise, everybody will say that we will mention.
70,
Let us see. All that. Any date you can ask.
My lord, serial number 63. It may be listed on Monday.
The serial number 50.
Sir, 50, 23rd.
Sir, serial number 50, interim order extend ಆಗ್ಬೇಕಿತ್ತು ನಾನು ಕೇಳಕ್ ಮುಂಚೆ.
ತಾಳ್ಮೆ ಇರ್ಲಿ, 2 ನಿಮಿಷ.
ಸೀರಿಯಲ್ ನಂಬರ್ ಪ್ರಕಾರ ಹೇಳ್ಬಿಡಿ.
ಎಲ್ಲಾನು ಕರೆಯಕ್ಕಾಗಲ್ಲ, 1 ನಿಮಿಷ.
36 ಮೊದಲೇ ಹೇಳಿದ್ರು ಸರ್.
ನಾಳೆ ಇಲ್ಲ. ಎಲ್ಲ ಮ್ಯಾಟ್ರ್ ಯಾವ್ದು ರೀಚ್ ಆಗಿದೋ ಎಲ್ಲ ಮಂಡೆ. ಆಯ್ತಾ, ಎಂಟ್ರಿ ಮಾಡಿ ಎಲ್ಲೆಲ್ಲಿದೆಯೋ ಅಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಬ್ರೇಕಪ್ ಇಲ್ಲ, ಕಂಟಿನ್ಯೂಟಿ ಇದ್ರೆ ಮಾತ್ರ ಎಂಟ್ರಿ ಮಾತ್ರ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಆ ಮಂಡೇ ಬೇಡ ಅನ್ನೋರು ಇಬ್ರು ಇದ್ರೆ ಯಾರಾದ್ರೂ ಇದ್ರೆ ಅಷ್ಟೇ.
ಸರ್ ನಮ್ಗೆ ಸಾಯರ್ ಮಂಡೆಗೆ ಅಂತ ಹೇಳಿದ್ರು 66.
ನಾನು ಅದನ್ನೇ
ಮಂಡೆಗೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ.
ಅದು 66
ಅದು ಓಲ್ಡ್ ಎಂಟ್ರಿ ಮಾಡಿ
ಎಲ್ಲ ಮಂಡೇನು
Sir, 96 Monday, sir.
ಮಂಡೇ ಬೇಡ ಅನ್ನೋರು ಇರಿ. ಯಾವ ಡೇಟ್ ಬೇಕಾದ್ರೂ ಎಕ್ಸೆಪ್ಟ್ ನಾಳೆ.
Okay. Monday, sir.
ಅದು ಇದು ಇರೋದು ಯಾರು?
Video. Court officer. Sir, 96 Monday, sir.
ಎಲ್ಲ ಮಂಡೆ.
ಎಲ್ಲ ಮಂಡೆ ಆಗ್ತಾರಂತೆ ಬಿಡು.
Court officer.
Sir, 96 Monday, sir.
ಸರ್ ಸರ್ 67.
Court officer.
67. Sir, 67 and 67.1. After 15th any day. ನಾನು petitioner ಕರಿತೀನಿ, ಅವ್ರನ್ನ ಫೋನ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ, ಬರ್ತಾರೆ. ಪ್ರಕಾಶ್ ಸರ್
ಬೇಗ ಕಂಪ್ಯೂಟರ್ ಕ್ಲೋಸ್ ಆಗಷ್ಟರಲ್ಲಿ, ಯಾಕಂದ್ರೆ ಕಂಪ್ಯೂಟರ್ ಕ್ಲೋಸ್ ಮಾಡಿ
ಅವ್ನು ಒಂದು ಇಂಟ್ರಿ ಮಾಡೋ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು ಸರ್. 67.1
ಆಗುತ್ತೆ. ಕಂಟಿನ್ಯೂಟಿ ಇದ್ರೆ ಮಾತ್ರ
ಇದೆ ಕಂಟಿನ್ಯೂಟಿ
ಆಗುತ್ತೆ. ಹೇಳಿ
Court officer.
ಆಯ್ತು, ಕಂಟಿನ್ಯೂಟಿ ಇದ್ರೆ ಮಂಡೇ ಬೇಡ ಅಂದ್ರೆ ಎಲ್ಲ ಅಡ್ವೊಕೇಟ್ಸ್ ಇರ್ಬೇಕು, ಫಿಸಿಕಲಿ ಇರ್ಬೇಕು. ಇಲ್ಲ ಅಡ್ವೊಕೇಟ್ಸ್ ಇದ್ರೆ ನಿಮ್ಗೆ ಗೊತ್ತು ನಿಮ್ ಕೌಂಟರ್ ಪಾರ್ಟ್ ಯಾರಿದ್ದಾರೆ ಅಂತ ಇದ್ರೆ ಮಾತ್ರ ಹೇಳಿ. ನನಗೆ ಅಷ್ಟು ಕರೆಯುವಂತ ಕೆಲಸ ಇದೆ, ಸಾಹೇಬ್ರು ಕರೀತಾರೆ.
Court officer,
VCL ಯಾರು? VCL ಯಾರು?
court officer,
ಎಲ್ಲ ಮಂಡೇನಾ ಸರ್?
ಹೇಳಿ ಯಾರು?
serial number 134. Monday ಬರುತ್ತಾ?
Serial number 96.
Okay, thank you.
Monday, sir.
ಎಲ್ಲ ಮಂಡೇ ಮೇಡಮ್, ಒಬ್ಬೊಬ್ರು ಕೇಳ್ತಾ ಕುತ್ಕೋಬೇಡಿ. ಸಾಹೇಬ್ರು
ಸರಿ.
ಹೇಳಿದ್ರಲ್ಲ
Thank
ಎಲ್ಲ
you,
ಮಂಡೇ.
thank you.
ಸರಿ.
ಓಕೆ.